Good morning, everyone. This is the New York City Board of Standards and Appeals public hearing for August 6, 2019. We'll begin with the appeals calendar. New cases. Item number 1, 2019-89A, 36 West 66th Street, aka 50 West 66th Street, Manhattan.
Yeah, we can call them together.
Item number 2, 2019-94A, 36 West 66th Street, aka 50 West 66th Street, Manhattan.
Okay, we begin with the appellants.
Madam Chair, I must recuse.
Yes. State your name, please.
John Lobert for Appellant, City Club of New York et al. Is this working?
Yeah, it's working.
Okay. Okay, I'd like to say a few words about timing first. I'd like to thank the board for agreeing to advance the date of this hearing, which I had understood was originally not going to be heard until September, the case. I know you have a crowded calendar, but, even so, it's still 3 months since we filed this appeal, and during that time, Extel has been building. For us, a rapid decision is really critical. In this kind of case, it's clearly the principle of justice delayed being justice denied applies, and we explained the reasons for this in our reply statement. Basically, the Court of Appeals decision in Dreikhausen v. Zoning Board of Appeals makes it very difficult, if not impossible, for challengers to obtain a preliminary injunction halting construction. And once construction reaches the point where demolition would be required if appellants were to prevail, appellants will face very serious difficulties in obtaining a remedy, even if a tribunal finds their case to be meritorious. And according to Extel, that point will be reached in March of next year. That's not a long time, considering the fact that if we lose before you, we then have to get a decision on the merits from the Supreme Court, and if we lose there, we would go to the appellate division and thence to the Court of Appeals. So, that said, I'd like to turn to the merits. The proposed building, we allege, violates the city's zoning regulations in 2 ways. First, it's based on a methodology for calculating allowable floor space that violates the bulk packing rule. Zoning Resolution Section 8234 and the split lot rules of Section 3348 and 7702. And this violation adds somewhere between 128 and 144 feet to the height of the building. Second, it illegally claims an exemption from FAR for 196 vertical feet of purported mechanical space in the midsection of the building that is neither, quote, used for mechanical equipment nor, unquote, nor customarily accessory to residential uses, and it's therefore illegal, or at least should be counted towards FAR, and that's under Zoning Resolution Sections 1210 and 2212. I'd like to focus today on the bulk packing argument because it was clear to me from yesterday's review session that the board believes the mechanical voids argument to be precluded by its prior decision in 15 East 30th Street. As we said in our statement, we believe that decision left the question open because it was expressly based in part on the failure of the appellant there to provide any evidence or testimony in support of its claim that such voids were truly quote-unquote irregular, despite the board's request that it do so. Since then, the Department of City Planning provided decisive evidence for this claim. And indeed, the Supreme Court rejected our argument that this issue was foreclosed, stating, quote, "It remains possible that the BSA will agree with plaintiffs that an aggregation of mechanical spaces where one or all are used solely as voids to increase the building's height violates at least the spirit of the zoning resolution," unquote. That was from Justice Jaffe's opinion in City Club v. Extell. In any event, on that point, we will rest on our papers. We'd ask you to consider them. And there's only one more thing I want to say about the voids issue. In our reply papers, we responded to Extel's argument that it had completed its foundation and that its right to complete its foundation, its building therefore vested before the amended statute came into effect. We pointed out that Extel's counsel, Kramer Levin, stated in another case concerning 200 Amsterdam that a foundation was not completed until the pouring of the first floor slab, and consistent with that statement, Kramer Levin only informed the petitioners in that litigation that the foundation was about to be completed when the developer there was about to pour the first slab. By a letter yesterday, Extel's counsel denies this. Well, I don't actually think he denies that what happened, so he denies that this is the definition of a completed foundation, though. And he accuses my co-counsel, Mr. Weinstock, of unethical conduct for allegedly discussing what occurred in settlement discussions. Mr. Weinstock responded to that in a letter, and I don't think we should be further sidetracked by that issue here, because I don't believe that the issue of whether Extel completed its foundation and thereby obtained a vested right to complete this building is before this board on this appeal.
Right, so that's what I wanted to just clarify. Are you questioning the vesting of this building? And is that one of the questions that you wanted to bring before us, of whether or not the building vested, because it's actually not ripe, because Department of Buildings hasn't issued a determination on that,
Well,
right?
that was exactly my thought. I mean, if you're
Okay.
going to tell me we can question it and it's ripe, I would, but I don't
Okay.
believe it's ripe.
Okay.
So that's why I say I don't believe it's before the board at this time. I'd just like to say that the discussion, I'm informed by Mr. Weinstock that the discussion in question was had after, not before, the signing of the stipulation, and that, I haven't researched this, but it seems to me that since the purpose of the rule of confidentiality of settlement discussions is that a party should not be compromised by conceding something in a settlement discussion and then later have it held against them if it doesn't settle or at trial or whatever, that's the purpose of the rule. And once the settlement is done with, if an issue arises regarding the meaning of the words in the settlement, that like any other agreement, you could adduce parallel evidence to.
So since we're not talking about vesting, why don't we not talk about
All
vesting?
right, we won't talk about it.
Okay.
I just felt I had to defend the reputation of my co-counsel in this matter, that's all.
Understood. He's got it.
So now I'd like to turn to the bulk packing rule. So we believe that or bulk distribution rule, whatever. We believe that the statute and the legislative history are clear. The bulk packing rule and the tower coverage rule apply only to towers, even though the bulk packing rule doesn't have the word tower in it. Together, they comprise the tower and a base rule. These rules were enacted in two versions, one for the special Lincoln Square district, and one for R9 and R10 districts generally, in response to concerns over, quote, significant increases in the height of buildings, unquote, from an average of 30 to 32 stories to an average of 40 stories. That quote is from the Department of City Planning study, I believe it's from 1989, called Regulating Towers and Plazas, at
Council,
pages...
before we move on, I just wanted to go back to the mechanical voids for a moment.
Yeah.
You disagreed with Justice Jaffe on whether or not the issue is precluded. Is that accurate?
Right.
Okay.
I'm sorry. Did he say that the issue is not precluded?
Well, let me clarify that.
Counsel,
We argued
that
there
the issue is
that we
precluded.
should not be required to exhaust our remedies here because it would be futile.
Because it was your belief that the issue is precluded.
Well, arguably it is, arguably it isn't. I mean, you know, I don't think, apparently it's, I don't know. Anyhow, that is what we argued,
Thank you.
yes. I think you could make an argument that it's not precluded too, and in fact, she made that argument.
No, I'm aware. Thank you.
Sorry, go on with your...
So,
You were at,
There was a-
that the
yes,
tower
yes,
coverage...
regulating
Right.
towers and plazas. The purpose of those rules, stated numerous times in the reports, was to create a mechanism to limit building height to the low 30 stories. That's a quote, which it occurs in both the R9, R10 report and the special district report, I think more than once. They can only accomplish this if they're applied to the same area. The city planning reports and the borough president's report make very clear that the chosen parameters of 60% of bulk below 150 feet and minimum tower coverage of 30% were carefully chosen to ensure that buildings stayed within this low 30 stories limit, quote, even in cases of zoning lot mergers. These parameters, which are very similar in both the R9, R10 amendments and the special district amendments, were chosen after careful work which went on for over a year with Michael Kortler's Environmental Simulation Center, also known as SimLab. The borough president described that process in her report on the R9, R10 amendments. She said, quote, in 1991, the Department of City Planning assembled a working group of design professionals, community and development industry representatives in an attempt to reach consensus on various elements of the tower and plazas issues. And so on. She mentions the participants who included REBNY and Civitas and DCP and so on, and her office. And she said the working group decided to test its ideas on a computer simulation tool at the New Schools Environmental Simulation Center, known as SimLab for short. Design criteria were established for specific soft sites, and for over a year, the participants tested their ideas in the SimLab. And that was from her report on the R9, R10 amendments. In her report on the Lincoln Square Special District, the borough president noted that the SimLab analysis of 6 soft sites referenced in that report was funded by Landmark West, and she specifically thanked Arlene Simon, who founded Landmark West and at that time was also its president. She's an appellant in the City Club's appeal and is here today and will address you later. Although the bulk packing and tower coverage rules I'm sorry, although the bulk packing rule is slightly different in the special district and in R9 and R10, the purpose in both rules is to limit building heights to the mid-20 to low-30 stories. And this is, I mean, I can give you citations where they say this. It's in the DCP zoning review of May 1993 at pages 1 and 14, in the special district report, pages 18, 19, in the R9, R10 report at page 5, and in the borough president's November 15th report at 2 and 15, and perhaps in her other, this is her report, I believe, on R9, R10. It's probably in her other report as well. Anyway, so yes, as Mr. Karnofsky points out, there are differences between the special district rules and those applicable elsewhere, but those differences are irrelevant to the basic purpose of it. The mechanism works to keep tower height constant in exactly the same way in the general rule and in the special district rule, and I gave an example, I believe, on page 12 of my statement about how that works mathematically. This was the intent. And if it were not the intent, the City Planning Commission could not and would not have said, as it did repeatedly, that the measures being adopted would keep heights to a predictable low 30 stories, and that they would work just as well as an absolute height limit, but afford more flexibility, and that they would work even in cases of zoning lot mergers. So to apply the bulk packing rule in a context where you can't build a tower is pointless, because most of the bulk is going to be below 150 feet anyway.
Well, how do you respond to the owner's statement that you can build a tower?
I'm going to get to that. I think that works to our advantage, actually. But to apply it in this split lot situation is worse than pointless. It leads to the absurd result that towers on a split lot can avoid the bulk packing rule in part or even in whole, and thereby be much taller than they would be if they were wholly in the C47R10 district. And there's no rational reason to think that just because somebody has a split lot, they should be allowed to build a much higher tower. The mechanism only keeps height constant regardless of lot size if the two rules are applied within the same envelope. If you put the bulk below 150 outside the envelope, as I said in my statement, it might as well be in Timbuktu for all the good it does in controlling height.
I have a question about that, actually. So the base building of the tower on a base that's supposed to grow to 150 feet in height, right? There's an earlier city planning report that talks about the Upper East Side, because actually that's where they started to be looking at these tower on a base, right? And the issue was the loss of street wall continuity. So there's two things at play, right? One of them is to create a mass that has street wall continuity. So the Timbuktu statement isn't really correct, because it's encouraging street wall continuity in both the R10 or R9 and the R8. The R8 has a different height limit, but still it's a street wall continuity where you're packing all of it before the setback.
Yeah, but
right?
don't I'm not really all that expert in all the provisions of the zoning resolution, but don't the quality housing regulations also require a street wall?
But this is an R8, it's not a contextual district, so you have an option to do a height factor building,
Well, you have
right? So if you have an option to do a height factor building where without the bulk packing,
Right.
you could start your setback and rise at the lower base height, that would arguably not be pursuing what the special district had in mind, right? Where you wouldn't have the full height, the full base height, and rather than saying that in these R8 districts, the base height minimum has to be wherever it is, 85 feet, instead it's requiring you to pack the bulk below whatever the maximum base height is there.
But as I understand it, it's not generally advantageous for a developer to use the height factor district regulations when the other one, affords more.
It's an option, so.
Well,
you
it
see
is an
buildings of
option,
both
so it would be
types.
possible, but apparently it's not often done. I mean, it was done.
No, it depends on your zoning law. A lot of times you
I
pick height
should,
factor buildings, there's a lot of significant
Well,
buildings.
I know Mr. James is here, and maybe he at some point.
Okay, we can talk about that. But
where was he? I don't know.
go on with your presentation. I do have a question after your presentation
Mm-hmm.
about this, yeah.
Okay, so, in any event, with respect to this mechanism, it does lead to the absurd result that if you build on a split lot, you can build your tower much higher than if it were not on a split lot. And in this case, I know we had some back and forth over this, but the illegal gain in tower floor area, we contend, amounts to 8.3 stories, which would be 8 or 9 stories. I guess what happened in my first iteration of this, in the initial statement, I was assuming that they could build the base out to the full allowable amount, and I wasn't taking into account, A, that the Armory building is there, and B, that they already have a permit to build a building which has a base, which has been designed in a certain way. So if you take the permit that was approved and that is being appealed from here, the result is that, as I explained in my reply statement, if you take that base, then the loss in tower floor area, if you like, from applying the rules correctly would be 8.3 stories. And I guess Mr. Karnofsky was kind of implying that this is a trivial point, but I would contend that 144 feet is significant even in the context of a 775-foot-high building with its huge mechanical voids. Now, I'm going to come to the point that Mr. Gibetta was raising. So, in yesterday's review session, I think you made clear that you didn't really buy my argument that within this special district was intended to contrast with the similar rule applicable elsewhere. And, I'm not solely wedded to that interpretation of why they did it. We really don't know why they wrote that, but there are various reasons they could have.
Sorry, wrote what? Within the word, within the
those
district?
words
Okay.
within the special district. One possible explanation is, although I think it's unlikely, but maybe they had in mind community facility towers. In which case, the rule could be said to apply to R8 as well as to the rest of the district, but only in that context. I would say that implicit in saying, let's assume for a moment that that was what they meant, but still it doesn't mean you also applied in a context where it doesn't make sense to apply it. It only applies to towers. I would submit that the bulk packing rule is a rule that applies to towers as much as the tower coverage rule, even though it doesn't have the word tower in it, because there's a long historical discussion about this rule, and every time it's discussed and every time it's mentioned in every report, it's always conjoined with the tower coverage rule as a mechanism that to keep height constant. There are occasions, too, I think, in the early reports where it was discussed on its own, but always as a tool to reduce the height of towers, not in any other context. So maybe when they said within the special district, they meant everywhere within the special district because they were thinking of towers in the special district. There are other possibilities, too.
So that brings up my question. So here I am, an architect trying to design a building in the city of New York. And maybe I have a client who has the wherewithal to even hire a zoning consultant and zoning counsel, and an expediter who actually knows about zoning, right? And so I start to draw my building, and I go systematically through the zoning resolution, and I try to figure out what it is I'm going to do. And I get to this section 82-34, and I read it, and it says, within the special district, at least 60% of the total floor area, et cetera, has to be below the 150 mark, right? So I read that, and it just tells me within the special district, so it must have to do with me, right? And my zoning lot is, however big my zoning lot is, it says within the special district. So the question is, would I even ask the question, since it's so clear, of the zoning council and my zoning consultant, who, by the way, my zoning consultant is probably giving me a wire diagram to say, here's your wire diagram, you can fill your building in like this. But let's just say in my office, I also have people who know about zoning, and they're reading it, and they're saying, oh, we don't really need to ask the zoning consultant about that because it says within the special district. So the reason that I ask this is that, as you know, laws are made for us to follow, right? And when they're clear, we follow them.
Right.
And when we don't have a question about them, we don't ask the question, right? And so we proceed. And then we go to, in this case, we eventually go to the buildings department. And if we have a question, we ask the buildings department specifically, I'm not sure really what this means, what does this mean? And the Department of Buildings then gives you an interpretation, right? But if we don't have a question, we don't ask. And if the buildings department doesn't find it as an error, then if they don't find that you've misinterpreted something or the way they see it, they don't point it out. So my question is, though there's this long history about what city planning may have intended to do and so on, if city planning wanted the buildings to only be 40 stories for argument's sake, why isn't there somewhere in this special purpose district that little phrase? The special purpose district was created to limit building heights to 30 to 40 stories. And so there's this mechanism, and it would have been the case for the tower on the base also, the little introductory statement saying, we've discovered that there's buildings that are 50 stories high, and so this is a mechanism to limit the buildings to around 30, 40 stories.
That's what it says.
No, it doesn't say it in the zoning resolution. It says it in an ancient report that I, as an architect practicing in a little office, would never, or even a big office, would never consult. Why would I go back to 40-year-old history? It's just not how we read the law. We read the text. And when the text is clear, we keep going. And when the text isn't clear, we ask all of our consultants and our friends, did you ever build something like this? Because I don't understand these rules. And then they say, you know, the rules before were read like this at DOB, and now they're read another way, so you should probably go to DOB and check. So that's my question. Why are you expecting that that an architect, first of all, or a property owner would dig into the history of clear language and in terms of what the courts have determined? How does what you're proposing comport with holdings that the court has made, that when you have clear language, you don't look further, you don't look at the legislative intent? It's only when the language is ambiguous that you look at legislative intent.
Well, first of all, I cited a lot of cases to you, and I think I cited even more cases to you in the previous time I was before you on 180 East 88th Street. to the effect that even where the literal language of the law says something contrary to the obvious purpose and leads to an absurd result, it's not to be followed. But that's not the case here.
Oh, stop, because that's not what the cases say. You want to...
Well, there certainly are some cases that would stand for what you're saying. Although, you're missing part of the balancing test. And part of that balancing test is you have to consider it and make it coincide with other cases like Allen v. Adami, and how property rights have a special, people have a special right to property, and if there is an ambiguity, even if there is an ambiguity, which I'm not sure if you've shown just yet, because the language seems pretty clear, just on his face. So now, even if there is an ambiguity, that should be resolved in favor of the owner. So I guess the first step is showing there's an ambiguity. And because it's very, very rare, the circumstances, and I haven't seen those circumstances in property cases. I've only seen those circumstances in I know, child neglect cases, as you cited, Jamie, in the matter of Jamie. I've seen them in large public policy cases, such as with rights to public safety in hospitals.
Well, what about Long versus Adirondack Park?
But didn't that go in favor of the property owner?
No, it did not.
But I think that this does go to the, I mean, for instance, all the land use cases, you construe ambiguities in favor of the owner because it's a deprivation of property rights otherwise, but that's only in the case where you have an ambiguity. When you have something clear, and I just have to say, you know, the BSA is, there are many, many Article 78 challenges brought against the BSA, so it's kind of almost bread and butter. And when we make a determination that the court views is our interpreting a statute where the statute doesn't need interpretation, we get our knuckles wrapped. So the court will actually say things in the cases, the court will actually say things like, come on, BSA, what were you thinking? Right? So,
well, but for example, I mean, there are cases where, you know, as in Peyton, which I also, as you know, was my case, at least in the appellate division, you know, in which the court recognized, or the BSA did not actually, well, in my view, the BSA didn't follow the statute in that case.
That's a litigation we can't speak about, right?
But let me, first of all, let me say that the rule of the presumption in favor of the property owner has not been followed very much in recent cases. And also, I believe that just reading the cases, it seems to me when the courts want to find in favor of the property owner, they invoke that rule, but when they don't, they just don't mention it. And I think in this case, the language is pretty clear. And I mean, let's talk about the facts of this case. This particular issue was in the forefront already in 2017, I believe, when Mr. Karnofsky wrote his first memo about it to Council Member Rosenthal, I believe it was. So it's not like nobody thought about this. That's not this case. Whether that could be true in another case, I don't know. It seems to me that any zoning consultant or anyone who is building a substantial building and who employs knowledgeable people would certainly know that the bulk packing rule is part of tower on a base rules and would understand the history of this.
No, but that's not the point. They're reading a statute, right? Statute gives a clear instruction, so you don't need to hire fancy zoning counsel or zoning consultants to just read the sentence, within the special district, do this.
And that's very different than the matter of Long that you cited, which was about a 30-day conditional, phrases that we see quite often in legislation and what they really mean and how a literal interpretation of that meaning would completely obfuscate the reason for having that statute. And so that's a a particular type of case. And I still think that, and I'll have to review it again, you did cite a lot of cases, but I still think that they did find in favor of, against the agency in favor of the owner in that matter.
Oh, okay. We'll
I
get to
think,
the detail.
I haven't read that case in quite a while, but I think the dispute there was about whether the town, it was between the town and the Adirondack Park Agency.
Right, and whether or not 30 days was.
Yeah, but I believe there are other land use cases in which this principle has been invoked, and if I may take a day or two after today to submit to you some of those cases, I think you'll find that it has been invoked in land use cases as well as in...
The principle of taking something that's clear and unpacking the intent?
Yeah, that even though the literal language of a statute says X, that where it leads to an absurd result that's contrary to the purpose of the law.
And you're discovering that, and you're discovering the purpose of the law through parole evidence, through evidence that's not in the statute.
No, usually the purpose of the law, I mean, there are many
It's in the
ways you look
statute.
at the purpose of the law, but one way you look at it is looking at the statute as a whole. Is this consistent with what the statute is trying to accomplish or not? I mean, that's certainly the case here.
Right, but I
We
think
don't
that-
need parallel evidence here.
Well,
I mean, we do have the reports.
The letters
but
and reports are, I think, are some of the most convincing evidence that there may have been an intent behind this legislation to limit the height. But from a clean reading of the statute, it doesn't show that.
No.
Well, I would say that implicit, even though the word tower does not occur in the
saying it's
bulk
implicit.
packing rule, that it's obvious that the bulk packing rule applies to towers, and anybody who knows even the littlest bit about zoning and about this area of the law would know that. I mean, I don't, people who build tall buildings are not unsophisticated in these areas, and I don't believe that anybody would be surprised to hear that, who is building a tall building in New York City would be surprised to hear that the bulk packing rule and the tower coverage rule are a part of
okay.
tower and a base, and, if you don't know that, you shouldn't be...
But if you're reading the whole this whole section, this whole special district section, and you read along and you follow the instructions, it's not absurd to consider spreading the bulk on the entire zoning lot. In fact, it makes it easy to follow, right? So if anything, for me, it's just kind of a simple instruction. Just spread the bulk out on the zoning lot, and now let's move on. And tower coverage has a different rule because split lot regulations apply to it, whereas this is saying split lot regulations don't apply to it. So the instructions don't sound absurd at all to me. They sound that whatever the size of my zoning lot is, spread the bulk around.
But
right?
it's not the instructions that are absurd, it's the result that's absurd.
But a statute,
Can you explain
but it's
how-
not necessarily an absurd result either. It's that you've got this low base that's supporting a tower. So I don't see the result as being absurd either. It's only that you're saying you need to go look back at the tower on the base regulations that are in another section and see how that chart plays out, where arguably it's not playing out the same way as the chart.
If this was all on the same lot, would it be different?
Yes, of
And
course,
explain, can you get into that a little bit?
of course. You mean, would the result be
Would the
different?
result be different? If it was all on, if it was all in the...
In the same zoning
in the same- in
district.
same-
Zoning district.
Same zoning district.
Well, yes, that's exactly, I think on pages 12 and maybe 13 of my statement, I spell out a hypothetical of how this would work. Maybe I should, hold on, let me get that. But, it makes a huge difference. Okay, so I had discussed on, previously how no matter the lot size, if you're within C47, you get 13.3 tower floors. Now that, it doesn't consider the penthouse rules and all, that's why, there's flexibility in it. They never said this is exactly how many floors, because it depends on your mechanical space, it depends on the penthouse rules and so on. But no matter the lot size, if you have 60% below 150 and 30% tower coverage, you come out with 13.3 tower floors. So, on the other hand, as I say on footnote 24, consider the result of using Extel's methodology on a split lot with 10,000 square feet in C47 R10 and 30,000 square feet in R8. And I work it all out, and the result is a 33.3-story tower. So it's a huge difference. I mean, basically, insofar as your bulk is not within this district where towers are allowed, it's outside of the envelope where you're counting, I mean, it would be, of course, if they counted the tower coverage also in the whole lot, then the height would remain the same, but the fact that the tower coverage is being applied only in C47 and the bulk packing is being applied in both to the extent that it's applied in R8, it's not doing any work.
Okay, we need to move on to the next appellant, but what I would like you to do, because we are bound by the standards that the court imposes on the BSA for how we review things, I would like you to look at the special purpose district itself and the language in the special purpose district, and within that district, explain to us how the language in the entire section leads to the conclusion that this is not just reading that section 8234 in isolation is improper, because when read within the confines of the special purpose district, it leads you to a different conclusion, as opposed to going outside and looking at a 1993 report or looking at Article 2, Chapter 2, where it's a completely different section, and whether or not you pull in from another section, not sure that that's the right way to do it, because we are in a special purpose district. And so,
Well,
to look at those sort of
I
four
can take a
corners of
look,
that.
but I doubt that, typically in drafting legislation, legislators don't spell out the purpose. You have to infer it from the language.
From the language of the statute, right?
Right, and
So-
here, I think it's clear from the language of the statute.
Okay, so
and I
explain
have
to us how it's clear from the language of not just 8234, where it's not clear that there's a problem, but the entire special purpose district. Something in that special purpose district should be leading the reader to scratch their head and say, this is strange, why am I doing this in 8234? Okay, that's usually what leads the court to say, there's ambiguity here, something's not jiving between the individual instruction and the bigger purpose of the statute.
Well,
I'd also ask for the cases that you said you were going to provide cases that would show with regard to property rights.
Well, I can provide you those cases. I don't think I'm going to find what you're looking for in the text of the statute, but I'll look, but I don't think it explicitly addresses what these rules are supposed to do. You have to
Or
glean.
implicitly address it.
Well, I mean, that's what I've argued. I mean, I'm also concerned, I'm happy to try and do it, but I may not find anything more than what I've said in my briefs, and I'm hesitant to extend our schedule too far.
Well, but so the issue really is that the case law, it gives us a direction. To the extent that you can't say, alter the direction that the case law is leading to, then I don't see how we get to ambiguity, because ambiguity isn't found outside of the frame of the statute, it's found inside the frame of
Well,
the statute.
as I explained in my briefs, I think that the ambiguity comes from the fact that it is obvious from reading the bulk packing rule that it applies to towers, except for well, obviously it applies to community facility towers as well as to other towers, but other than towers, it's not
So I guess
relevant.
the only other argument you would have is the absurd result by following that way, and how that absurd result would mean that following it literally would not.
Well, there's that, and then there's the fact that this rule is not relevant outside the context of towers. It's
Okay.
not doing any work.
Okay, so I think you have your...
I did want to say, can I just take a
Yeah,
couple
yeah,
more
please.
minutes quickly? So, I mean, I think there are any number of possibilities why this planning commission might have written within the special district. They might have thought it doesn't make any difference if the bulk packing rule were made applicable there, because they didn't foresee any development happening in that very small portion of R8, which was filled with occupied apartment buildings, the relatively large and relatively new Jewish Guild building, and a landmark church. They really focused on the C47 area and the 6 potential development sites, and if they had thought about development in R8, they may have believed that the bulk packing rule wouldn't apply because most buildings would be quality housing, or it wouldn't even apply to height factor buildings unless the zoning lot were really huge. And in this area, you wouldn't have a really huge zoning lot. You do in 200 Amsterdam because it's on a super block, and and also I'd like to note that the commission is not always so precise as what you are imputing to it. I mean, in the report, it states twice that both the tower coverage and the bulk packing rule apply throughout the district. Well, obviously, it didn't really mean that. I mean, and Mr. Karnofsky had cited that in support of his argument in his memo to Councilmember Rosenthal, but it doesn't really support his argument, and it's just a mistake.
Okay,
Okay.
okay, I think we should move
All
on
right.
to the next appellant. Is that okay?
Yeah,
Okay, thank you very much.
Thank you.
sure.
Mr. Klein,
Our zoning is just going to speak.
okay.
Hi, my name is George Janes. I'm the planner that...
Sorry, can you lift your mic up to be more...
Absolutely.
your height? Yeah.
Is this better?
Yeah.
Okay. My name is George James. I'm the urban planner that filed the zoning challenge for Landmark West. I also was coincidentally executive director of the Environmental Simulation Center, although all this work had happened before my time there. So I was engaged by 10 West 66th Street, the building next to this property, in 2017, to look at possible development scenarios on this site. That was after the initial plans for the shorter building were filed, but before the plan that we know now. And the thought of divorcing the bulk packing from tower coverage just didn't occur. It didn't seem like that would be something that could be possible. And I can provide this board, with permission of my client, of course, those analyses and say, well, you were saying yes, I wish the plain language were clear, but the fact that I couldn't conceive of the purpose of bulk packing without tower coverage. The two are always linked, and there is a long legislative history of that. And in terms of absurd results, so the challenge has an example in it where we show what would happen if this is actually the case. on a different kind of site, a site that is a little larger, that you could meet the bulk packing requirement of the district simply by zoning lot mergers, right? So you can just go in to the site and say, well, you know, in terms of the amount of floor area under 150 feet, we have an enormous zoning lot, including a lot of old buildings that had been built 100 years ago. And those all count for under 150 feet, but the floor area produced by the tower portion of the lot could all be above 150 feet.
But it still has to be 60% of all of the floor area on the zoning lot,
Yes.
right?
Yes. So it just depends on the size of your zoning lot. Again, I wish I had pictures to show you, but they're in my zoning challenge. And you can theoretically, I used a different site on the other side of town, which has a bigger block. But if you take your interpretation, it will lead to absurd results. And it's not necessarily here. Your point is saying is that this is not necessarily an absurd result. And, you know, I think it is an absurd result. However, I see your point. But you can take it to an extreme with this interpretation by divorcing the two and essentially allow for all of the floor area to be over 150 feet. That's produced by the tower portion of the lot.
And only having the coverage on the tower, right.
Exactly. That's exactly right. And
And you're
even
saying
with
doing that interpretation would be an absurd interpretation?
Yeah, it's an absurd result. It's an absurd result of the interpretation that you're proposing. And I would also say is that the void text amendment, which the Department of City Planning passed recently, that wouldn't even address this because they've left open void. So you could put it on stilts and still allow for the building to be entirely over 150 feet, the tower portion of the building. And, you know, I think I understand your point about hardship on applicants, but you're here to interpret the law, right? What does the law mean, right? And what does that mean? And I think.
So just to be
Yep.
clear about that, that's the court's instruction to us, right? That when we have ambiguity, you construe it to the benefit of the property owner when it's ambiguous and it's a tie. So it's not to say it's ambiguous and one version is ridiculous and the other one makes sense. It's when it's a tie, when it's could be this way, could be this way, I don't know, you know, that's when you construe in favor of the owner.
But there is so
Okay.
much record.
Yeah, but it
So-
comes down to a common, the conflict comes down to the common law and property rights as a product of common law.
My response to that is that there is so much record here. There's so much record in terms of the city planning reports, in terms of the hearings, of what the intention of the law was.
Right.
There's so much information.
So let's do it like this, because you're the zoning specialist, you're not the zoning lawyer.
Yes,
So
indeed.
the zoning lawyer is in charge of the zoning law, and you're in charge of zoning
Yep.
specialty and what the zoning resolution says, et cetera. So why don't we
Okay.
handle it like that?
All right, so I will say a couple other points. So I was before you a couple of years ago on 15 East 30th Street. And in fact, you told us to get an engineer to evaluate these spaces and in that building. And in fact, I tried very hard, and we had actually some people evaluate them, but they would not go on the record.
Okay, but
You're-
I just want to
this is-
clarify what the request was. We were looking at whether those, I think it was 3 mechanical floors,
Yeah.
were actually occupied by mechanical equipment, right? And so we asked the property owner, show us your mechanical floor plans, and they did. And the mechanical floor plans showed mechanical equipment filling all 3 floors in plan. We never asked, how tall is the mechanical equipment? Because we concluded that the zoning resolution gives no instruction whatsoever as to height of any space at all, any use anywhere,
You
right?
did ask, however, for us to get an engineer to evaluate the use of the space.
Right, to check whether they were exaggerating on the amount, because
indeed.
your position was that there's too much mechanical equipment in this place, and we said, we're not mechanical engineers. Mechanical engineer says they need all that floor space, so therefore, it seems to be a legitimate use of mechanical equipment, and DOB agrees with that, right? So, and your opposition disagreed that there was the need for that much mechanical space, and so we said, well, then hire an engineer, but it wasn't to talk about the height, right? It was just about the layout of the mechanical equipment on the floor.
And
Right.
I would say
Okay,
that the issue is not precluded because we never got that. And that if I understand what you're saying about the height, right? It's not about the height, it's about the use of the space. And there's an enormous amount of space in both that building and this building that's being used for mechanical equipment. And there should be an evaluation of both buildings in terms of the adequacy of that space for the mechanical equipment that's set
so
aside.
I think that DOB, for one, has now, well, long before we had that case, DOB analyzed whether mechanical space is being improperly designated as mechanical space, right? They always had rules of some percentage of the building was a reasonable percentage. Very tall towers, of course, have different kinds of mechanical needs than other kinds of buildings, right? And so they're the ones who we would then have to ask, DOB, did you check whether, sort of check the smell test on the amount of mechanical space? But that's actually a different question than whether the definition of mechanical not being floor area is properly allowing height, right? What you're asking, which is a completely different question that DOB didn't analyze, is that amount of mechanical floor space appropriately designated as mechanical floor space? So we would need to go back to DOB and say to them, you would need to say to them, we need a determination on whether there's too much mechanical floor space, which DOB is actually better equipped to analyze than we are because none of us are mechanical engineers, right?
But that's not before us.
And it's
because
not, that's what I'm
wasn't-
trying to say. You need to go back and get a different determination on a different question. Your question was about whether the voids are legitimately high.
Okay.
Right.
So let me make one final point. I'm going
Okay.
to delete most of this because it was largely about voids, and you don't want to talk about voids. But I
Right.
will say, I'm sorry, not voids, vesting. But the one question about vesting I will say is that Mr. Karnofsky's papers said that the developer informed the DOB that they had vested. And the point is that there hasn't been a vesting determination, and the fact that there is no slab.
That would make us not have jurisdiction over the issue at this point, though. Because there wasn't a determination, so we can't decide on that.
We don't have a
We
determination.
don't have jurisdiction. If there was a determination and that was challenged, that would be a different story.
Right. So, I mean, arguably, you should have challenged DOB's finding of vesting within 30 days of the vesting date. That's really the way you should have done it. I don't know if there's another way to pursue it now. But we can't because it's not before us without a DOB determination that their vesting was
We lack jurisdiction.
right, right.
All right.
Okay.
Are there any questions?
No, this was your chance. Thank you. Mr. Klein, did you want to add something?
Yes.
Morning, Madam Chair, Commissioners. My name is Stuart Klein, Slowick on behalf of Landmarks West. Just to put a fine point on this vesting issue, I will be filing, it is obviously not before the board, I'll be filing a request to revoke the permit based on failure to complete the foundation in a timely fashion, and that would be supported by both testimony of the surrounding community and pictures. But putting that aside for the moment, I'd like to address the last matter that was raised by the board and by George. And I first looked to page 3, paragraph 4 of the ZRD2 denial, which said, "The challenger claims that areas claimed for mechanical exemptions should be proportionate to their mechanical use." In response to that, the city said, "A review of the proposed PAA document 16 indicates the proposed mechanical deductions are substantially compliant." In my papers that we submitted in May, on May 13th, 2019, we suggested that those mechanical deductions were a bit fanciful and overreaching. And I'm not speaking to height. I think the problem with this particular area of concern is that everybody's discussing height, and I'm not discussing height. Height has nothing to do with this. In the Sky House case, it was resolved by the board that the height is not to be taken into consideration. However, the mechanical space, the use of the mechanical space, or rather the space used by mechanical equipment, should be taken into account. And
Sorry, what you read, was that a final determination
yes,
or an
it was.
objection?
Yes, that was page 3, paragraph 4 of the final determination by Scott Pavin at the Hub.
Can you show me that?
Sure, of course.
Because it's too hard to find it in the PDF. Don't know. Because it wasn't discussed in any of the papers, right, about mechanical equipment not being, so that the question wasn't presented to us in the papers, that there was a question about the amount of mechanical.
I don't think it was expanded upon, but certainly the question was asked. We asked in our May submission that we challenged that particular section that said the mechanical deductions were appropriate. And the mechanical deductions, obviously, the board accepts the fact that the mechanical deductions are two-dimensional. It's the area covered
Okay.
by the mechanical space.
So that was a Borough Commissioner denial on looking at the amount of
That's correct.
mechanical space.
And that, in
Right.
fact, was the
Okay.
predicate for this entire application.
Well, so what I'd have to say, because at the beginning of this case, Mr. Lobier, and we've had submission on this, stated that that the appellants want a kind of speedy review of this challenge. And a review of mechanical voids is a long review process. I mean, mechanical space is a long process because it requires a submission by property owners, engineers of the mechanical equipment. It requires DOB to go through it with us and go through and look again because we don't have enough
With all due
detail from them.
respect, that's not the burden on the DOB or the board. It is not for the board to determine if the mechanical deductions are correct.
Oh.
In the representation on the Sky House case, the Buildings Department came in and said it reviews these things on a case-by-case basis.
Right.
Based on the information that was given to them.
Okay.
The problem with this particular case is that none of that information was given to them. Yet they somehow decided that the mechanical deductions were appropriate.
But they get mechanical drawings filed with the application. I don't understand.
I blew up each and every one of those mechanical spaces, I think it's floors 15 through 19, and none of them are dimensioned, number one. The floors are not dimensioned, number two, so there's no proportionality drawn between the particular piece of equipment and the amount of space that is being in. And-
You looked at mechanical drawings?
Yes, I did.
And you determined from just looking at mechanical drawings that they were not proportionate?
No, I determined that.
You determined that you couldn't determine.
You couldn't arrive at any determination because the numbers weren't there. And in fact, they recently filed an all-2 application to put in 2 boilers, and the boilers are not identified, and there's no other information as to dimensionality of any of these units. But let me just go on for a moment.
Yeah, because I'm not really sure what you're asking us to do with anything. Nothing?
I'll make it very clear.
Okay.
Okay. After the Trump Soho Hotel case, and there was an issue in the Trump Soho Hotel case as to whether or not staircases that went through spaces used entirely by mechanical floors, whether they should be eliminated from FAR computations. And in order to clear that up, In the wake of that, there was a great deal of discussion over at the Building Department, and Tom Farriello, the first Deputy Commissioner, came out with a draft memo, a draft bulletin, rather, that the plans examiners are using to this day for reconsiderations. And he said in that, and I will submit a copy to the board, the bulletin reads in part, "The purpose of this bulletin is to clarify what types of equipment qualify as mechanical equipment, as well as establishing the size criteria for mechanical floor area deductions." It goes on to say that the department must consider the floor space directly adjacent to the mechanical equipment for the purposes of access defined by the ratio of equipment, something you raised yesterday, ratio of the equipment to the adjacent service area, or the manufacturer's recommendations regarding the required service area. Further examples are given regarding pipe shafts and horizontal piping. None of that information, none, zero, was submitted to the Buildings Department, despite the fact that in the Sky House case, the Buildings Department said before it would give approval on a permit, it reviewed each and every one of those issues. Now, I reviewed the mechanical plans for floors 15 through 19, and not only were there no specifications, there was nothing submitted to the Buildings Department with regard to manufacturer's cut sheets or manufacturer's recommendations. Now, you have to take into account that this particular building is asking for a 10% reduction in mechanical space, as opposed to Sky House, which is asking for 5%. Historically, the Buildings Department would accept anywhere between 5 and 6% as maximum deduction. Here we have 10%, and there is not a scintilla of evidence submitted to the Buildings Department which indicates that additional 4 or 5% is acceptable or provable. So I believe, just like in the Sky House case, you have to be given, or the Buildings Department has to be given, those very facts that were apparently intentionally eliminated from the submission of the Building Department, and review them to see what the proportionality is between the units in question, which apparently haven't been identified to anybody, and the amount of deductions taken. And once again, this has nothing whatsoever to do with height.
Understood.
Okay.
So just to clarify, you just said before that it's not our job or DOB's job to calculate this, but...
Oh, it's
you're
DOB's
saying-
job.
So it is DOB's job. to
DOB's
calculate.
job, in Sky House, they were quoted as saying, it is, we look at this on a case-by-case basis before we give our approval. That could not happen here because they didn't have the information.
And you're
Okay.
requesting for DOB to respond to that here.
That's absolutely right.
Okay, so then I say, so I don't think we're in a different place than what I said before. It
You always agree.
takes time for the DOB to review this material. We would ask them to review the material, and the applicant would have to, the property owner would have to submit that material. That takes time for review, and then if you disagree with DOB's determination, DOB may change its position, right? But if you disagree with the determination, then you would bring it here, the follow-up here. I understand there's a final determination, but you're asking DOB to do something arguably more than they did already. They may have...
No,
suggested-
I'm asking DOB to do what they say they do in every single case,
Okay.
which wasn't done here. Now, I know where you're going with this, so it
More
maybe...
time.
What?
It's just...
Yeah, I know, I know.
Time.
So what I would suggest is, maybe we should split the two applications, and the board can decide vis-à-vis the packing issue and the tower issue, and
Then
we
you
could
submit
reserve
it.
this.
Okay.
We could reserve this for a further submission by the building department.
Right, okay,
That would move this along.
that would move this along.
Right, exactly.
And then you can decide what to do with your other...
Exactly, because we're talking about 20,000 square feet of space here that I don't believe should be given to this building.
At least you don't say there's any basis for it at this time.
Excuse me?
You didn't find any basis for it at this time.
There was no basis for me to make that determination.
He didn't
In
have
like
to
manner,
make it.
there was no basis for the building department to
Right.
approve it. Thank you.
Thank you. Okay, anybody else for the appellant representative? Okay, so then the property, DOB, actually.
Good morning, Commissioners. Michael Zoltan on behalf of the Department of Buildings. The appellants challenge the department's issuance of the permit for two reasons. Therefore, there are only two questions before the board. One, whether the department correctly determined that the building complied with the bulk distribution provision of 8234. And two, were the floors containing mechanical equipment permitted to be deducted from the available floor area on the zoning lot due to the floor to ceiling heights. I'll discuss the building's compliance with the bulk distribution provision first. So during yesterday's executive session and today, the board seemed to understand the department's argument regarding the reading of the statute. The plain language of 8234 is unambiguous. It clearly applies to the entire special district. One point I'd like to add to the whole argument of the phrase within the special district. The zoning resolution is a roadmap. You turn to any section and it tells you which district it's applicable to. Frequently, sections specifically list the relevant districts. So if you turn to provision, it will say this applies to R9 and R10. Sometimes the provisions are incorporated by reference, such as in this one, 8236, which is the tower coverage provision that's sort of linked here that we've discussed. That specifically sends you to 3345, and 3345 tells you which districts it applies to. It says on it R9 and R10. And sometimes you need to refer to earlier in the chapter to see where the parent section applies to. So 23651 doesn't say the districts, but you go right up to 2365 and it tells you it applies to R9s and R10s. The zoning resolution tells you where it applies. It's not just this within the special district. Each section always tells you where it applies. The appellants admit that the zoning resolution does not in any written way state that 8234 does not apply in the R8 district. Instead, they request the readers of the zoning resolution infer its applicability to the C47 district only. Nowhere else in the zoning resolution is applicability, or lack of applicability as the case may be here, is it inferred within the zoning resolution. So I think Commissioner Shibata put it best yesterday. I think this was the quote. My recording was a little fuzzy. Is the legislative intent so clear that this result is absurd enough to override unambiguous language? The department submits that the evidence of the legislative intent is not clear enough to override plain unambiguous language. Clearest evidence of legislative intent is the plain reading of the statute. In this case, the text provides all the evidence as to what the drafters were intending. Anytime provision in the special district was intended to apply to only a portion of the special district, the drafters did one of two things. Either they listed the sub-district, so in 8231 it says within sub-district A, for any building in a C47 district. Or they incorporated another provision by reference that clearly laid out the applicable district. Again, going back to 8236, the tower coverage one, they send you back. In this case, the drafters wrote the language in a very specific way. They did not list specific portions of the district, nor did they incorporate by reference a provision stating that it only applies. Quite the opposite. They added the words within the special district. The plain language, it's not a scrivener's error, it's specifically chosen by the drafters. So now I turn to whether or not this accomplishes the drafters' goals.
I just want to pick up with one paragraph there. So that's 8235, which says within the special district. 8236, which is the special tower coverage and setback regulations, says, to pick up on what you were saying, the requirements set forth in section 33-45, parentheses, tower regulations of another chapter, or 3564, special tower regulations for mixed buildings in another chapter, for any building or portion thereof that qualifies as a, quote, tower, shall be modified as follows. So, to the point of your
That was
specificity.
8236, right?
Yes.
So that
Yes.
sends you back and tells you specifically which district it applies. I may have misheard, but the other one I referenced was 8231, which talked about sub-district, and that specifically said within, and it didn't send you outside the special district provisions, but it referenced the sub-district, which is in the maps, and C47.
Correct.
So they specifically enumerated the zoning districts in the special district as opposed to just saying within the entire
For-
special
I
district.
just, I'm reading this for the benefit of a transcript. So 8231 says floor area ratio regulations for commercial uses within sub-district A for any building in a C4 district, the maximum permitted commercial floor area shall be. So it's qualifying and qualifying and qualifying several times, so you know exactly what to do where.
Okay, now going on to the drafter's city planning's goals. The appellants allege that the plain reading of the unambiguous text is at odds with City Planning Commission's goals of limiting building height. Not that building height was the only goal, but going with that. Specifically, appellants argue that the plain reading of the statute would result in a reading that would actually permit an increase in the height of the tower beyond what would otherwise be permitted. This, however, is not true. In order to understand whether the plain reading of the provision effectuates city planning's stated goal of limiting the height of buildings, we need to look at a world with the provision with plain reading and a world without one. So, 8234 states that within the special district, at least 60% of the total floor area permitted on a zoning lot shall be within stories located partially or entirely below a height of 150 feet.
I have a question. Are you conceding that the goal is to limit is you saying that's,
No.
you're not conceding that?
I mean, they stated as one of their goals. I mean,
And do you agree with that statement?
that it was
That
one of the
this
goals?
is one of the goals, that to limit the height of a building?
Of that section specifically, no, but of the entire special district, one of the things was, yeah, they talked about the height of all of the buildings that were there beforehand or that could have been built, and they enacted a broad set of regulations with a bunch of goals, one of
which to limit height.
yeah. Right, so now applying the provision to the entire zoning lot, regardless of the district, does place a limitation on the height of buildings. It requires 60% of the floor area of a zoning lot to be located below 150 feet. This does place a limitation on the height of buildings. Now, possibly not to the extent that appellants want it to be, where it would be for the smaller zoning lot, but it does limit the height of buildings. Now imagine a world without it. No requirement to pack the bulk. Now there's no requirement to maintain 60% or any percent of the floor area below that 150-foot line. This would lead to taller buildings. So the provision, as read plainly, does cause buildings to be lower. Now, not to the extent that appellants would like it to be, but it does keep it lower. And this shows that 8234 is not an absurd result, as it does accomplish their goal. Now turning to the CPC report, which again, I agree it's not required to turn to when the plain language is unambiguous. That's the end. You read it as it's written. But, arguendo, when discussing 8234, the CPC report refers to the provision as applying to massing and height of new buildings. However, when referring to the tower coverage provision of 8236, the report, and again I'm not in the text, says it would establish minimum tower coverage standards. Even in the report, the drafters were clearly indicating that 8234 would apply to all buildings, tower or otherwise, whereas 8236 would only apply to towers. This shows that the drafters were intending to apply 8234 to the R8, which is not typically developed with towers. Again, it's just evidence that, even in the drafting stage, this was a consideration.
You believe the intent, they considered this particular result?
I'm sort of arguing both sides. So, if they intended it, I'm saying that the evidence is not clear in the
understand your
CPC report of what they intended, that they 100% intended that this should not be allowed. I think the plain text is clear,
Okay.
plain text, and then within the city planning report, the
You're not-
drafter's intent is not fully clear. It's still messy there.
I understand.
And in the report, because this discussion was about towers, the idea that they used the word building when the real discussion was about or not the real discussion, when the discussion was concerned about height of towers, and then they used the word building in the report, shows that they're actually considering both eventualities. Not everyone's going to build a tower, right? So there will be buildings that are affected by these regulations and towers that are affected by the regulations. Not everybody will build a tower here because they don't have the zoning lot size. There's a preference for not a tower. it's not the right type of building typology for 40% coverage, that kind of thing.
The appellants cite numerous elements of the report to evidence the intent of the drafters. However, nowhere in the report does it clearly state that 8234 is only applied to the C47 portion of the special district. It's not a case where the report says one thing and the drafters forgot to add that small but crucial detail. Instead, the appellants are attempting to infer from some of the CPC's words that the appellants believe that the drafters meant to apply 8234 to the C47 portion only. However, absent clear and unambiguous language affirmatively stating that 8234 should only apply to the C47 districts, this is only really speculation. For instance, the appellants cite 23651C as being similar to 8234 and as a provision which applies only to R9s and R10s as indicative as to what the drafters were thinking. But I would counter by saying that this shows me that the drafters knew how to distinguish that a section applies only to R9 or R10, or in this case C47, and chose not to in this case. The drafter's intent is not clear from the CPC reports. So for this issue, I remind you of the question I'm asking the board to answer. Is the legislative intent so clear and unambiguous language of the ZR is rendered absurd enough to be overridden? The department submits that it is not. Now I'm going to turn to the second part, which is mechanical space.
So I actually had a question for you. Oh, so it actually wasn't a question for the owner, but it's a DOB question as well. So because the R8 district permits towers in the R8 for a community facility, this is something you probably won't be able to respond to on the fly, right? Is there any interpretation that the community facility portion of the building somehow or other invokes the community facility tower regs for this site, which is, I'm trying to get my head around exactly how you do it, but the instructions are kind of, they're the same, right? But then you would be applying the tower coverage to the entire site because you've got both a community facility and a residential tower, if that were the case, right? I'm not sure that it
the tower
applies.
coverage provision or the...
To the coverage. So
well, the tower coverage provision specifically references districts.
I think the tower coverage portion for the community facility in R8 and C47 is the same.
is the same.
Same, right.
So
Okay,
that's the
then it
thing.
would link you into...
It would link you in, and then
Exactly.
you would be distributing the coverage on the entire zoning lot. So it would be bulk and tower on the entire zoning lot. But the question is, and I'm not sure because I just didn't sit there and try to analyze it, whether the programming in this building might invoke tower regulations for the community facility.
Okay,
You know?
I understand the question.
But I didn't analyze
right,
it. I
sorry.
just noted that there's a tower.
Community facility.
Yeah.
So, right, I don't have an answer on that right now. I can look
Okay.
into it. Moving on to the mechanical equipment. So, the board stated yesterday that the issue of the floor to ceiling height is...
I'm sorry, there's one more question.
No.
Are there any other, any districts where towers are permitted but tower coverage rule doesn't apply?
I can't speak of special districts offhand or anything. I'm not going to speculate. I'm not sure.
Yeah.
You can
Okay.
look into it if you want.
I really would appreciate that.
So to clarify,
Where tower coverage, where towers are permitted but tower coverage rule doesn't apply?
tower coverage,
No,
not
tower-
bulk distribute. Tower
Towers
coverage
don't
bulk
exist without a coverage
A tower coverage
limitation.
rule.
It's not a tower unless it has a
It has
tower
a-
coverage rule.
Right.
That's how you make a tower, is you don't cover more than X of a lot.
That was tower coverage, not bulk distribution that you were asking on.
Sure. Right.
Okay.
Okay.
So on mechanical equipment, the board stated that the issue of the floor to ceiling height is an issue precluded as previously decided by 15 East 30th Street, and the department agrees, and I'm not going to talk about that any further. However, yesterday the chair asked for clarification regarding the timing of the foundation permits. So under the ad code, you can receive a foundation permit once you get zoning approval, even if you don't have the NB permit yet to actually build a building, and it says in the code how it's it's at the risk of the developer to continue, but you can get the foundation permit once the zoning has fully been approved. In this case, the owner received zoning approval way back when the building had a bit of a different design with the mechanical space structured a little bit differently. This was in July of 2018. So that was when the zoning approval was given and the foundation was planned for the same footprint as the building currently is going up. Then procedurally, the department issued an intent to revoke on that zoning approval, never revoked it, but issued an intent to revoke. The foundation permit was still valid. And then there was the PAA, which changed the scope of the NB permit and the zoning approval a little bit, but again, the foundation was never changed. So the foundation has been approved since July of 2018. That didn't change based on this PAA. That was only affecting the NB permit, not the foundation.
Okay, and in terms of vesting, as long as the foundation that's going to be used for the building above it is complete, then it doesn't matter if there's a change in the building above it, as long as there's a change prior to the enactment date?
If if the foundation is complete and the foundation itself doesn't change, then the
Right.
foundation, that's fine for the foundation being complete, but the permit still has to be valid. You can't change and increase your non-compliance or non-conformance after the text change.
No, but before the text change. So anytime up to the text change, you can change the design of the NB, right?
you-
As long as it's relying on the same foundation.
See if this clarifies, or is enough. If on the date of the text change, you have foundation permit, foundation was completed, and is completed for the building going forward, and you have an NB permit, you have vested.
Okay. And it doesn't matter when the NB permit is
Correct.
approved, as long as it's prior to the enactment date?
Of the vesting date.
Okay. Thank you. That's
Um,
helpful. Okay.
One of the last things that came up was regarding the ZRD, the public challenge, and then the ZRD2 signed by Borough Commissioner Scott Pavon. Just for clarification, because this case has had a lot of procedural happenings, that was based on a public challenge in a ZRD2 that was the subject of a formerly filed BSA case that was mooted out based on the new ZD1 in zoning approval. So this BSA case is not a challenge of any DOB public challenge ZRD2 decision. It's a challenge of DOB issuance of that PAA approval, which changed the scope of the NB permit. So it's essentially challenging a permit, not that underlying ZRD2. That ZRD2 was actually rescinded by implication when the intent to revoke was sent out. So that ZRD2 is sort of was mooted out, and the BSA case based on it was mooted out. So
Okay.
that's what's before the board now.
Okay. So if the challengers wanted to challenge, for instance, vesting, that's a whole new pursuit at DOB.
But not just vesting, it sounds like
As
he's
he's saying
saying if they want to
mechanical.
challenge
To
the
the
floor area
the
of the
mechanical also.
space.
Well,
Yes.
not, well, the height was before the board,
Right?
but the 2D layout was arguably not, as it wasn't part of this actual appeal.
But they do
Okay.
have a basis for, you're saying they don't, it's not before us because it was, you did an intent to revoke or rescind and therefore mooted out the original.
I'm saying that
There's
right
no-
now it's not before the board,
Right.
as it's not one of the final determinations that is being that
Presented here.
Right, it's not the subject of this appeal.
Okay. Okay. Thank you very much. Helpful. Okay.
We have a slideshow, if you could just wait 1 minute.
Okay.
Madam Chair, members of the board, David Karnofsky, Fried Frank, Harris, Shriver, and Jacobson, Land Use Council, to the project, to the appellee in this matter. The appellants have raised two issues, and two issues only, in this matter, but the board was clear yesterday that it views the height of the mechanical spaces issue as decided in its 2017 decision regarding a site on East 30th Street, as well as on the basis of the subsequent legislative action taken by CPC and the council in 2019. We agree for the reasons set forth in our papers, and I won't dwell on this issue further unless you have questions. Second, of course, appellants argue that the plain language of 8234 of the Special Lincoln Square District doesn't mean what it says and means something altogether different, what appellants would like it to say. I'm going to go through this issue of within the special district in some detail to examine all of the various arguments that they make about it, precisely because, as you, Madam Chair, have said, one has to understand that not just on its own terms, but in the context of the structure of the special district as a whole. I'm then going to talk about the legislative history. I'm going to talk about the absurdity point. And finally, I want to make some remarks about the issues raised by Mr. Klein with regard to mechanical space as a matter of process and procedure before this board. Section 8234 states, very simply, we know it, within the special district, at least 60% of the total floor area permitted on a zoning lot shall be within stories located partially or entirely below a height of 150 feet from curb level. Except, say the appellants, within the special district somehow means in certain portions of the special district, not the entire special district. In fact, they now say in their most recent papers that it means, quote, within the special district where applicable, unquote. But the areas within the special district to which appellants say 8234 applies, the C47 portion of the zoning lot, and the portion of the zoning lot to which they say it does not, the R8 portion, are nowhere identified in this regulation. And so what they are asking this board to do is to rewrite the statute, either to exclude the R8 or to include the C47, or perhaps to do both. And they assert, without any support, that what they call, quote, implicit qualifications of this kind are routinely read into language all the time. That is not the case. As Commissioner Chanda pointed out at the review session yesterday, the special district does not operate on the basis of implicit exclusions or inclusions. Instead, the special district regulations are fine-grained and highly tailored, and in many instances only apply to specified portions of the district only, to specified sub-districts, to specified street frontages, to only certain of the underlying zoning districts mapped within the special district. And here are some of those provisions. In particular, and this was pointed out earlier, 8231 as an example, within Subdistrict A, for any building in a C47 district, the maximum permitted commercial floor area is 100,000 square feet. And on, provisions which specify the area, the location, the sub-district, the zoning district to which they apply. Now, other special district regulations are not as narrow in scope as these, and there are many more cited in our papers, but they instead apply within the special district, but with certain specifically identified exceptions. And here are some examples of this kind. Within the special district, all buildings shall be subject to the height and setback regulations of the underlying districts, except as set forth, and then the modifications, the exceptions are set forth with specificity. Likewise, that second provision with regard to loading. So, when the City Planning Commission wanted a provision to apply to a particular sub-district, to a particular street frontage, to a particular zoning district, it said so, and it did so often. And when it wanted a rule to apply to the entire special district, but with some exceptions or modifications, it also knew how to do so, and it did so. Unlike all of these provisions, Section 8234 applies without any exceptions. By its terms, it applies irrespective of sub-district, street frontage, or any other limitation as to location. It therefore applies to the zoning lot irrespective of the underlying zoning districts of the zoning lot. Appellant's argument is not only at odds with the structure and language of the special district, but it's at odds with the zoning resolution as a whole, which uses the term within the special district in other special district chapters at least 90 times to mean what it says. According to appellant's latest argument that within the special district means within the special district where applicable means where towers are allowed. And they first assert that towers are not allowed in the R8. But of course, as the chair pointed out yesterday, community facility towers are allowed in R8 districts under section 2454. This is it, and it says basically that in the R8 district, portions of buildings which in the aggregate occupy not more than 40% of the lot area can penetrate the sky exposure plane. That is a tower, community facility tower in the R8. Now, our papers attach 2 illustrations of community facility towers that could be built within the R8 portion of the zoning lot. And here they are. It's a little hard to read, and we have copies we can circulate as well. But the first shows the height and number of stories of a community facility tower that could be built on the R8 portion of the zoning lot without application of 8234 60% bulk distribution. It's a building of 470 feet and 30 stories. The second, on the right, illustrates the height and number of stories of a community facility tower that could be built with application of the bulk distribution under 8234. It is a tower of 350 feet with 22 stories.
But you're just applying that to the R8 portion in terms of bulk distribution?
That is correct. In this case, we're showing you a community facility tower in the R8 portion and showing you the difference between the application of the rule.
But this is using the tower coverage and bulk distribution on the same size lot?
Yes, this is on the R8 portion only of our zoning
Right,
lot.
but this is exactly what appellants are saying. That's what you're supposed to have been done in the C47, right? The picture should have looked like that in C47.
We will
right?
get to that, but the
Okay.
point here is just a very simple one to illustrate. A community facility tower can be built, and that 8234 has an effect on the result.
Okay.
So appellant's repeated statements that there's no conceivable purpose to applying 8234 in an R8 district is belied by these examples. Now, trying to overcome this, the appellants say, well, community facility towers are rare, the drafters probably didn't think about this. Of course, as Commissioner Chanda said yesterday, this is an area that is characterized by some major community facility uses, and indeed, until very recently, Touro College had a facility on a site just across the street from the project site within an R8 district. But appellants then say, well, even if 8234 applies everywhere in the district, that doesn't mean that it must apply everywhere in the district. In other words, I guess what they're saying is that it only applies when development occurs under the tower regulations, so that standard height and setback buildings are not subject to the requirement. But 8234 says nothing of the kind and draws no distinction between standard height and setback and tower development. Now, Madam Chair, you asked 2 questions about this yesterday. First, you asked whether the portion of the proposed development located in the R8 portion of the zoning lot is being built pursuant to tower regulations or pursuant to standard height and setback. The answer is standard height and setback. We can provide more information on that. Second, you asked whether there is any incompatibility between Section 8234 and development under standard height and setback regulations. In other words, would compliance with 8234 impede development under standard height and setback in any way? And the answer to this is it would not. This is an illustration of a generic R8 building built under standard height and setback that rises to 85 feet and then lives within the sky exposure plane, and it shows that...
This is an alternate.
Yeah, this is alternate. And we can provide other examples. This is alternate. And it shows that the 60% within the 150-foot requirement is more than met. It's somewhere in the 80%. So any suggestion by the appellants that 8234 by definition can only apply to tower development is simply wrong.
And I just want to point out with that diagram, I understand why alternate was used, because it's the skinniest version. We see a lot of hotels that are built with this alternate setback, right? It's the skinniest version, and if the idea was to prevent the skinny version, it's still possible to build it that way as opposed to a street wall height and setback building.
Provided that is permitted in our.
Speak up.
Yeah, no, the height and setback, the street wall height and setback is permitted in an R8, right? This is an alternate setback version, and I understand why the test was done for alternate setback, because if there was an intention to prevent skinnier buildings, which those alternate street wall buildings are, alternate setback buildings are, it's obviously not being prevented, it permits it to comply with the 150-foot
Right.
rule. Okay.
Now, at the same time, the appellants have made the argument that DOB's calculation of the 60% of permitted floor area based on the zoning lot as a whole violates the split lot rules, because 8234 applies only to C47 district. So under this argument, unlike the one we've just discussed where appellants acknowledge that 8234 may apply to the entire zoning lot in both districts, they're saying that it doesn't apply in the R8 district at all. So they're arguing this every which way. But in the absence of any language in 8234, which limits its application to the C47 portion of the district, C47 portion of the zoning lot, appellants resort to pointing to a different section altogether, which is 8236. And they argue that that provision somehow limits the application of 8234 to the C47 portion of this project site. This is 8236, and we've talked about this before, or I should say that my colleague, Department of Buildings, talked about it before, so I won't dwell on it too much. However, 8236, by its terms, governs how tower development under 3345 and 3565 apply within the special district, with certain modifications specific to the special district. Now, sections 3345 and 3565 are commercial tower regulations that necessarily apply in the C47 district, but not in an R8 district. And the same is therefore the case for 8236. And so the project site is clearly a split lot for purposes of 8236. Nothing in section 8234 sets forth a similar limitation, restricting its applicability to a C47 district only. And there is also nothing in 8236 itself, which by cross-reference or otherwise provides that 8234 only applies to the C47 portion. So, unlike in the case of 8236, the project site is not a split lot for purposes of 8234, and the 60% calculation under that provision must be applied across the entire zoning lot. Now, in yet another attempt to narrow the scope of 8234 to the C47 portion of the project site only, the appellants argue that the phrase "within the special district" is a kind of explanatory note that is only intended to highlight that 8234 differs in what they characterize as minor respects from the bulk packing rule of section 651A3, the tower on the base rule. According to this fairly convoluted logic, the phrase "within the special district" signifies in 4 words, and this is the language from the appellant's brief, signifies the following: that the general version of the bulk packing rule in 23651 differs from the special district version in 8234 in that it is slightly less demanding and also more complex. The required percentage of floor area below 150 feet starts at 55% and increases as tower lot coverage decreases from 40% to 31%. This is packing a lot of words into "within the special district." What appellants are arguing is that the special district is either governed by or somehow just a variation on the tower on a base regulation set forth in 23651. Of course, if the City Planning Commission had wished this to be the case, it would have said so. And CPC routinely does this sort of thing in special district regulations, under which underlying rules apply with specified modifications or exceptions. And here are a few examples from other special districts. These are all situations where the special district regulation says within the special district, underlying rules apply with certain exceptions and modifications. The City Planning Commission knows how to do this when they want to do it, and they did not do it here. Now, appellant's response to why the City Planning Commission didn't do something like what I just showed you is that the drafting would have been too complicated. And here's what they say. It would have severely challenged the drafters and resulted in an incomprehensible provision had they tried to draft the special district version as a modification of the general provision, as Excel suggests. In fact, DCP did precisely what the appellants say would have severely challenged the drafters when in 1993 it adopted Section 3564 at the very same time as the Tower on a Base rule. Now this section, 3564A, expands the locations to which Tower on a Base regulations apply beyond the R9 and R10 districts that are specified in 23651, and it provides that the Tower on a Base regulations apply to specified commercial districts, by the way, not including a C47, subject to certain enumerated modifications. By contrast, 8234 does nothing of the sort. It makes no cross-reference to 23651, and it doesn't incorporate the provisions of that section by cross-reference either with or without modifications. Why exactly are the appellants making this tortured interpretation of the term within the special district? By characterizing the phrase within the special district as a kind of explanatory note that 8234 varies from Tower on a Base with respect to the percentage of floor area subject to bulk distribution, the 60% versus the 55 sliding scale, the appellant's objective is to create the impression that 8234 otherwise operates identically to Tower on a Base. And as I'll explain in a minute, this is a sleight of hand designed to read Tower on a Base into the special district in order to calculate bulk distribution under 8234 without including the R8 portion of the zoning lot. Now, Tower on a Base and 8234 differ from each other in a number of ways, both large and small, and our papers discuss many of those differences. One such difference, for example, is that Tower on a Base applies to zoning lots that have frontage on a wide street. 8234 has no such limitation. Appellants' attempt to erase the differences between the two provisions fails for all of the reasons that we cite in our papers. But the key difference between the Tower on a Base regulations in 8234 and 8236 for purposes of our discussion today boils down to this. Under the Tower on a Base regulations, both the minimum tower coverage requirements and the bulk packing requirement are found within the tower regulations of Section 2365. These are the tower regulations of 2365. They apply only to tower development within R9 and R10 districts only. The minimum tower coverage requirements in 23651A and the bulk packing requirement in 23651A3 are in fact subparts of the same provision, 23651, which again applies only to tower development in R9 and R10 zoning districts. Therefore, where a tower on a base building is built on a zoning lot that is split between an R9 or an R10 and another district such as an R8, the bulk packing calculation is consistent with the express terms of 2365 made based on the floor area of the portion of the zoning lot within the R9 or R10 only. 8234 and 8236, on the other hand, are two separate provisions. They are not subparts of a single provision, nor do they cross-reference each other. One, 8234, governing bulk distribution, applies to any zoning lot within the special district. The other, 8236, governing the calculation of tower coverage in towers built under commercial district regulations, applies only in the C47 district. They both apply to the project site, there's no question about that, but are not linked in terms of applying to the same zoning districts as is the case with 23651. Therefore, whereas here a tower is built within the special district on a zoning lot that is split between a C47 and an R8, the bulk distribution calculation is based on the floor area of the zoning lot as a whole, consistent with the plain language of 8234. Now, perhaps recognizing that their explanatory note theory is wholly implausible, they now say that CPC, quote, had no need to cross-reference the two versions of the bulk packing rule or to indicate in any way that they are essentially the same. Well, why is that? Appellants now say because it's obvious they're the same. But tower on a base and 8234 are different, and they operate differently. And the fact that the two provisions were adopted on the same day doesn't make them the same. another argument made by appellants. These are two separate provisions adopted through separate applications with different language and different applicability. I'm now going to turn to the legislative history. And on that, I would say that this board, I think, has consistently followed the admonition of the Court of Appeals in the Raritan case, which I believe is still good law, that where the statutory language is clear and unambiguous, the court should construe it so as to give effect to the plain language, and resort to the legislative history is not necessary. And we think that standard is met here, and that the analysis really should end here. However, yesterday the board did express an interest in the legislative history, so I'm going to turn to that now. Looking to the legislative history, the appellants point out that in considering the 1993 amendments which added 8234, DCP identified what it considered to be 6 remaining development sites in the special district for study. These were selected based on traditional soft site criteria: vacant land, vacant building, a site which contains a commercial building which is at least 50% underbuilt, only up to 50% built under the allowable FAR, a site which contains a residential building but has less than 4 occupied units. Now, each of these sites was located entirely within a C47 district, and appellants cite this as support for the proposition that Section 8234 must therefore only apply to property map C47. In effect, what are they saying? They're saying that a zoning provision should be narrowly construed to apply only where the characteristics of a site match those of soft sites that were studied in the preparation of the amendment. In other words, that within the special district means, and here's some language I've crafted which would have to be added to reflect their position, within the special district for those sites with the characteristics which match those of the 6 potential sites identified and studied by the Commission in the preparation of this amendment. The absurdity of this proposition is obvious. The fact that these 6 soft sites did not include one in the R8 or even partially in the R8 is not a basis for ignoring the plain language of the statute that was adopted. The legislative history, in fact, shows that both CPC and the stakeholders in the process understood that the new rule governing bulk distribution would apply on a district-wide basis. And that's because, as discussed in the CPC report, various stakeholders had proposed a district-wide 275-foot height limit, absolute height limit. The City Planning Commission rejected a district-wide height limit in favor of its own proposal, which did not include fixed height limits expressed either in terms of feet or numbers of stories. Now, the appellants state, essentially, that in rejecting a district height limit that the CPC made, and I'm quoting, repeated invocations, and they repeated this today, in its report, that the regulations would produce buildings of, quote, a specific height range and upper limit from the mid-20 to the low 30 stories, although you heard about 20 to 40 today, so I'm not sure what's really being said. In point of fact, the CPC report says this once only. There is only one reference of this kind in the CPC report, and it says it only with regard to, quote, the remaining development sites, meaning the 6 soft sites. To be specific, CPC states in its report that its proposal, quote, would produce building heights ranging from the mid-20 to the low 30 stories, including penthouse floors, on the remaining development sites. The appellants ignore this qualification because their underlying agenda is to convince that buildings with stories in the low 30s were a fixed and firm maximum throughout the district, and that somehow CPC knew and believed this with a mathematical certainty. What the CPC said, in fact, was only that its proposed rules, quote, should predictably regulate the heights of new development, nothing more. Significantly, Community Board 7 and others strongly disagreed with this, with the board stating in its resolution recommending disapproval of the 1993 text amendment that, quote, city planning's proposal to limit building height with packing the bulk, requiring 60% of the bulk below 150 feet, has not been tested on actual buildings and is therefore unpredictable. And the borough president also took issue with City Planning Commission's rejection of a absolute height limit and was concerned about this other approach and encouraged the Planning Commission to consider the issue further, to reintroduce into the process an absolute height limit. And she said, it's essential to continue discussions with DCP during the review process so that a more suitable recommendation evolves that takes into account the context of the entire district as well as each of its sub-districts. So overall, what does this show? It shows that while DCP conducted planning studies on 6 soft sites, the DCP and the various stakeholders understood full well that the new rules would not be limited to those sites and would apply throughout the district in lieu of a district-wide height limit. And it shows that how the rules would play out on sites other than the 6 soft sites was a matter of dispute due to the fact that it had not been studied. The environmental simulation work focused on the 6 soft sites. Again, the appellants argue that the fact that the project site wasn't studied somehow means that 8234 doesn't apply to the R8 portion. They state, in 1993, the very small R8 portion of the site was entirely developed with substantial residential buildings and the large and then relatively new building of the Jewish Guild for the Blind, so it's unlikely that the drafters would have considered that that portion of the special district might be redeveloped, much less that it would be redeveloped with a tower. But as we all know, the drafters never have a perfect crystal ball. And the fact that development occurs which may have not been anticipated by the drafters is not a basis for having this board or a court rewrite the zoning which was drafted and adopted. As stated by the Court of Appeals in the Raritan case, the courts are not free to legislate, and if any unsought consequences result, the legislature is best suited to evaluate and resolve them. These appellants believe that this is an unsought consequence. Their recourse is to the legislature. In another sleight of hand, the appellants repeatedly state that application of the plain language results in an increase in the number of stories and building height. The question is, compared to what? As shown here and in our papers, if 8234 had never been enacted, the building, this building, could achieve 43 stories and a height of 839 feet. With 8234 in place, the building achieves 39 stories and a height of 775 feet. Appellants do not dispute, nor can they, that under the DOB approval, the combination of 8234 and 8236, each applied in accordance with their terms, operates to reduce building height and stories relative to what would otherwise occur in the absence of those provisions. Is this an absurd result? It is obviously not. Instead, the so-called increase in stories and height that they complain of is the difference between the height and number of stories that results from DOB's lawful approach in compliance with the language of 8234 and the approach that the appellants would prefer based on their interpretations. What are they saying? They're saying, ignore the plain language of 8234. Indeed, ignore the language and structure of the special district regulations and the clear differences between 8234 and the tower and the base rules on the basis of a statement in the CPC report that refers only to 6 soft sites that states in a rather tepid fashion that the application of the rules should be predictable, and it makes reference to a vague and undefined mid-20s to low 30s range of stories. And you should also ignore the fact, this is what they're saying, you should also ignore the fact that the CPC's less than definite, if not equivocal statement was actually the subject of a lot of dispute about the time about the efficacy of these rules to produce what the stakeholders wanted, which was more definition and more certainty as to what would result. Adopting the appellant's reasoning is the absurd result. And further, to suggest, as I think you pointed out, that in the face of the language of the statute, that a property owner or a zoning consultant should be required to figure out whether a building of 35 stories, 36 stories, 37 stories is somehow illegal because of a reference in the CPC report to mid-20s and low 30s is absurd. At the end of the day, appellant's complaint is not really with how DOB applied 8234 to the site. It's with the height of the mechanical spaces, which is 176 feet, the tall mechanical spaces. But as discussed earlier, and as recognized by the board, the building's mechanical spaces are lawful under the regulations in effect prior to May 29, 2019, these being the regulations under which the project was vested in April of 2019. I'm going to just talk a little bit about Mr. Klein's issue with respect to mechanical.
Before you do that, one of the questions that I did have for you, which I don't know if there's any more diagrams,
Yeah.
was whether the fact that there's a community facility in the R8 portion would somehow or other invoke an R8 community facility tower. I just don't, because I'm not really sure where the community facility is located in the building, and I didn't try to figure it out.
Can we follow up with that to show
Yeah.
you the location of the synagogue and the massing in the R8 with more precision? And I think what it will show is that it's been approved by DOB on the basis that the split lot functions so that the standard height and setback produces the base in the R8, and then there's the tower portion on the...
So that the community facility isn't in the tower.
Right.
Right.
Correct. That's
Okay,
correct,
okay.
yes. So we can show you.
Because that's the only way that it's community facility tower regulation would apply, in which case, now you've got tower coverage on the entire zoning lot as opposed to
Right.
just...
That was not the way it was done, and we can show you the location of the
Okay.
community facility.
If I may.
Yes.
I'm sure you've heard the arguments that of the absurd result. Do you want to respond to that? The absurd result of?
I think the question is this an absurd result? In this
Well,
case,
we're talking about this type of interpretation can lead to an absurd result.
you can always put together a hypothetical which leads to quote-unquote absurd results, and I think the courts, and we cite a case, have said that is not the way to measure the absurdity doctrine under New York state law. You look at the question of whether the result in the case before you is absurd or not on the basis of hypotheticals that are not before you, that don't exist, and that have been put out there simply to go down a rabbit hole. And we'll be glad to share that with you again. With respect to mechanical equipment, the issue raised by Mr. Klein, what I would say is this. If you read the statement of facts that Landmark West submitted in May, there are only two issues raised. With respect to the height of the mechanical spaces and with respect to 8234. It mirrors precisely the two issues raised by City Club. Extel joined in the request for expedited treatment made by the City Club, and the board scheduled a hearing for August 6th, as John Lobier said, about a month earlier than would otherwise have been the case. We were served with papers by the City Club and Landmark West in May, and those papers, as I just said, raised two issues and two issues only. We submitted our papers on July 23rd, and at the same time as DOB. And then last week, 2.5 months after filing our papers, and a week, 2.5 months after Landmark West had filed its papers, and a week after we had filed our papers, Landmark West raises for the first time other issues relating to the mechanical equipment. And you will not find that discussion in the original papers. It was about the voids. And what Mr. Klein said at that time was that he wanted copies of records, as their receipt will go a long way in determining if and when I can submit an appropriate response. Clearly, this was not about a response, as was the case in Mr. Lobier's situation, where he replied. This was not about a response. This was about whether Landmarks West was going to raise a whole new set of issues and essentially conducting what I believe was a kind of fishing expedition to determine whether or not it would in fact raise those issues. My point is that Landmarks West had ample opportunity to raise these issues in May, and it chose not to do so for whatever reason. And I think that this current request is an effort at delay. We don't think that the appeals process should work this way, and we don't think appellants should be able to raise issues like this at the last minute. And we will be prejudiced by this, because this is inevitably going to result in second hearings, third hearings, who knows? Precisely the result that we and the City Club were seeking to avoid when we asked for expedited treatment. So I enjoin the request that the board not consider these issues in the manner that was suggested earlier, because it is the late introduction of a new issue that could have been raised back in May, was not, and should not now.
Right, so you know that we can't prevent the appellants from going back to DOB from scratch and raising new issues. That's not we're unable to prevent that, so if they choose to do that, that's the way it goes. In another case, we tried to, there wasn't a time concern as much, so in another case, we pursued something, and you provided materials in order to respond to that, it's your option to do that. But then that extends the hearing process, and did extend the hearing process.
Could you indulge me a little bit and explain exactly how you see this working then?
So in that other case, because we could predict that the appellants were going to go back to DOB and ask for a determination on another issue, we suggested here that you had the option of allowing it to DOB to give their testimony on the subject, and then, and you responding by providing the materials for us, for DOB and us to review, right? And that was a way of kind of moving those questions along more expeditiously, as opposed to having them go back and starting again. And in that case, you were quite concerned, and everybody was willing to move that way. Yes, yeah.
This is
It was the sign,
Watchtower.
yes, correct. So, but in this case, you know, both you and appellants are saying that they want to move the decision quickly. So my recommendation is that we just stick with the questions that have been presented already in the papers, which are bulk packing and the subject of the mechanical voids, which we've already said is issue precluded, right? And then if appellants are going to come back with their next challenge, that's just the way it's going to be, but you won't get an answer. This way you'll have an answer on the first issue.
On the first issue, okay, thank you.
Yeah. I do have a question about the CPC report.
Yeah.
So I was trying to, when you said the subject of height was only mentioned once or something in the...
No, the subject of height was discussed.
No, but I mean 30 stories, number of stories. So, you know, I'm sort of chewing gum and walking at the same time while you're talking and trying to check the number of times that it's mentioned. And it seems like the subject of height of the tower was of great concern in the CPC report, and struggling with whether they actually limit the height by saying a maximum of 300 feet or 267 feet or something like that, and then a decision, no, that's a bad idea, except for those special sites in those designated locations, sites 1 through 4 or something like that, right?
Yeah.
So help me with this. If the text were more ambiguous, let's just, I don't know how we would phrase within the district in a way that it's more ambiguous. But let's just say, it would say, where applicable, or something like that. And then with where applicable in the district, and that you don't really know what you mean by that, because what do you mean by where applicable? Because as you say, that would apply to the R8 in the case of a height and setback building, right? Then, looking at the report and the concerns in the report expressed about a 50-story building as being so completely out of context, how would you respond to what this bulk packing separated from coverage is doing?
Well, first of all, I don't think it's possible to adopt within the special district interpretation that has that ambiguity.
No, I don't.
So I don't think we go there
right.
to begin with. And I think that's very fundamental. I think what the history shows is that there was a very intensive effort to study a limited range of issues on a limited range of sites. That's not surprising. Soft sites are what rezonings tend to focus on, particularly when you're in a predominantly built-up area like the Lincoln Square Special District. So I think that's what was going on. But the community board and others, and there's a fuller record on this in terms of various stakeholders, including Landmark West, who were in favor of this, took the view that there should be this, they wanted certainty. There should be 275 feet district-wide. The commission said, no, we've come up with this system, and we're going to apply it district-wide. And they only noted what it would produce, however, on the studies, on the sites they had studied. They had not, it seems to me, probably studied the fact that the district has more than one zoning district designation, although they were aware of it, and the report identifies the R8 as a component of the district. So our point is just that that is not, the fact that they may not have studied a R8 site or a split lot site does not mean you rewrite the law.
Well,
If
does
you don't
that
like the
mean-
result, you go change the law.
If it's completely against the intention of the law, then following it would not be appropriate.
Well, we disagree on that because
There's-
we've showed, I think, that following this law as written in its plain language does produce a reduction
result.
in height and in the number of stories. It may not be the reduction of height and stories that the appellants would prefer, but it does work. It operate, 8234 and 8236 work together.
I guess.
And they
with the
produce a
argument,
reduction in
though,
height.
With is the intention a reduction in height, or is the intention a much larger reduction in height?
There's no evidence of that.
Yeah,
There's
so,
one reference. You can't find anything in the report that indicates that.
Well,
And so
there-
there's, to say that this is an absurd result, I think, is really stretching it.
I think the report does talk about the concern about a 50-story building and talks about, it says this would produce building heights ranging from the mid-20 to low 30 stories,
Yeah.
including penthouse floors on the remaining development sites, but those are those
This-
small development sites, which are really little islands,
Yeah.
right?
I would also say this building has 35 residential floors. It has these large mechanical spaces. It is within, you could even argue, and I think this is a good argument, that it's within the range of what city planning was predicting. 35, 34, 33. I mean, is that what we're going to base a decision on? I don't think so. The real issue here, I think, as I said at the end, is the 176 feet, or total of 196 feet of mechanical space, which is legal.
And I just want to, I'm reading some of the provisions where the word stories show up. The prior regulations only provided for a maximum tower coverage, not a minimum tower coverage. So among the many things that they were doing was making sure that at least the tower takes up a certain amount of space on the zoning lot, proportionate to the size of the zoning lot, right? So most of the time 40%, and then it goes down if the zoning lot gets smaller, right? So they were looking at tower coverage as the main control, it seems, of keeping the height down. So there were two controls at play, tower and packing, which were both introduced as a way to keep the height down. And I think that diagram, which now vanished from the screen, though, is interesting because it shows the efficacy of the tower coverage rule in concert with the packing rule. There's a 4-story difference between those two buildings. So, and I think that's what Mr. Karnofsky stated, that obviously the packing rule had an impact. Had city planning looked at this site, they might have come to a different conclusion in how they worded it, but they didn't look at this site, right? And they may have also assumed that the site was going to be built under, that's what I'm kind of guessing, is that because the site was owned by a community facility, that they were going to be building community facility tower, if anything, and then that diagram that you showed previously would have applied here, right? So, okay. Any other comments, questions? Thank you. All right, so are there any other representatives, legal representatives of any of the parties? Otherwise, we'll move to public testimony.
You want to issue a response?
This should be at the very end, but I'd like to take public testimony. We've been at this for quite some time.
Then I'd like to reserve to respond
Sure.
to his response,
Yeah,
because
sure.
it's a habit here of doing rebuttals and replies without...
Yeah, I know, so that's the other thing, there were still replies for 30 pages and things like that, that's not okay.
So electors from elected.
Yeah, so elected officials, please.
First. Going up there.
Thank you. Where should I leave my copies?
You
You
can
hand
go.
it to Ms. Prenga. Thank you.
Okay, thank you.
Thank you very much. Honorable Chair Perlmutter and honorable members of the board, I'm going to speak from my heart.
State your name, please.
I am Helen Rosenthal. Thank you. And I represent the 6th District in the New York City Council. I'm testifying today in strong support of the application filed by Landmarks West to revoke the building permit for the 50 West 66th Street development granted by the Department of Buildings April 11th, 2019. Just going to start by saying I really understand how it feels to be the little guy, the community, the people in the community here who just want to live in peace without really tall buildings surrounding where they thought they were going to live in an area where the common height was 23 stories. The language, the zoning language is just so complicated. You don't need to hear that from me, and I'll wrap up by talking about a couple of obvious points. But it is just so frustrating to be a common resident. I just want to share that with you. I've sat on your side as a community board chair, but boy, this is truly overwhelming. As I and other local elected officials have pointed out repeatedly, the building permit relies on a flawed interpretation of the zoning resolution. This development simply does not conform with the zoning regulations or intentions of the special Lincoln Square District. In 1993, the City Planning Commission, as we've just discussed, created rules for the special district which essentially limit buildings to their mid-20s and low 30 stories in height by controlling their floor area and footprint. And I'll note that at that time, we did not have the technology that would make it so it is not cost prohibitive to build a 1,000-story building, which is the case now, but wasn't the case then. The rules require that 60% of the building's floor area be located below 150 feet, and each floor above 85 feet occupy a minimum footprint. These two provisions work as intended to restrict height only when they are both applied to the same zoning lot. The developer's decision to apply his tower coverage and bulk distribution calculations inconsistently across a split lot contradicts both the letter and the spirit of the special district regulations and the zoning resolution. It's so frustrating to hear Excel talk about the, what do they call it? The appellate. Sorry, not a lawyer. Master's in public health. To say that they're throwing ideas to see what sticks. They're throwing ideas against a developer that similarly is picking and choosing when and where to apply certain of the zoning district regulations and the zoning resolution. And it raises real questions about the integrity of the land use process overall. Secondly, the city's negotiated settlement with this developer flies in the face of the recently approved zoning text amendment that caps mechanical void spaces at 25 feet and requires voids be no less than 75 feet apart. I hear you're not going to look at that, but again, from the perspective of a layperson, it's pretty remarkable, the timing of reviewing those mechanical void spaces and the timing of this application, leaves us disappointed at how slow the process works for the community. As currently planned, this building will have 239 feet, almost 24 typical stories of vertical void space, 196 feet of which are supposedly intended for mechanical purposes. And in truth, these voids are not used for mechanical equipment at all, nor are they accessory uses to the residential space in the building. And in fact, the fire department had to go back and work with city planning and the DOB and the developer to make sure that the mechanical void spaces would be tolerable for the fire department should they be in a situation when they're running up these floors. again, back to this point that technology has allowed us to build so tall, but it doesn't necessarily mean that it is in the spirit of what the public needs and desires. This continues Extel's pattern of incomplete and inaccurate information. For well over 2 years, my office and the surrounding community has been pushing for transparency about what would be built at the site. And as you know, despite their initial filing plans for a 25-story building, interestingly, at roughly 250 feet, in 2016, the developer sought and has received approval for what his true intention has always been, a 775-foot building, remarkably only 39 stories tall. Fully enforcing the zoning resolution is beyond critical. The public interest is not served when developers selectively follow regulations in a way which undermines their clear purpose. Similarly, the special Lincoln Square District guidelines were specifically created to control building heights. If the city wishes to revisit this public policy goal and eliminate the special district, the public is entitled to a straightforward and thorough discussion. And essentially dismantling the special district through selective permitting decisions is disingenuous at best. By revoking the permit for 50 West 66th Street, the BSA will be taking a strong step toward ensuring the integrity of the land use and development process in New York City. Look, in plain language, even the city planning document itself said it expected that the height here would be no more than mid-20s to low 30 stories. And even if you bastardize what the height is of a story and use mechanical voids, we're not even there. We're at 39 stories. I think we're being a little, I think the developer is being a little flip with what is intended to be law that I believe was meant to ensure that the district around Lincoln Center would be free and clear of 80-story buildings, which is what this is. Thank you very much.
Thank you.
Thank you.
I just want to kind of clarify what the role of the BSA is. I know you're not a lawyer,
Fair.
so that's you know, the part that's difficult for people who aren't, say, land use wonks, like legal wonks. So the BSA's job is actually to, in interpretive appeals, is to review decisions by the Department of Buildings. But for one, it's the Department of City Planning that drafts the zoning regulations based on its studies. And as you know, the City Planning Commission then approves them, and then City Council ultimately is the decider of whether it finally goes forward, right, or it gets modified. So, and then the Department of Buildings is just there to interpret the regulation, right? And when there's a disagreement about how DOB has interpreted the regulation, then it comes to the BSA for us just to essentially run a check. Did they interpret it reasonably? Is it fair? Because we can't legislate. We can't be the ones who say, you know, I mean, we've seen this in several recent cases. We appreciate where the community is coming from about whichever subject, and we appreciate that the zoning resolution probably should have dealt with that issue. But we can't make the zoning resolution deal with that issue. We can only look at whether it's handling it now, and if it's not handling it, then it's for city planning to handle it. So in the subject of the mechanical voids, obviously, city planning realized that there is this, excuse the pun, but void in the zoning resolution that was allowing something it could never have anticipated happening when it wrote the regulations, right? So there's that part of it, and so I do want to say that a lot of this is about what we interpret, what we view Department of Buildings' job is and whether the Department of Buildings has done the correct job. And then if there's a problem and city planning is directed to address the problem, then it should be dealing with that in legislation. So that's part of it.
I really, with all due respect, I appreciate that. And we all know, as residents, that at the end of the day, that's what's going to happen. We're very well aware. What I'm doing is reminding the BSA that for 3 years, we've been trying every angle possible to our ability to deal with really fundamentally a disingenuous developer. We wrote op-eds, we pushed hard for DOB to re-look at the paperwork. We sued at every level, and here we are at the end, and of course you're right. So why are we all standing here if it's futile? Couple of things. One is that it's critical for the public. There are a couple of reasons. One is to reiterate the injustice of it. Simply that. You know, in the 30s, 40s, and I apologize that I'm sure I will be attacked for this. But you know, when black people tried to vote, they were first told they had to learn how to sign their name, right? When they learned how to sign their name, all of a sudden the criteria changed. You have to be able to count the number of marbles in this jar. From the perspective of a constituent, of a resident, someone who lives here, it's like the criteria is always changing. And even when you meet the criteria, the rules have already, it was the rules, the void, mechanical voids, that was changed last month, not in time. And, it's exactly why all these rules, arcane rules that are set up, are exactly why so many people are held back. It's why there are only 12 women in the New York City Council out of 51. And it's why the poor and less educated people will always be at the mercy of the 0.001%. And I'm here reiterating that for the last 3 years as a community, we have fought really hard. We have tried every avenue. We've tried to close a loophole. Now it turns out we closed it too late. It's really frustrating. So, it's the best I got.
Thanks very much.
Thank you.
Any other elected officials?
Thank you very much. I am Gail Brewer, Manhattan Borough President, and I hope that I don't fall into the same trap. But I will say that little unknown fact, Department of Buildings and City Planning Commission don't always talk. So that's a problem that you can't solve, but it is a big one. So I am here to oppose the construction of this project at 50 West 66th Street as designed. Much has been reported about the unprecedented height of the mechanical floor. Some call it a mechanical void. On May 29, 2019, as you know, the City Council approved an amendment to the zoning resolution to address mechanical voids. That amendment may affect this project, as you know. In addition, the FDNY raised safety concerns about the developer's initial 160-foot mechanical floor. The developer addressed these concerns in part by subdividing that mechanical portion of the building into 3 contiguous floors. Those floors are still too tall. In fact, at a collective 176 feet, they are 16 feet taller than the original mechanical floor. However, leaving aside the mechanical void text amendment and the measures the developer took to address the fire department's concerns, this proposed building raises specific critical zoning issues. First, there is a question about whether or not this space is truly being used for mechanical equipment. In total, the proposed mechanical floors in this tower will add up to 229 feet, nearly 1/3 of the building's overall height. I've yet to hear of a building that needs that much mechanical equipment. What will likely be Above the mechanical equipment on these floors is a great deal of empty space, a void. This empty space does not adhere to section 12-10 of the zoning resolution. Second, the tower coverage and bulk packing rules are established by sections 82-36 and 82-34 of the zoning resolution, the ZR. The area of this building occupies 2 zoning districts. The developer has chosen to use a larger portion of the merged zoning lot to pack more floor area at the base of the tower. Tower itself is configured to rise on a smaller portion of the lot, enabling the developer to pack more FAR at the top of a narrow envelope of excessive height. The tower coverage and bulk packing rules were enacted specifically to ensure predictable contextual building heights. The developer's incorrect interpretation, in my opinion, of these zoning requirements has resulted in a significantly taller building than would otherwise have been allowed. The developer needs to follow both the letter and the spirit of the law and apply it to the entire lot area as intended by the zoning. By any reasonable measure, I think, the empty half shell that forms the core of the tower is subterfuge. It is not a mechanical void as defined by the code, and the BSA should not allow it to become a precedent, I think. We cannot permit the construction of developments that evade the intent of the zoning resolution. The developer needs to follow the rules. The BSA must rule that tower coverage, I think, bulk packing, and the design of mechanical space must conform to existing rules before projects are approved. Thank you very much.
Thank you. Any other elected? Any other elected officials?
I have someone
Yes.
from Linda Rosenthal.
Or representing your elected official?
Hi, my name is Caitlin Lettery. I'm here representing Assembly Member Linda Rosenthal, so I'll be reading her testimony. I'm Assembly Member Linda B. Rosenthal, and I represent the Upper West Side and Hell's Kitchen in the New York State Assembly. As a long-time opponent of overdevelopment and an outspoken critic of zoning lot mergers that have heretofore allowed the construction at 200 Amsterdam Avenue to continue in my district, and the author of state legislation to close the mechanical void loophole, I strongly urge the New York Board of Standards and Appeals to appeal NYC DOB Excel proposal at 36 West 66th Street. Excel has reserved an astounding and excessive 161 feet of inter-building space for mechanical infrastructure. Knowing that mechanical void space is not counting toward total building floor area ratio, Excel is attempting to circumvent the letter of the law to stretch the building height so that units above the void will have better access to better views and thereby fetch higher prices on the market. Earlier this year, the City Council passed a local law to clarify the law on void space and set clear limits on the amount of space within a building that can be used before counting toward FAR. While I and more than 30 of my colleagues in the state legislature who represent parts of New York City do not believe the council effort went far enough, the effort did clarify the intent of local lawmakers to circumscribe this kind of development. BSA cannot allow plans for development so contrary to the spirit of the zoning resolution to move forward. Doing so would signal the developers that they could calculatedly flout zoning rules so long as the plans are filed within a certain timeline. As if that weren't enough to add 160 additional feet of empty space to a building, Excel also proposed to use a series of other developers' tricks to do an end run around zoning rules. The zoning lot merger that Excel utilizes to cobble together development rights, enabling it to achieve its current 775-foot height, violates the rules of the Lincoln Square Special District, which limits building height to approximately 30 stories by controlling FAR. By merging zoning lots and selectively applying the special district rules to different lots, Excel is constructing a building much taller than what would have been permitted if it had followed the rules of the special district. In addition to the obvious developer overreach, this building represents the kind of short-sighted urban planning that New York City must abandon. The zoning rules are not in place, are not just in place to protect our access to light and air, two precious commodities in the concrete jungle, but also to ensure that all development is contextual. A 775-foot tower may make sense for Midtown, but not for the middle of a much more residential Upper West Side. Development of this scale will have a tremendous and unplanned for impacts on local infrastructure such as local schools, transportation, supermarkets, and sidewalks, just to name a few. Rubber stamping the plans for this development now doesn't just allow construction at the site to move forward, it broadcasts to developers citywide that BSA is weak and when challenged will stand with developers who have violated the letter and spirit of the law and not the people in the communities it should serve. All across the city, people are rising up against the kind of system of broken government where wealthy and well-connected continue to chart their path like manifest destiny, while the rest of us are left holding the bag full of consequences. New York City has been struggling through an affordable housing crisis that has left more than 60,000 people and so many children living on the streets every single night, while thousands of others struggle to pay rent and put food on the table. And despite these grim statistics, we are here fighting to stop a building with 16 stories of empty space. This space could be used to provide homes to the hardworking New Yorkers, but instead it's being used so the residents on the top floors can literally look down on the rest of us from penthouses in the clouds. There are a few dichotomies that more clearly and sadly embody the Tale of Two Cities narrative that City Hall has sworn to fight against. I thank you again for the opportunity to testify and again renew my request that the BSA reject this proposal at 36 West 66th Street.
Thank you. Please refrain from clapping, please. It'll take a long time. The next speaker, please.
I think they're done with elected.
Yeah, I think we're done.
So
So,
if there are members of the public who wish to testify on these applications?
Yeah, well, I have the sign-in sheet. Should I read from the sign-in sheet?
We're at almost hour 3. Can we just like start lining up and talking?
Okay, just state your name.
Yeah, state your name before you start taking. You have 3 minutes.
and sorry, could people who want to speak line up on the ramp so that we can move
just
this
keep
along? You have 3 minutes.
Good afternoon. My name is Arlene Simon. I am one of the appellants in the City Club lawsuit. I'd like to just deviate from my statement a little. I will deviate from my statement for just a moment, amazed that I stand before you, looking back and remembering Landmark West's hard-fought battle almost 30 years ago. Nothing has changed. I have lived on the Upper West Side of Manhattan since 1960 and since 1969 on West 67th Street, 1 block away from the Extell project. I founded Landmark West in 1985 to preserve endangered landmarks and to protect a treasured neighborhood from inappropriate overdevelopment. The Upper West Side is a vibrant, diverse, human-scale community. I was president of Landmark West from 1985 to 2016. In that capacity, in 1992-93, we fought to block construction of the Millennium Tower, a 545-foot tower on Broadway and 67th Street, a block and a half from the Extell Tower. We work with other civic organizations, including the Municipal Art Society, in the fight to amend the zoning resolution to prevent similar outsized towers in the future. And then, Borough President Ruth Messenger stated in her report on the zoning amendments, Landmark West funded Michael Kortler's New School Environmental Simulation Center's work with the Department of City Planning. That work created the simulation of minimum tower coverage and bulk packing. That work resulted in the towers on base rules at issue in this case. Let me emphasize, again, it was understood by everyone involved in the process at the time, everyone, that the new rules would limit building height to the low 30 stories as stated in the City Planning Commission's own report. Landmark West and the other civics advocated strongly for an absolute height limit. But City Planning
If you could
assured
wrap
us.
up, your 3 minutes are up.
If you could wrap
Please
up your comments.
You can submit your comments to the desk and we will read them, but your 3 minutes are up.
I'm sorry?
Your 3 minutes are up. You can
Well, I'm
submit
only-
your comments.
Okay, I'm just almost finished, but City Planning assured us that the new rules would work just as well. One look at the city skyline today and Excel's plans shows that we were right and City Planning was wrong.
Ms. Simon,
A few more words
please.
and that's it. But
Okay.
beyond that, neither we nor anyone else anticipated the shenanigans that Excel is pulling here. The building is not human scale. As a matter of law, common sense, and a decent regard for our culture and future, it should not be built.
Thank you for your comments. Next speaker, please. Please refrain from clapping. We're trying to keep the hearing moving. You can snap, but please don't clap. Thank you.
Good afternoon. Thank you very much for this opportunity. I'm here today.
State your name,
although
please.
I'm Paige Cowley, an architect and also chair of the wonderful organization I inherited through the Simons, representing CB7. I'm hoping my 3 minutes starts now.
Wait, so what organization? Sorry, chair of?
Landmark West, but today I'm reading a statement relating to Community Board 7. We've been looking at this also for 3 years, so my 3 minutes, I hope, will start now. We have on many occasions over the last 3 years generated various resolutions about this project. We've noted that the proposed tower would generate oversized shadows into Central Park, would be dramatically out of character with the existing cityscape. We also noted the excessive height of the proposed tower provided no compensating benefits in terms of increased housing stock, as most excessive height would be consisting of voids. We've read the brief by Klein Slowick for Landmark West opposing the tower and are in full agreement. And very quickly, 2 important facts. 1, provisions of the zoning resolution governing bulk packing and tower coverage were enacted in response to the then anomalous Millennium 1 building. I won't mention that in greater detail. The clear and express intent of these rules was to require at least 60% of the floor area in R10 or R9 zone in the Lincoln Square Special District. I disagree with Mr. Karnofsky here with all the diagrams. To be honest, it's chicken soup, alphabet soup there in trying to determine what is practical. You can make any of these calculations comply if you study them hard enough and bend the rules. These requirements were obviously intended to restrict building heights. On to point number 2, and again, I have the full text for your review. In addition to perverting the bulk packing and tower coverage rules, the developer has achieved much of the height of its proposed building by the simple expedient of creating 196 vertical feet of essentially voids. Obviously, these spaces do not contribute, and again, I won't belabor that. You've heard enough, and you will hear more. It is our understanding that every structure in the city must comply with the use group regulations contained in the zoning resolution. The only uses permitted in the tower portion of an R10 structure are residential or accessory to residential. There is no use group designated as void. That's really important. This is something that we hadn't anticipated years ago when the writers of the code had anticipated technology, voids, view corridors, money, or where we would be. But now the world has changed, and now we're told that we need to accept this and not listen to the public who live in these neighborhoods. Lastly, while necessary space for mechanical equipment is clearly accessory, unnecessary height of these spaces is not. From the standpoint of the surrounding community, these voids constitute waste whose only function is to reduce light, air, and create an eyesore. We respectfully urge the Board of Standards and Appeals to disallow a building permit for 36 West 66 unless the developer submits plans that conforms to the zoning resolution and actually addresses some of the concerns of the community, so these types of buildings can be curbed. Thank you.
Thank you. Next speaker, please.
Good afternoon. I'm Michael Harwain, an Upper West Side resident and head of the Real Estate Committee for Congregation Habonim, an 80-year-old treasure of our neighborhood. I'm here to make sure you're aware that there are many residents of our neighborhood who are not only in favor of this building, but are counting on it being built in a timely way. Thank you for this opportunity to testify with regard to the appeals pending before you. I urge the BSA to help us protect our only option for a new permanent home for our synagogue and nursery school by allowing construction of 50 West 66th Street to proceed as currently planned. Please do not allow the appeals to stop this development and thereby prevent us from returning to our home on 66th Street. Congregation Habonim is currently in a temporary location that cannot accommodate our needs, is draining our resources, and is not a long-term solution. We've invested significant time and resources to advance plans for a new permanent home in a condo unit that we will own on the ground floor, basement, and outdoor space of the as-of-right building currently being constructed at 50 West 66th Street. I've been working on the plans for our new home for 7 years with other members of our community and outside professionals hired by Habonim. Our plans include a beautiful new synagogue with a large sanctuary and smaller chapel, a school with 7 new classrooms for preschool and school-aged children and adult education, and a programming and event space, all of which will serve the Upper West Side. If construction on this site is not allowed to proceed, our congregation will be irreparably harmed, and we will be left with no alternative for a permanent home on the Upper West Side. I'd also like to specifically address some comments we've heard from those who believe we should just hope that the developer of 50 West 66th Street will revert to its obsolete plans for a 25-story building on part of the current site. The simple fact is that this is not a feasible outcome. We've been following this story closely. The developer originally owned a smaller piece of land on West 66th Street and filed plans for a building appropriate for that site in 2015. But in November 2017, the developer acquired the adjacent Guild for the Blind building on 65th Street, doubling the size of the land, and the developer then amended its plan to a larger building designed for this larger site. An enormous amount of design and construction work has been done for this larger building, which is as of right, and Congregation Habonim has invested significant resources planning for its new home in reliance on the city's approvals of this building. We can't just wish for a smaller building that will never be built. That is not a solution for our congregation, and will only put our very existence in jeopardy. What we can do is ask the BSA to respect the well-considered decision of the DOB for 50 West 66th Street and allow this project to proceed as currently planned. This is the only option that will enable Habonim to build our beautiful new home and continue serving hundreds of families on the Upper West Side. Thank you.
Thank you.
Can you please come and sign in? Thank you. Oh, you did?
Next speaker, please.
Good afternoon. I am Elaine Whitcoff, an Upper West Side resident for 26 years and a member of Congregation Habonim, the synagogue founded in 1939 by Jewish refugees from Nazi Germany exactly 1 year after Kristallnacht, the night of broken glass, where Jewish homes and stores were ransacked, synagogues were burned, and Jewish men were arrested. I was the president of Habonim when we began the difficult search for a new home 7 years ago. We were in dire financial straits in a crumbling building built in the late 1950s that we had outgrown. Today, we stand ready to make a positive addition to the Upper West Side by building a brand-new synagogue and school on the ground floor of the building under construction at 50 West 66th Street. Thank you for this opportunity to testify. I am here to make the BSA aware of a serious potential consequence of the current appeals, should they be granted and the building permit revoked. We're not involved with the development of this building, but our future depends on its continued construction. If the DOB approval of the project at 50 West 66th Street is invalidated, Congregation Habonim will lose our only viable option for a permanent home. We urge the BSA to help us save our synagogue by allowing 50 West 66th Street to continue construction as approved by the DOB and proceed as currently planned. Congregation Habonim is an egalitarian, conservative synagogue serving hundreds of families. Our religious school and nursery school have educated thousands of Upper West Side children. Congregation Habonim is currently in a temporary rental location that just simply cannot accommodate our needs. This year, we turned away 18 nursery school families, nearly one-third of our enrollment, whom we cannot accommodate. However, we will be able to serve these families in our new home at 50 West 66th Street. We have invested 7 years and significant resources in our dream for a new permanent home, and if this project is stopped, we have nowhere to go. Using this appeals process to stop construction of 50 West 66th Street now puts the future of our congregation in serious jeopardy. We were distressed to see that these appeals could be used to halt the current plan for 50 West 66th Street, where an enormous amount of design and construction work has already been done. Indeed, in our current lobby, we have beautiful renderings of our future home on display to buoy our members' hopes about our wonderful future. If construction is not allowed to proceed, our congregation will be left with no other feasible option for a permanent home on the Upper West Side. Without Congregation Habonim, our neighborhood would lose its only conservative synagogue. We do not want to become collateral damage in the current appeal process. We ask you to please save our beloved synagogue by respecting the careful review this project underwent at the DOB and allowing this project to proceed as currently planned, thus enabling Congregation Habonim to build our beautiful new home and continue serving hundreds of Upper West Side families.
Thank you. Thank you. Next speaker, please.
Good afternoon. My name is Michael Gruen. I'm the president of the City Club of New York, one of the appellants. I have very little to say. I want to acknowledge and thank our very fine attorneys for the excellent work that they've done on this, and express our total agreement with their position. Second, I was somewhat surprised to hear in the course of the hearing, not only from parties, but from some of the members of the board, that there is a rule that requires, in the case of ambiguity or uncertainty about the meaning of a statute, requires that it be interpreted in favor of the owner. I won't express an opinion on that now, but I do want to express my gratitude for the board's offer of an opportunity to respond to that and other issues in the next near term. Thank you very much.
Thank you. I just want to clarify that point. It's construed in favor of the owner where there's a tie on the two sides of the interpretation, not where there's a kind of an absurd reading versus a reasonable reading, okay? Where it's a tie.
Thank you.
Can you please
Thanks.
sign in, sir?
Next speaker, please.
Please sign in.
Hello, my name is William Raudenbush. I'm the Vice President of CFESD, which is the Committee for Environmentally Sound Development. We are the appellant on the 200 Amsterdam case. And I wanted to illuminate mainly to the public and support our City Councilperson Helen Rosenthal in what she said is a frustrating process, and illuminate to you why this is such a frustrating process and what's going on behind the scenes that make it such a frustrating process. Under the guise of the LLC that's currently developing this project, extensive lobbying was done. And it was done-
Please address the board and not the...
It was done, and extensive lobbying was done. It was done about mechanical voids and the process of city planning, which this may ultimately come to. Now, wrap your heads around this. 10 members of the Department of Buildings and 8 members of FDNY were lobbied extensively during this entire process. FDNY, our bravest, that lobbied about the possible safety of these mechanical void issues, and I couldn't find a single fire engineer in the entire country, and I called several, that could justify putting an auditorium, empty-sized, empty space below a bunch of residences high up in a tower. Now, I understand that's not before this board, but frankly, the amounts of lobbying, the amounts of access that the developers have, that members of the public do not have to the agencies, is a complete ethical outrage. We need to raise these standards, and to the developers, I have to tell you, if you thought the rent laws hurt up in Albany, just wait till this kind of thing reaches Albany, because it's going to be a lot worse, than it could if we just simply step back and have good faith on the kinds of decisions we make and how take both sides evenly and equally. Thank you very much for your time.
Thank you.
Thank you.
Next speaker, please.
Please.
Go ahead.
Good afternoon. My name is Mark Diller, and I'm sorry to take a moment to tell you who I'm not before I tell you who I am. I am a member of Community Board 7, and I am also a member of the New York City Civic Engagement Commission, but I'm here solely on my own capacity today, so please don't hold anything I say against either of those two wonderful bodies. And I'm here in another attempt to invoke the community interest and perhaps to give a mechanism for that to be implemented. Ambiguity should be evaluated in context, and I understand that one of the issues before you is whether a statute that may appear to be clear is in fact ambiguous in the context in which it is being applied. I understand the admonition that Chair Perlmutter voiced before, that the courts look to the BSA and say, if I'm quoting you correctly, come on BSA, what were you thinking? I suggest to you that that same standard should be applied in evaluating the word ambiguity when approached by the context of what the community will say when the decision is rendered, whether this is a sensible application of the law. And if the standard is ambiguity, then any good lawyer that I know can find a way to make sure that that word means what we all think it means, and that shorn of embellishment and the absurdity of a result that produces a building that, because of the way in which the zoning resolution was written 50, 60 years ago, could not have anticipated the way in which it is being applied today, should be the vehicle for finding that ambiguity that allows us to open this up and say, is this what the folks really meant when they talked about stories, because they didn't have in mind the technology that today creates opportunities that were not in the contemplation. I'll leave it there. I think that that is the vehicle by which a just result for the community, so that the community doesn't turn to you all and to us in the community board and to those in between and say, what were you thinking? Thank you very much.
Thank you.
Hi, Chris Giordano, West 64th through 67th Streets Block Association. Thank you, Chair Perlmutter and Board, for hearing our community's concerns, giving us an opportunity to share this with you. So in 1992, I moved next door to the Jewish Guild for the Blind, which was a great institution that served not just our neighborhood, but the entire city. Now I live next door to a construction site. In 1993, the Lincoln Square Special District Zoning Resolution was established. And as we've heard repeatedly, at that time, city planning stated the controls in place should predictably regulate the heights of new development, and that these controls would sufficiently regulate the resulting building form and scale, even in the case of development involving zoning lot mergers. While we find Extel's mid-block development, a 775-foot tower twice the height of surrounding buildings with about 240 feet of void space and only 127 apartments, anything but predictable, we do find it ironic that Extel's lawyer was part of the city planning team that established the framework and controls for predictable and reliable development when the special district was created. We have asked the question, what is the benefit to the community? Why should the special district zoning resolution be set aside for this development? Even city planning called it egregious and obscene when we met with them last September. And yet our experience has been that the Department of Buildings will stamp a ZD1 regardless of an existing zoning resolution or loopholes or fire safety concerns, leaving the community in the dark, trying to defend interests it thought it had already defended. Further to the benefit of the community question, even though it's been this administration's expressed intent, we see no integrated planning, no housing affordability, no financial benefits, negative environmental impacts and safety concerns, land use reviews that were too little, too late, and a lack of adherence to the data. But ultimately, we've heard a lot of lawyers talking about zoning. I'm not a lawyer, I'm not a zoning expert, but as a member of the community, ultimately we see this as a moral issue. We don't want to be judged by history as a society that allowed buildings to be built by exploiting rules and bringing no value to the community that they sit in. Thank you.
Thank you. Next speaker, please refrain from clapping. Oh, they could, she said you could snap, I'm sorry.
Hi, my name is Stacy Shube. I live down here at the South Street Seaport and am a member of Seaport Preservation with a bit of a cautionary tale. I've lived here in the historic South Street Seaport for over 20 years, and every day I'm watching as developers are buying, stealing my sky, my light, and the history of my neighborhood. Fulton Street's a perfect example and a warning. Fulton Street was supposed to have been wider than it actually is. It was never widened, but they're sticking with the regulations for what should have been. So now that they've started with tall towers, there's a precedent. The horse has left the gate, so to speak, and they continue to get taller and taller. At this point, if I wanted to see the sky, I would practically have to lie on my back and look straight up. To see the impact of an XL tower, I ask you to walk through Chinatown, Little Italy, or the historic South Street Seaport as it looms over everything. With its very privileged residents, it casts large shadows on the Section 8 housing below. It's only 50% to capacity, largely inhabited with people who only live here part-time, many of whom are foreign nationals looking for an investment and a view. They don't send their kids to our schools, and they don't contribute to the community. These outside buildings replace, at their base, the local mom-and-pop businesses that keep the neighborhoods affordable and safe. Where everyone knows everyone, the tailor, the bodega, keep an eye on our neighborhood kids, are being replaced by big box stores, chains, or enormous vacuous lobbies. Affordable housing is lip service. I've observed a few low-income units being added to these buildings while the rents and the remaining housing stock skyrockets, forcing low-income people to leave. The fact that they're destroying the historic South Street Seaport and our enjoyment from the street of our beloved Brooklyn Bridge and our waterfront, as evidenced by recently Howard Hughes Corporation shuttering Pier 17 to the public for a private event on 4th of July in violation of the ULIP. To think that they'll be killing the history down here, the birth of New York City, and replacing it with purely high-end entertainment, even renaming it the trendy Seaport District, is depressing and frustrating. But to see that they will now be doing this to a national treasure, the living, breathing Central Park, is unconscionable. And if I'm not mistaken, although you mentioned this isn't your role, don't quote me, but I believe the judge in the Two Bridges case granted a stay, saying just because something is allowed to be built doesn't mean that it should.
We're not a court, by the way, just letting you know.
Next speaker, please.
Excuse me, can you come sign in?
Good day, Chair Perlmutter and Commissioners. I'm Blair Walsh, speaking on behalf of the New York Landmarks Conservancy. For nearly 5 decades, the Conservancy has been dedicated to preserving, revitalizing, and reusing New York's buildings and neighborhoods. The current proposal for a 775-foot tower at 36 West 66th Street would set a reckless precedent, and we ask you to support the challenges to its building permit. The Department of City Planning established amendments to the Special Lincoln Square District in 1993 exactly to address out-of-scale buildings in this area. The amendments include measures that spread bulk across a lot and defined a range of tower coverage. Used in tandem, they maintain existing scale. The proposal for 36 West 66th Street delinks those rules to push bulk into one small part of the site. Then it doubles down with a 160-foot tall mechanical void that appears to exist primarily to boost the building's height. This maneuver was so egregious, it inspired the Department of City Planning to amend the zoning resolution earlier this year and set limits on voids. Skyscrapers are part of New York's character and heritage, but their owners need to follow the same rules as everyone else. The zoning resolution is supposed to create predictability for all New Yorkers, and blatant attempts to manipulate the system should not be rewarded. We urge the BSA to support appeals from Landmarks West and the City Club of New York, which challenge the validity of the building permit for 36 West 66th Street. Thank you for the opportunity to present the Conservancy's views.
Thank you.
Next speaker, please.
Good afternoon, Commissioner. Sean Corsandi for Landmark West. And Landmark West is grateful to finally be able to address this development issue in a public forum. For the first time, neighbors, advocates, the community board, and electeds who have remained completely shut out of a behind-the-scenes whodunit, as of right, none of your business while they dominate your neighborhood development, will, after more than 4 years in at least one bait-and-switch placeholder building, for the first time, have an opportunity to be heard and considered by a deciding public agency. Should this be at the BSA? Likely not. City Planning, the agency, has said they are, quote, not happy about it, referring to the site as obscene, has otherwise been silent. We look to their minutes and discussions preceding the 1993 revisions of the special district and the resulting text which calls for, quote, producing building heights ranging from the mid-20 to low 30 stories. Given the language, one is then hard-pressed to imagine they didn't expect to see buildings with heights ranging in excess of that limit. Yet today we're here discussing a building 3 times as tall, where 239 cumulative feet of vertical rise, 30% of its proposed height, is sheer void. We're discussing a building in part on a specific site that DCP considered. Development Site 6, the ABC assemblage, is more than half of the C47 footprint. But DCP still never imagined it would metastasize into something like what is before you. Zoning is meant to be a limit, one that provides a sense of predictability to the neighbors and the community. It's set forth to protect the public in the case such as this, specifically those 400 or more families in contiguous apartments from an out-of-scale neighbor. The current iteration of 36 West 66th Street is a building that is a merger of more than 5 zoning lots for 127 units. This is a far cry from the 261-foot tall, 25-foot story structure initially filed, when they complied with the Lincoln Square Special District requirements. After repeated amendments and filing of a wholly different building bring us before you today. We're requesting you look at the facts. Is the split zoning lot properly applied? No. Is the bulk distribution applied as intended? No. Is the mechanical space justified? No. Then why does this unwarranted development continue as of right? Why is it exempt from the zoning that governs the rest of the neighborhood? And most importantly, when can the public have their right to protections as afforded to them by the zoning resolution? This project is egregious on so many levels, and we ask that you revoke their permits in favor of compliant design which follows zoning. Thank you for your time.
Thank you.
Next speaker, please.
Thank you.
Good afternoon. My name is Josette Amato, and I'm speaking on behalf of the West End Preservation Society. I come before you today in support of our colleagues and all challenging the approval for this building as proposed. Originally, the DOB approved plans for a much smaller building. With an acquisition of another lot, a heap of air rights, and some fanciful interpretations of regulation, the scope jumped dramatically to the 775-foot building we are now facing. The DOB was prepared to revoke the permit earlier this year when confronted with the fact that a 161-foot mechanical void was both dangerous and unconscionable. My words, not theirs. A revision was forthcoming, but oversized void space still remains. The sole purpose of this is to increase height to obtain top dollars for top floors. While it may be legal, it doesn't make it right. As we have heard, the site conflates different zoning districts into one enormous lot. Here, the development is picking which rules apply to different sections within the same proposed building. This cannot possibly be a correct interpretation of the zoning regulations. You don't have to be an expert to see that the proposed building, as lovely as its renderings may be, is totally out of context for this mid-block Upper West Side neighborhood. It sits on the doorstep of a historic district and will literally tower over its surroundings. It will throw shade everywhere, including Central Park, which should concern us all. We ask you to find the Department of Buildings was in error when they approved these amended plans. We ask you find this does not adhere to the zoning regulations for this area. And finally, we ask that exploiting the system should not be rewarded. Thank you for considering our comments.
Thank you. Next speaker, please.
Thank you, Madam Chair. Howard Euro, a concerned member of the species Homo sapiens. In short, times change in nature and in life, and human consciousness changes with times. In the good old days, New York was the leader in the development of the skyscraper. When the Flatiron Building was built and the Empire State Building and Chrysler and all the rest, we were not aware that human activity was bringing upon us a global climate crisis. Now we are. And I think that that makes all the difference in this discussion specifically and in all similar discussions. I'm advocating an immediate moratorium on the construction of all mega towers, or whatever you want to term I might call them monster towers, but super towers and so on, until such time as we can sort out how they fit in or do not fit in to the global climate crisis which is upon us. And I think that New York, which was the leader in the development of the skyscraper, and rightly so in its day, should now become the world leader in the development of the moratorium on the super tall building, again, until such time as we have figured out globally what to do about construction in light of our consciousness of the global climate crisis which we have brought upon ourselves and upon the planet. Thank you.
Thank you. Next speaker, please.
I'm Lynn Ellsworth with Human Scale NYC. I'm an economist. I tend to look at these things from a less than legal point of view, which may not be of great interest to you all. But I'll start by saying that in 1999, the then chair of the CPC, Joe Rose, described a race to the top to capture views. And he said that zoning has become neither predictable nor comprehensible. It has become discredited in the eyes of the public. And he said that height limits are clearly needed, and that our zoning promotes an architectural vision that does violence to our urban fabric. Not much has changed since he wrote that, and in the case at hand, the violence and the wrongs and the damages have several parts. First, there is a fiscal wrong in the seizure of the public sky dome for private gain. Both right and left-wing economists agree on this. Neoclassical economists like myself would call it an uncompensated seizure of the public commons for unproductive economic rents. Karl Marx would have described it as an act of primitive accumulation of a natural asset. Either way, it's the same thing and not a good thing. Second, there is the intergenerational damage to Central Park and all the residents of the city through the excessive shadowing of the public realm. Economists have a hard time assigning a price to this damage, but suffice to say that our best estimates is that it far outweighs the billions that Gary Barnett will earn in profits should this building rise. Third, there is the damage to all the people who have had to raise the funds to pay for lawyering to counter the convoluted and absurd arguments that make up the claims of the developers' attorneys. Fourth, there is the damage to our municipal democracy when the developer hires a former legal counsel to DCP to represent him. And fifth, there is damage to the broader economy when huge amounts of international investment capital are wasted on unproductive things such as luxury second homes for international oligarchs, which we know is those are the people who buy these units. The solution to all of this is time-honored and even ancient. Even the Mishnah Bava Kama says that if a man was splitting wood in the private domain and injured anyone in the public domain, he is liable for damages. Such is the case here. Thank you.
Thank you. Next speaker, please.
Are there any other speakers? No other speakers? Okay. All right then, so a very, very short, yes, response.
You want to take a break first?
No, we'll take the break after.
To encourage this to be short.
Yes.
Okay, well, first of all, I was thinking, a little slow on the uptake, but I was thinking about what you said about the poor applicant who just looks at the zoning resolution. And, I agree with Mr. Janes. Maybe he should go to law school and be here instead of me. But that, it's your job to interpret the law. And the owner who comes to DOB, it's DOB's job to tell them, well, maybe you thought it meant that, but here's the rules. So, I don't really see how this example of the naive owner who doesn't know what the rules are. I mean, the zoning resolution is very complex. It's full of ambiguities. And if they can't figure out what the bulk packing rule is supposed to mean, they shouldn't be advising a developer. So,
I just want to correct, I wasn't talking about a naive applicant. I was talking about an educated applicant with zoning counsel and zoning consultants and a very good expediter who knows about zoning, all together reading the text and following the instructions of the text, right? And then
Okay.
going to DOB and having DOB review the drawings, because this was not a self-certified project, right? So
Well,
this was a
no,
DOB review
no, it was not, and in fact, they were very aware of this issue from the very beginning, so, and they took a very aggressive stance, but the zoning resolution is full of ambiguities, and they can be interpreted one way or another. Now, okay. As to Mr. Karnofsky's point that all these provisions in the zoning resolution always say where they apply and so on, I would just point to, I haven't gone through the whole zoning resolution, but just, I mentioned it in my reply statement, section 8222, it's called location of floors occupied by commercial uses. I don't believe it has any, it doesn't state any locational limitations or exclusions. I presume it does not apply in R8 because commercial uses, as I understand it, are not allowed in R8. And there are other instances, I believe, too. But I had they may be in our papers, I believe
Yeah,
they are.
I'm looking it up, we're looking it up now, 8224, right? That's the sign regulations. It says no permitted sign, right? 8224, is that what you said?
No,
Oh, 22.
8222.
Location of
It says
floors.
location of floors
Look.
occupied by commercial use, the provisions of section 32-422.
Which I'll just note refers to C4, C5, and C6. Right.
So that's a specificity, it's an example of specificity. First, it's telling you it's floors occupied by commercial uses, so automatically we don't think about it in the R8 because we don't have any commercial uses, right? It'd be different if it said location of floors.
Absolutely, but here it says bulk packing, we know that only applies to towers, so.
No, actually, we don't know that. That's why I asked, why can't this apply in a height and setback building? And in fact, it can apply in a height and setback building. That's the test that I wanted to see. You know, if, for example, it didn't work in a height and setback building, then that might be something where you say, well, that's confusing because I can't make this work on any of my buildings, but it does work on a height and setback building.
Well, I thought Mr. Karnofsky, if I'm not wrong, was saying that that building had 80% of its bulk below 150 feet, so.
Right, so it means you can get 60% below 150 feet, right? And they were using.
Well, you certainly can, but the rule isn't doing any work in that example.
The rule isn't doing any work.
The bulk packing rule.
Doesn't impact the envelope of the building.
So you can get, I'm not sure that it's correct, so you could give us more information on that, but it's at least complying. It's showing that 60%
It's complying, but the bulk packing rule is not adding anything. It's superfluous in that context.
I thought Mr. Karnofsky showed us a plan where applying the packing of the bulk, the height is what is being built to, as opposed to if the packing of the bulk was not applied to the zoning lot, if the zoning resolution was not revised in 1994, then the tower would be much taller. So there seems to be an effect of the packing of the bulk. So
Well,
I'm not sure I
okay.
understand how you're making the argument that the packing of the bulk is superfluous, because it seems to be working in the way the drafters intended it to be.
In this building or in a hypothetical?
I'm not talking about hypothetical, I'm talking
Oh,
about
in
this
this
building.
building, in
because
this
that's what's
building,
the-
in this building, it has an effect. To the extent that the bulk is in C47, it's limiting what can go in the tower. As George Janes explained, hypothetically, though, if all of the bulk could be placed outside of C47, then the entirety, so to the extent that there is bulk in R8, it is enabling an absurd result. The absurd result is not the absolute height of the building. The absurd result is in the mechanism that works precisely in the opposite way of what's intended, namely to the extent that you have bulk below 150 feet, you are allowing the outside of C47, you're allowing more space in the tower.
Right, no, we understand this point, and I think the point was simply that if there had been no bulk packing rule, the building would have been taller,
This
so it's
building,
having
yes.
an effect. Okay,
Yes.
thank you. Okay. If you want to add anything, please do it in writing. So let's just move on to give Mr. Karnofsky a chance so that we can move on to the rest of our many cases. Yeah, we have, this is case number 2, 1 and 2. No, 1 and 2, it's actually 1 and 2.
There's another appellant.
Yes, I know. I know he's raising his hand.
I have nothing more to say for today, thank you.
Okay, thank you, Mr. Klein.
Notice that, right? Thank you, Madam Chair. I'd just like to address 2 items that Mr. Karnofsky brought up. One is that, one item that he brought up, and one item that I think the board has to consider. He said that the issue of the spatial relationship between the mechanical use and the floors was not brought up before. I would cite page 18 of my May submission, where it says, "Nothing in the owner's public document supports its claim that this space is necessary to house mechanical equipment. The subject mechanical equipment is not described, nor is any technical data about this equipment given to either the DOB or the community, I'm sorry. In its opposition filing, Extel, parent of the owner, remains silent on the nature of the mechanical equipment or its operational characteristics that would clarify its spatial requirements and describe how cavernous volumetric cubic footage is tied to the optimum technical exploitation of the subject equipment." So once again, this is not only defined by height. It was defined in the Sky House case as the spatial relationship between the mechanical space and the surrounding space. But, so I think that was raised. Of a greater concern to me is a safety issue that hasn't been addressed today. And that is, if you remember, the buildings department was waiting to hear back from the fire department as to the safe operation of firemen within these voids. And it came in with a 1-page letter saying it reviewed the changes in the plans and could now agree with them. I find that rather mystifying, just as I find the buildings department's case-by-case analysis of this particular building mystifying, because the fire department had the same information that the buildings department received with regard to this mechanical space, and that was 0. The fire department predicated its decision on absolutely no information supplied by the developer.
Okay, so I just need to ask you, are you asking us to look at whether the fire department did its job and whether we should be reviewing?
No, what I'm doing, what I'm simply saying is that is something that will be dialed into the equation, and I will be speaking to the fire department about it. But I think it's of overarching importance that somebody look at this. It could be the board, it could be me, it could be the building department, but it has to be looked at. But with regard to the mechanical space, once again, everybody has allowed the word height to overprivilege all the other arguments being made, and I think the Sky House case eliminated that from the equation.
Okay, thank you very much. All right. So in turn, Mr. Karnowski.
I want to note that if you look at page 18, it's clear that that discussion is in the context of a volumetric measurement, not a horizontal measurement. So I think it's clear that the issue was not raised. However, you've made clear how this is going to proceed from here on in, so I have no more to say.
Right, so we're just dealing with the one issue, right? It's the bulk packing issue, because mechanical voids are at the moment mechanical voids are off the table. Mechanical space is something that needs to be brought up to DOB for their review, because if they haven't reviewed it, they need to review it, okay? Let's just finish it that way, No, I think we're good here. So what I would like to do is create a briefing schedule. Sure. And I need to limit the length of the papers to 6 pages, not more. I'm sure that you can get your arguments in concisely in 6 pages. And you can have exhibits, but don't use the exhibits as a way to make a 100-page document, please. but 6 pages of writing, all right? And try not to be redundant. We already have the information, the arguments previously made. Okay, so I leave it to council for the briefing schedule. I just want to bring up one last point. I was looking up this is actually an Extell development as well, the famous 99th and 100th Street buildings on Broadway. Those were developed in 2005 when the buildings were in an R8 zoning district. So subsequent to the Tower on the Base regulations, both of those buildings, the one in particular that's on the west side of Broadway, is a 38-story building that is built according to the height factor regulations at the time. And so the building is in fact 38 stories, built after Tower on the Base regulations were created. And so, and I know that the neighborhood had a reaction by changing the zoning in that district, but there you get to predict what happens when you have a large enough zoning lot where it's a very large zoning lot where you can transfer all that excess development right and you get a tall building. So that's something that therefore was predictable under height factor zoning, that you would get tall buildings if the zoning lot was large enough. And so city planning, let's just say, didn't take into account those eventualities if it was really interested in keeping buildings in the low 30s. This was a 38-story building prior to the facts of the mechanical void concept, okay? All right, so briefing schedule. So we should start off with appellants getting...
Well, apart from giving you some cases, I mean, I don't really see a need to write a brief about it. I would send you some cases in response to Mr. Shabetta's.
Well, but don't just send us cases, tell us what they stand for, otherwise we'll just read them and come to our own conclusions.
They basically will be land use cases, if I can find them, standing for the proposition that when you have an absurd result, even if the literal language of the statute is to the contrary, you don't necessarily follow the literal language, that's all.
I think you might also want to specify why this is an absurd result.
Why what?
Why this is an absurd result.
Yeah, you need to clarify why it's an absurd result, but it's more importantly because the proposition is when the language is clear and unambiguous, has the court ever looked behind that, beyond the statute, into the legislative
In a
history?
land use case.
In the land use context, because here we are.
All right,
land
well,
use.
if I find
Okay.
such a case, I will send it to you.
Okay,
I can do it
thank
in
you.
one page, and I
Okay.
can do it, I
How
don't
much
know, but
time?
within a few days, it's not.
Might it make sense for all of the parties to have a single submission date and a single simultaneous reply date? Would that make sense? Mr. Karnowski? If you have nothing
First
to
of
say.
all, Mr. Lobier put in his 31-page reply.
Yes, no,
And
we're
I-
not allowing.
No, I know
Oh, and
I
you
know you're not
haven't
allowing it, but we
responded.
have not responded. So we intend to respond to it, and I don't think we should be limited to 6 pages in responding to 31 pages. So I think we have that reply, and then we can do a 3-page reply to whatever he puts in.
Yeah,
on-
so that's.
I mean, I think that was not right, and I don't think we should suffer the consequences.
How about if we make a compromise, wait, make a compromise, we extend the number of pages to 10, and you concisely respond to the points that you think need responding. And,
I mean, it's normal in every court that, you know,
This
you have
isn't
an
a court,
appellate
Mr.
brief, you
Lobier.
have an opposition and a reply.
No, so for one, it's not a court, and for two, we didn't know either that we were going to be getting on Sunday a 32-page reply, right? So the board has to review these things and has to respond to them, and so, yeah, you were supposed to have just submitted your argument, and the other side submits its argument, and then...
I would suggest that Mr. Lobier can respond to the issues which have been raised. I do not think he should be responding to arguments made today, again, on the same issues of 8234, on statutory history and all of that. We will respond to that. We'll respond to his 32-page brief.
Okay.
I mean, I just did that to accelerate, you know, so it wouldn't have lengthy briefing after.
Okay.
But generally, appellant does have the last.
This was an appeals hearing at the Board of Standards and Appeals. What typically happens is you file your appeal, there are responses, it gets calendared for hearing, that's it. The reply briefs and all of that is what comes out of the hearing process. It's actually not a standard practice here, to have a reply brief, just FYI.
Yeah.
But that lesson haven't been learned. Any objection to simultaneously submitting your response to his reply and him submitting his kind of response to this hearing on the same date, Mr. Karnofsky?
Well, he's going to presumably address new materials that we will not have seen and will not.
Right, but I was proposing that the submissions be simultaneous and then the replies to the first submissions be simultaneous so as to not.
I'm sorry, I've lost you. I'm a little.
So
it's
so
late
in
the
other
day.
words, you both, let's just say for argument's sake, because we don't have a date, we're trying to put you into September because there's a concern about speed,
Yes.
right?
Yes.
So in order to be able to do that, we need a rapid turnaround on the first submission, right? And a rapid turnaround on the second submission, there being a total of 2 submissions.
Rather than ping-ponging back and forth and
Yes.
having 4 or 5.
Right?
Respond to my...
Listen, so everybody submits simultaneously, everyone knows what their arguments are going to be, you've already heard each other, you've already read each other's papers, you respond all at the same time, on the same day to those issues, and then...
Having received each other's
Having
responses.
received, and 2 weeks later, or whatever we
Yeah,
get,
whatever.
you respond simultaneously to those issues, and then it's done, right?
Do we
And no
agree to
sir,
that?
sir replies,
Yeah,
et cetera.
So we could.
I have a lot more to say.
Good, excellent. So you'll be less than 10 pages.
How about if we, so Mr. Karnofsky, understanding you have to reply to Mr. Lobert's reply brief, what if it was 2 weeks for the first submission and then a week for your simultaneous replies? And that way we could put them actually on for September 10th? If,
How much time does that give us?
2 weeks from today.
so 2 weeks from tomorrow, the first set of submissions would be due August 21st, and then any replies would be August 28th, and that'd be 2 weeks in advance of September 10th.
Okay.
So, and then what would happen later?
Sorry, Mr. Lebert.
So it would be submissions in 2 weeks and then for 1 week for reply?
Yes.
Correct.
And then what happens in September?
To the extent there needs to be a reply.
And then we come back, and either the board, do we close the hearing based on this?
We can close.
No. Can we close the hearing? No, we cannot, okay. So then the board either closes, or the board continues the discussion, depending on what we learn from the submission. We don't know what it's going to say, right?
We could close, but...
Then it might open, we won't be able to discuss that, yeah, okay.
So it's possible there could be a decision September 10th? It's possible there won't be.
The dates again?
September 10th.
Okay, well, I will say very little, only because I think it would be best not to have a second hearing.
Well, you have, so, we have to have time to review the materials, right? Okay, so you get the second hearing.
So does everyone have those dates? Mr. Klein, those dates work?
It was the 21st.
The 21st and the 28th.
Thank you.
Mr. Zoltan, any? Okay.
It works? Okay, thank you very much. Thank you, everyone, for coming.
Thank you, everyone,
Appreciate
for
your
coming.
time.
Thank you for snapping. Mr.
This has
Klein?
nothing to do with scheduling. Obviously, I don't agree with regard to whether the mechanical space is right before the board, but all I ask is this, that I will be making an application to the buildings department to review this. The last 5 times I've submitted FOIL requests to the building
Please,
department.
everyone, please.
The last 5 times I brought requests before the building department, I ended up having to bring 78, forcing them to give me the information. So all I would like, if possible, is a letter from the board asking them to expedite their review.
We can provide a letter. I don't know what good it will do, but we're happy to provide a letter.
That's all I
to
ask
Mr.
for.
Klein.
Thank you very much.
Sure, thank you very much. We're going to take a 10-minute recess?
No.
5 minutes?
No, it's got to be 20 minutes. It's lunchtime already, right? Let's resume at 2. How like that?
We're taking a break. We're resuming at 2 with the rest of the morning calendar.
Otherwise, we're... What, an expedite letter? It's not a big deal.
We are back on the record. Continued hearings. Item number 3, 2017-249A. Major Deegan Expressway, and Van Cortlandt, Bronx.
Good afternoon, Madam Chair, Commissioners. Patrick Hilda, Tarkovsky and Drogan. We had submitted our request to the board that this appeal be withdrawn.
Yes, okay, thank you. So for a motion to withdraw?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shabbat?
Thank you very much.
Thank you.
Special order calendar, decision items. Item number 4, 271-13BZ, 129 Norfolk Street, Brooklyn.
Is anyone here for this? No, okay. Anyway, it's, they submitted a letter requesting withdrawal. So for a motion to withdraw?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shabbat? Aye. Case is withdrawn. Continued hearings. Item number 5, 429-29BZ, 4801 Kings Highway, Brooklyn. You must be sworn in.
It's adjournment.
Oh, it's an adjournment.
Yeah.
Good afternoon, Matt Schomer, David F. Hutchins, Citron for the applicant. The only open item was DOT's review of the site plan. We received comments from DOT, and we've been working directly with them, just not quite there yet. So a relatively short adjournment would be preferable.
I guess the earliest would be, October 22nd. Okay, so the earliest available hearing is October 22nd with a submission of October 2nd.
Okay. Thank you.
Thanks.
Item number 6, 509-37BZ, 202-01 Rocky Hill Road, AKA 202-02 47th Avenue, Queens. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yeah, and also the applicant submitted. Yeah.
One thing to hand out. Oh, Elise Fullader from Eric Palatnik, PC. One thing to hand out.
Okay, and I just wanted to state, we got, I don't think he's here today. We got a letter from Mr. Euler from, what is it called? Auburndale
Civic Association.
Yes. Yeah, it's saying that there were no cars stored, that abandoned cars stored on the site anymore, and that he's happy with the kinds of cleanup provisions proposed. And then we also got this letter that you're giving to us now.
And this letter just states that some of the work that needs to be done, we need to get permits for because of the type of work. So therefore, the issue is without a BSA approval, getting permits. So we wanted to ask what we can do, because they said there's no way they can do some of this work, like the fuel oil tank removal and switching the location or fixing the masonry trash enclosure without a BSA approval.
Because...
They said they could do minor things like asphalt or painting.
Okay, so how about we do it like this? As many of the things that can be done, and like, I'd be surprised that they can't do the planting beds without a permit. That's surprising to me, because it's not structural. Or,
like, is there any way to do this on condition, in some kind of condition where we do photographs and a letter of substantial compliance or something?
So part of the problem is we haven't seen this.
Well, yeah, because...
Yeah, you know, so how do we know that you'll come back? That's our
Well,
problem.
can there be some sort of condition to, like, that's what I'm saying, like a letter of substantial compliance where we do come back and we show you photographs?
How do we know that you're going to come back?
I mean...
What will make you come back?
Okay, that's what I'm saying, is there some sort of condition you can put to make us come back?
That's the point, is
Yeah.
we place conditions,
Yeah.
and then 15 years later, when forced to come back because DOB or a bank or something says,
Yeah.
where's your C of O?
Because the whole point of this is we did have a C of O that didn't have an expiration on it from years before, and we're coming back because we amended the site and now we want a C of O. So that's why I'm saying, is there something, like the intention is to get a C of O?
Can I ask a question?
Yeah.
The architect mentioned work related to curb cut, masonry, trash enclosure, fencing, planting,
Yeah.
relocating fuel oil tank.
Yeah.
Are the works, he mentioned those, so I'm assuming these
Yeah.
are the works that would require permit?
Those were the big, on the phone we discussed, and they put in the big, because we did it overnight, they put in the biggest items, because they said probably the asphalt and the painting's okay, but we didn't look into each item, but they said most of the items that were required would need a permit.
Well, so that's, some of this is confusing to me. Certain types of permits, so it's to permit the legalization of a change of use, right? That was your...
Yeah.
But before that, you had an existing gas station was allowed.
Yep.
So you're just talking about a use change from a gas station to an automotive service station, right? And the gas station approval didn't expire, correct?
Yeah.
So I don't understand why any of this work can't be done pursuant to the existing allowable use.
In our discussions, they said that it's not possible, but I can ask them to explain why.
No, so I'm having a lot of trouble. The only way I'm going to believe it is if you
the
submit
examiner
an
comes back.
application under the existing use, the existing approved use, and it's rejected because for some reason that...
Because they said their experience with the examiners, when they go, they say, where's your BSA approval? Well, how can you do this?
No, but you don't need a BSA approval. You've got an existing use group 16 gas station with lubritorium, right? That's what it says on your even CO, right?
Yep.
And so all of this work is appropriate. A trash enclosure, a curb cut, fencing, plantings, fuel oil tank, all of that is related to a gas station.
So I guess we could file for permits, and if we have a problem, we'll just not do the work that we're not allowed, like I could show
Correct.
proof of the work we're not allowed to do.
Correct. So let's do it like that.
I guess that's the best we can do.
Because otherwise, the conditions in a situation like this don't work, that people come back 10 years later, 15 years later, oops, we didn't...
So any work that they have a problem with, I will submit that to the board, proof that they had a problem and they were not allowed to do.
Yes.
I think the key thing is that file it under the current use and
Yeah.
see how much of these permits can be permitted.
That's what...
Yeah, I heard it also just depends who you're working with at DOB sometimes. Like some L2s, no problem, do it, some you need.
But you're not enlarging the building. The building
Yeah.
footprint is remaining the same. You're just making improvements on the site.
Yeah, like-
And all of these improvements of the site, you could do whether it's a gas station or an automotive repair. These are standard, so that's why I'm not sure why.
I'll ask them to try.
Okay.
It'd be different if you didn't have any permission to use this spot for commercial use. But you do. So, go
Have them
ahead.
try.
Go forth. All right. So, therefore, let's give, are there any speakers on this? Let's give a lot of time. So maybe...
End of October?
No, longer because...
And they say once they get permits, it'll only take 6 to 8 weeks, they told me to do.
Right, so how long, will they do this as a self-cert, or they're going to do this as...
I want to get it done as quickly as possible.
Okay, so why don't we put it the end of November? Something like that.
Okay, so that, how about hearing on November 26th, for submission, November 6th?
So let's see, submission November 6th, that means you file right now, arguably permits in mid-September, that's giving you, yeah, that's arguably enough time.
Okay.
Maybe a little more.
Thank you very much.
Okay, thank you.
I'm just going to interrupt for a moment. I was given this watch that was left in the audience. Does this watch belong to someone?
Maybe we can give it to the security at the...
Okay, we'll give it to security.
Okay. Thanks.
Okay. New cases, item number 7, 285-52BZ, 30-14, 34th Avenue, Queens. Do you affirm to tell the truth? Please raise your right hand, all parties that will be speaking. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good afternoon, Faye Baton from Sheldon Loeb LPC for the applicant. We attended yesterday's review session. I'm also joined by John Anderson, the architect, because I know there was a lot of discussion and some questions raised at the review session. I also have, I don't know if anyone needs, because there was comments about the size of the site plan. I have printouts. Would that help through our discussion?
Maybe.
Okay, so I'll hand those out. Just some comments that I could address right now. The sign provisions, we'll go with the C1 district regulation, so those will be revised. As for photographs, there was comments about having the photographs of the rear of the building. I have photos here as well, but the building directly abuts the residential building, so that rear we can't take pictures of, but all the other sides will provide rear pictures.
Right. Okay.
And the statement of facts typo regarding parking, I will fix. So I'm going to pass out this site plan, and John's going to come and answer some of the questions.
You want me to go through the comments that were issued?
Yeah,
Yes.
that's fine. Thank you.
No problem. As far as the lighting diagram, as we understand, there was some confusion as to why there were zeros. Basically, the zeros indicate a lighting illumination on the pavement level. It's a lighting program that we use to show different foot candle ratings. We were showing the illumination levels on the pavement underneath the canopy and also surrounding the building. The zeros that were shown to the rear of the building, basically they're modeled that way because this is a corner lot. There's two buildings on each of the sides that abut our lot, and there's a couple. One's a single-story commercial, one's a multi-story commercial, and basically they block any lighting that would spill over that property line. There is a 30.
So your drawing doesn't show a building going, so wait a second. So you show, does this work? Okay.
There is a.
You're showing, for example, on the, I don't know what side that is, it might be the west side, yeah. On the west side lot line, you're showing like 4.2 level, and I can't read this one. And then it's 0 just on the other side, but you don't have that area on the other side of the property line hatched to indicate there's a building there.
So we will clarify that. There is a slight hatching that shows the way we are denoting an existing building. So we'll clarify that in a future submission. Just to note, there's a commercial building on the northern side. That's a single-story building that's also hatched. There is a 30-foot gap, basically on the property line that is opposite of 34th Street. That 30-foot gap, there's a 4 to 5 foot masonry or brick wall there with a hedgerow or ivy growing up on top. So that was also modeled as a wall that prevents lighting from spilling over. We can re-examine the lighting and make sure we're modeling it correctly. The pole lights, the building lights, they're all very low, and they're LED with sharp cutoffs. So that's why basically all the light is projecting, mainly forward or towards 34th and 31st.
So when you say sharp cutoffs, it means there's a shield?
Well, there's not necessarily a shield, but the photometrics or the lenses within the fixtures, they're meant to project forward and not have any spillover in the back. In addition to that, there's buildings that are abutting our property lines.
Right, okay, so to clarify, then, the extent of the building that abuts, and indicate the height of the building.
Absolutely.
And also, obviously, if there are any windows,
Correct, we can do
we
that.
care about you lighting the windows.
The building abutting 31st Street, does it have a window?
Yeah.
on
It's
that?
a two-story building, and it's the photos that were shown. There are windows that are above our building that's on our property.
So that's part of it too. If your lighting has lumen spread and it's lighting into windows, then there needs to be a shield on it, right?
Correct. And again, any lighting that's along the building is on or facing our property, and it's not above our building. It's just up to the top of the parapet, not to the parapet, I'm sorry, just below the valance of the building. So it's not very high, and it's projecting forward. So we don't think that there's any light that's going to spill over and affect those neighboring properties, but we will clarify that.
So the window is on the second floor?
That's correct.
And you're saying your light is below the height of the second floor?
It's below the height of the top of our building.
Top of the building, okay.
It's mounted about 12 feet
Okay.
on our building base. There are some area pole lights that are out towards the front, and they're only about 12 feet high.
Okay.
And they are shoebox-style LED fixtures that project light downward. We're not anticipating any spillover that's going to illuminate the neighboring buildings.
Okay.
And we're not projecting any uplights either.
I just have a question. It looks as if one of the building light fixtures might be at the height of that window. I don't know if I'm looking at the original site photographs. And I'm looking at the light that's on the roof of your one-story building. Is that a light fixture? That's my question. So it's page 12 of 13 of your site photographs. Oh, no, that's okay. It's,
Those are the pipes, those are the vent pipes, are you referring to?
No, I was looking on top of that. Is that a light fixture? Because it looks like it might be a, if you look at your proposed plan, it says FS 53.21. I don't know if that's a light of
Oh, yeah, I
sort.
see. It looks like a light or a speaker or that thing.
Yeah, it's hard to see. I like expanded it to try and get a better look, but then it just becomes blurry.
Well,
Yeah.
if it is a light, we can definitely remove it from the top of the building. We don't want any floodlights up there if it is. I don't know if it is. I can't tell you if it is or isn't, but if it is a light, we'll definitely remove it. Because it would be right in front of that window, it appears.
Okay, keep going.
Oh, it's actually
The dumpster location, we located the angle of the dumpster to facilitate removal or emptying of the dumpster, of the trash enclosure in the dumpster. We do recognize that the door may swing, and we'll work with Luke Oil on reorienting that dumpster so that it won't affect any parking areas, and we can add some detailing for the dumpster enclosure as well in the next submission.
Okay, so it's more than, so normally we get an enlarged drawing of the dumpster that shows what it's made out of, ideas for it not to be hideous looking, please.
Okay.
And also, yeah, so like, what is that little hatched area that's behind, that's adjacent?
It's just striping. It's a gore area. It's not an area that's going to be, a car can park back there. We were just striping it out, pavement striping.
And why not? So this is part of the question that I had about how you're buffering this use from the residential use?
Well, the residential use, so on our side lot line that's perpendicular to 31st Street, that building it's pretty much a building wall there. There is an existing wall between along the property line that is opposite of 34th Street. That's a 4 or 5 foot brick masonry wall with a chain link fence on top, and it's got ivy growing across it. And I believe that there's some photographs that we just submitted that show.
That's the ivy that belongs to the neighbor, though.
That I don't know. It most likely does. But there is an existing wall there, and we could add screening on that chain link fence. And then the next side yard, which is opposite 31st Street or perpendicular to 34th, there's a commercial building.
Right, okay.
So the building, we're basically saying that the buildings are mostly blocking or providing the screening to the residential uses, and the wall is adding to that.
Well, not really, because when you look at the photograph you provided, all the windows of those little row houses stare right into your property, right? And the photograph that we have here, is that one of the ones that was provided? Doesn't
11
show.
of 13.
Yeah, doesn't show any greenery on that.
There is no.
Right, so there is now? There is, because this is probably a winter shot, maybe? But so, when I look at hatching like this, and I look at the space behind the dumpster and so on, I look at planting opportunities. So why shouldn't it be something where you green the site?
We can add landscaping.
Yeah, okay. And that way, maybe move the dumpster forward a little bit to give you some more landscaping to go behind the dumpster, because it's the other part of it. You're locating the dumpster next to a residential use. It's exactly the wrong place, right? So that's the other question. Like, why can't it be, for example, on the other side? Isn't that a blank wall? That's a commercial space, that's a commercial building on 31st Street, right?
On 34th Street?
On 31,
On 31st.
31st.
I thought it was a residential.
That's residential also?
Yeah.
Does it have,
The building on 34th Street is commercial.
oh, the building on 34th is commercial.
It's a
Okay.
single-story commercial building, yeah.
Right, okay. So then I'm wondering, why can't instead you create, you move the dumpster to be next to parking space 3, and then have a buffer area, so it's not at an angle. And then you have a buffer area of planting between the residential rear yards and the dumpster, because right now you don't have anything.
Okay, we can
Separate.
definitely work on that.
Okay. Okay.
The next comment, site plan, you would like a larger size. We can enlarge the site plan and provide additional detailing. You had noted that there's numerous ramps on the sidewalk near the building. Are you referring to the building surround? The concrete
Yeah,
sidewalk?
there's this kind of walk around where you've got 2, 3 what are called ramps, handicap ramps, and I can't understand what they're actually doing. Are you walking along the sidewalk and then you go down a ramp and then you go up again?
So basically, this is what we refer to in the industry as a bay conversion. So it's taking out the automotive service bays and changing that to a C-store. So we'll
Right.
do a continuous 6-inch high concrete sidewalk around the building. And to accommodate ADA requirements, we'll put, right now we're showing the handicap or the accessible parking space right at the corner. So we would need to then have that depressed and have a ramp that goes up in either direction. And then on the other side, we were just providing another ramp in that location to promote any patrons that would be parking in parking spaces 3 through 5, the ability to walk up.
But how does that ramp even work? I mean, if the handicapped space is on the right side where you've got that little symbol, and you exit from the passenger side, let's just say you exit from the passenger side, even though you could also be exiting from the driver's side, right? If you exit from the passenger side onto that hatched area, you're not encountering a ramp, unless you are, but this is I don't understand the slope of I don't understand how the ramp is working.
You would be at grade or at pavement elevation at 2% slope in either direction to meet ADA accessibility codes. Then you would have a depression in the corner of the building, and then you would ramp up on either side.
So, okay.
We can provide clarification.
Yeah.
And in the next comment about, one of the comments as we extend down, we'll talk about the orientation of those 2 parking spaces backing out onto the sidewalk. It was noted, I believe, in your review that that's not appropriate. We will reorient that. So we're going to change the handicap parking spaces in the next submission regardless, but we can make additional detailing in the plan set to show how those ramps will work.
Okay. Hence the need to enlarge the site plan. 'Cause
Not a problem,
it's
okay.
minuscule. Okay.
Maneuverability, the chair wants to know the need for the 24-foot curb cut on 34th Avenue. So the way this gas station is, this is a typical earlier or non-modern gas station setup where we have dispenser islands that are parallel to 34th Street instead of what you would typically see in a larger gas station where you'd see them 90 degrees to the building. So in the parallel setup, you would enter, if you're heading down 34th Street, you would enter in a right turn movement, access the fueling position, and then you would leave also out of the 24-foot curb cut along 34th Avenue.
So it's like a loop up and out.
Yeah, you would come in and then back out again. To then, if somebody wanted to access 31st Street, obviously they can make a right turn to make a left turn out through 31st Street, if you wanted to continue on 34th, that wouldn't be the most opportune movement. So to make sure that the setup works in the most efficient manner, the 24-foot curb cut that you're talking about, in our opinion, needs to stay because it provides better circulation for this type of setup.
Okay, why don't you just provide a maneuverability that shows how cars
We
would
can.
access the site?
That was suggested in our
Yeah.
call yesterday with our attorney to provide
Right.
that. We've shown the truck, we'll show the passenger vehicles. We talked about protection, and then the vacuum pumps. There's a vacuum pump and an air tower underneath the existing freestanding sign. We can definitely relocate that in a better location to prevent cars from parking there and creating any type of blockage. We've already have some ideas on where to locate that, as well as the trash enclosure and some of the parking spaces.
Okay, great.
And we'll provide detailing on the next submission.
Okay, great. I think that covers it, right? Are there any other speakers on this? Any speakers, I mean? And we do want photos of the perimeter, right? And, you know, the reason for the photos of the back of the building is to understand that the building's being maintained, since the residents are sharing your experience with you.
Understand.
You know? Okay. All right, so then, how much time to do this?
time do you need? Oh, so 30 on this, 10th?
When's the next available?
That's what we're looking at.
Yeah, so 30 on the 17th, 29 on the 3rd, 16 on the 22nd.
Okay, let's stay with the 22nd.
29th is 15th.
Okay, let's stay with the 22nd.
Okay, so how about a continued hearing October 22nd, which would be a submission date of October 2nd?
Okay, perfect.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank you.
Appeals calendar, new cases, item number 8, 2018-125A, 495 Wild Avenue, Staten Island. Oh, you
And-
know this one.
Yeah, you're going to do that after. I just wanted to comment that fire department submitted a letter, so, with comment.
Good afternoon, Cesar G. Quinto applicant. I received the fire department comment letter yesterday, and along with the, I reviewed the executive videos, comments by the, I'm prepared, I think one of the issues, we wanted to see floor plans, building elevations, and sections. I have some copies here I could distribute to the...
Please. Thank you. Yeah,
are.
at the back.
Yeah, that'd be great. Mr. Daly.
Mr. Daly?
I have a copy
Chief
of
Dale?
plans for you.
AC off? Yeah.
Oh, sure.
Thank you.
Okay, I guess we'll start with the fire department. The plans there basically show the floor plans, and there was a mistake on the site plan. As you can see, part of the building is one story. If you look at the building section, which is the pass-through tunnel, which accesses the rear parking lot. That will be on the last page.
Okay.
And it shows a clearance height from floor to underside of the structure of 17 feet. The proposed building will be fully sprinkled. The nearest fire hydrant is directly in front of the building, roughly 8 feet away. I've highlighted there in yellow. I also highlighted the building will fully be sprinkled. The other comment was the question about the fence on the opposite side of the street. I was out there yesterday, and I basically measured it from the existing curb line on our side of the street to that fence. It's approximately 60 feet. which the street width is roughly 34 feet based on the survey that was submitted. So I don't believe that there's any obstruction with fire department access in the event of an emergency.
Sorry, so the fence, you're talking about the distance of 36 foot 4 inches to the edge of asphalt pavement? Is that where you're saying the fence?
There it is on this side of the street, there's a fence. So from this point to this point, it's about 60 feet.
Okay, so there's the pavement line, and then,
Right.
which is only
Which is
34,
34 feet, yes.
and then the fence is set far back. Okay.
And there is parking there that's 90 degrees to the street line.
Right, that's the in.
Correct.
Parking.
Correct.
Okay. All right.
Madam Chair, the other question you had was, do you want the distance to the nearest map street, which is northwest of our property? It's approximately 420 feet.
Okay. But you don't show that on a site plan anywhere?
No, but I did make that submission with the borough president map, which was submitted back in,
And it shows that dimension?
well, the dimension is on my site plan and on the survey. This map I did submit.
Okay, right.
Okay.
So,
Victory Boulevard, this is where it's adopted here.
okay, and your
from the
site?
west side is over here.
And it says on this plan, 420 feet?
Right there, Victory Boulevard.
Oh, 422 survey from Victory Boulevard. Okay. Okay, thanks.
And I think the other comment you had was about modifying the hardship findings.
Yes. Did you want to maybe talk about the hardship findings?
Well, basically, I mean, I did some research. I mean, basically, the site in question is an M31 zone, which unfortunately, residential buildings are not allowed in an M district. So therefore, the only permitted use as of right is what we're proposing here, which is similar in nature to the character of the neighborhood. And there's been recently, between 2009 and 2019, 5 buildings that were issued CVOs of similar nature. And basically, Wild Avenue has been open and in use since 1925 with a CCO. And basically, that's the hardship.
Okay. Okay, so we also had a question about common ownership with adjoining lots?
Yeah, this lot is owned by, under a separate corporation, by the building directly behind us, by the same owner. 491 Wild Avenue, which is lot number,
When you say behind, it's
491 is lot number 51.
So does that lot have access to a map street?
Yes, it does.
So how does this work? So there's a 3-story masonry building at 491, so it says on your site plan, right? So, but it's being treated as separate lots here, right? You can't drive through to the other one.
No, it's a separate lot, correct. There's a tax map here that...
Yeah, that would be helpful, thank you.
That situation.
So it fronts on, why does it have a Wild Avenue address? That's weird.
This is the building in the back. This is the lot in question that we're developing.
4950 is the lot.
Right.
Oh, it's an L-shaped
A-shaped
lot.
lot.
Oh,
And the building
a
is back
flag.
here. Right.
I see.
Okay.
So, yeah, I'll show you. So there's a flag, there's a lot adjacent to this lot and a flag-shaped lot that bends around the lot, but but it has frontage on Wild Avenue. So it's exactly the same situation. Its only frontage is from this unmapped street. It's not that it's a through lot that has frontage on another street.
And it does have a final CO 491.
Right. Lot number 51, is that what it is?
It is,
Yeah. Commissioner Shabeta, it's lot number what that's next door?
I think it's 50, is it 51?
Yeah, that sounds right.
it is 51.
Okay.
I
Got it.
believe that was it, unless
Yes.
I'm missing something.
I think that, and I think Commissioner Shanda, you had a question about the zoning chart?
I think it was just trying to make sure that the zoning chart and statement of fact refer to the same thing, which, as I understand it, it's a two-level building, so there's one portion that is two-story and the other one has
Correct.
one story. So I
That's
think
correct.
that answers my question.
Okay. And then I would like to hear from Fire Department, if they have anything they want to add.
Good afternoon, John Daly, Fire Department. Thank you, sir, for responding to our comments on our letter. After reviewing these plans, we have no further objection
Okay.
to this application.
Great, thank you very much. All right then, so I think, and we already had DEP sign off and DEC sign off.
They had no jurisdiction.
They had no jurisdiction, right. And then, okay then, I don't think there are any other issues. Are there any speakers on this? Did I ask that question already? And the Community Board recommended approval, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Ali Brown? Aye. Commissioner Shabeta?
And a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shabeta?
Thank you very much, and for your responsiveness, that
Oh,
really
I'm
helped.
sorry, I just have one question about this case.
Oh.
Was this sent to submit the plans?
Oh.
Otherwise, I'll just,
They'll
because
be
those are the
submitted now.
plans.
Yeah.
Okay, so.
Okay.
Just take it. All right, thank you.
Jen, do you have a copy
Yeah.
with you?
For the record.
You have a copy?
No, I don't.
Okay. So we're gonna give you a copy.
Yeah.
They're marked.
You're good, thank you.
We're good?
Yes, you're good, thank you. This is a different case.
Oh, okay, oops.
Yeah, these are both be uploaded. Thanks.
Okay,
Just broke our own rule.
item number 9, 2019-17 BZY, 30 West 39th Street, Manhattan. And should I call the next one as
Yes.
well?
Oh, no, sorry,
no,
different
so discussed
findings.
them
Yeah,
yesterday
we did
separately,
this.
so
Yeah,
just
different
one.
findings, yeah.
There's no need to swear.
Good afternoon. Well, you've had a long day. Robin Kramer, Duval and Stackenfeld, on behalf of the applicant, 26 West 39th Street LLC. I'm going to just respond to the comments that were raised yesterday. Now, some of the responses obviously relate to both, but I'll give you first the ones on this application. So the first question was about filing. I know we filed on time and submitted our notices. I hope that you got your internal
Yes,
confirmation of
I've
everything.
seen proof of the January 22nd filing.
Great.
Yeah.
All right, so you had, the first thing was that you noted that the community board had commented that there was continuing work. And we do not dispute that there was continuing work. Work continued until there was a stop work order issued on, I believe it was April 30th. But none of the work that was submitted as evidence of having achieved the findings or reached the findings necessary for the BZY application included any work done after December 20th. So while there was work, it is not included in anything we submitted, either the costs or the work itself. I'll just say that the applicant had 2 audits from the Department of Buildings, one at the end of February and one in late March or April, and both times the Department of Buildings allowed them to continue construction, so they continued construction. Okay. Now, you raised some questions about the permits, the fact that we had the foundation permit and we're constructing with that, and before we got the NB permit, for the entire building. And your counsel yesterday read the section or indicated that there was a section of the building code related to it, 128-104.2.5, phased or partial approval, which says that if construction documents for construction of a new building, that the commissioner may grant partial approval of construction documents before the construction documents for the entire building have been submitted, and it sets forth a series of requirements that have to be submitted. You have to have submitted a lot diagram showing the location of the lot, a zoning analysis, foundation plans, including a loading diagram, earthwork plans, floor and roof plans, structural calculations. All of those were submitted in time, and all of them have been submitted to you. All of the items listed here are either on the zoning sheets that were submitted as part of our application or on the foundation plans and SOE drawings that were submitted as part of our application.
I don't think we have the approved zoning diagrams, or
Okay.
zoning, it's supposed to be the zoning analysis is the language, whatever.
Yeah, well, we
that
have the
is.
zoning, the zoning, the Z1s and the Z100s, all of that is part of the application. It should be, I will 100% go
Right.
verify, and if not, we'll submit it. Now, there was a problem.
Wait, before you go on. So the requirement for the validity of the permit so that you can proceed with foundations is that there be zoning calculations or zoning drawings submitted in order for that foundation permit to have been issued, and it had to have been approved, right? So we don't have stamped approved zoning drawings. We only have architectural drawings where I believe you provided a note that said it was too heavy, and so therefore we didn't have one that has the approved stamp on it. We actually need proof that the zoning drawings were approved in concert with the foundation permit.
Okay, so, well, they weren't approved in concert with, they were approved prior to.
Prior to issuance of the foundation permit, okay?
We have I will get that, the zoning approval was obtained in February of 2018. So, the Z1 was approved in February of 2018, so we'll get that and make sure you have that. Now, with respect to as you just commented, Chair, about the fact that the problem is that the plans that were prepared, since this was submitted through the borough and not HUB, the plans were submitted in hard copy, not electronically, so they were not stamped electronically, and therefore we had to submit. But we did submit one hard copy of the stamped plans. We just couldn't submit electronic copies legible enough for you to read. We did try and submit, but I understand it may have crashed your system. So, because it had to be so large in order to make it legible. So we did submit one hard copy.
Okay, so if you could just take a photocopy of the cover pages that include the Z001 to show that that was approved and the date that it was approved.
Okay.
And ideally, that approval date is prior to the foundation permit issue, right?
Very good.
The permits were issued in July of 18, right?
Yes. Okay. Will do. You had several questions regarding work and hours worked and after-hours work. So, after-hours permits are required if you're doing work other than between 7 a.m. and 6 p.m. 7 a.m. to 6 p.m. is 11 hours, so if a worker works 11 hours and gets paid through lunch, that is perfectly acceptable, does not require an after-hours permit in order to do that work. The client did not get any after-hours permits for weekdays because they weren't needed, because nobody worked longer than 11 hours, nobody worked before 7 or after 6. There were after-hours permits for weekends when the client worked. Now, sometimes because you don't know, client doesn't know, and you need to get the permits days in advance, client may get a permit for after-hours work on a weekend and then decide that for whatever they're in the process of doing, they don't need to use the permit, and they just don't do it. But they had the permits for all the weekends that they worked and did not work any after-hours times on weekdays. Now, there were some questions also about when the logs were prepared, so the logs are prepared daily, and they're done just on this electronic, there's no handwritten journal. And the logs are prepared daily, and the supervisor on site puts in the information as it's going during the day. Sometimes at the end of the day, he will close out the permit that day. It's always saved after he puts in time. When the supervisor closes out, then when it's printed, it has that green banner across it that says something like closed out. I don't remember the exact language. He may save it that day, but if he doesn't formally go in and check the box that says like closed out, then it doesn't print with the green banner, then it doesn't show up the green banner across. It doesn't mean he didn't do it on that date, it just means he, didn't dot his i's and cross his t's, essentially.
So to that point, I don't know about this site, but many construction sites have photographs taken every day by the construction management crew. Did this site have a construction management group that takes pictures
We did have
every day?
photos, and we submitted photos, certainly toward the end. We have more photos if you would like additional photos.
Yeah, so in other words, to understand what the progress of the work is every day during these critical periods, I don't think we got that kind of...
During the daily, I don't know if,
Yeah.
I don't know if we had photographs every day or not.
They weren't submitted, so, okay.
So we can't, would you like us to submit those?
Yes.
Okay. Okay. And then, as I said already about the work after, then you had some questions about the amount of the concrete in the rat slab. The rat slab is only a small portion of the construction needed for this type of mat foundation, but we will get to you the amount of concrete poured in that rat slab. So I don't have it, but we will get it to you. You also had some questions about checks dated after December 20th. There were two checks dated, one dated in January and one dated in February, but those were for costs incurred in November and December, because checks this client pays checks pursuant to his contract between 30 and 60 days after costs were incurred. So checks paid in January would have been for November costs, checks paid in February would have been for December costs. So all of the costs that are incorporated and paid by those checks were incurred prior to December 20th. And we could come back and show you specifically, check X dollars relates to requisition Y, that's X dollars also.
It would be helpful if you could also, if you can tie it to the work that was completed in any way, that would be helpful. In a spreadsheet, like that says, I don't know, installed 18 out of 18 soldier piles, paid that date, or incurred this date, paid after the date, like that kind of thing, then that'd be helpful.
Okay.
So, and in terms of the concrete, I believe we have concrete pour logs, right?
You do.
So that's the issue, is to tie in the concrete pour to the actual, which is foundation work versus any kind of supportive excavation, right? Anything, no, that's what we're looking at, is how to separate the foundation from not the foundation, right?
Right, understand, but remember, as I say, not the concrete is not, there's not a lot of concrete in a rat slab compared to the total concrete.
Right.
Because concrete isn't the only measure of how much foundation.
Right, but we got these concrete pours, so we're not sure what they're related to.
Fine, we'll do something about the concrete pour. I think those were the only questions I have noted on the BZY application. Was there something else?
I suppose there was one question from Commissioner Shabeta about work done without permits. So I think a lot of this is to clarify, so because we don't really understand, your logs don't explain at what time in the of the day. It just says, guys came, 11 guys, 11 hours, have a nice day, right? It doesn't say what time they came. I don't know if there are any other logs like that. We've seen logs where it actually tells you how many guys from which trades and all of that sort of thing were on the job. If you have anything more detailed where we could know that all the work is being done between the hours of 7 a.m. and 6 p.m. Because we have those comments from the community board that work was done after the 6 PM time.
Actually, what the community board, when they raised it, they had never looked, they didn't ask us if we had variance after-hours permits for this. They just made the statement, and in fact, there was a representative from the council member's office who looked at, as he was, I mean, she didn't mention dates, the woman who made this comment at the community board, but the representative from the councilman's office happened to be able to check and found that there were, in fact, after-hours permits issued, but since no dates were mentioned as to what she was talking about, and also, again, remember, she was talking about, I'm not trying to say that we did work without a permit after the 20th, but she was also talking about work done after the 20th.
Right, but I'm trying to clarify, there seems to have been statements made at the community board that work was done in the evening during the week, for which you would have needed weekday after-hour permits, which we don't see in your stack. We only see Saturday after-hour permits.
Correct, because we did not, in fact, do that.
You didn't, in fact?
We did not do work after 6 PM any evening.
On a weekday.
On a weekday.
And did not.
Oh, not before 6 AM or after.
Before 7 AM.
Yeah, or
So
after.
you only did the work during weekdays from 7 AM to 6 PM?
Correct.
and-
Weekends, we did other times.
And you sought the permit for that?
Correct. And certainly, there was some very late night, I mean, sort of almost overnight kind of permits, which you're allowed to do per an after-hours permit on a weekend,
But we
not
actually
weekdays.
didn't see the use of the after-hour, maybe one or 2 days. The Saturday after-hours
Yes,
permit
they
wasn't
were.
really, the logs don't show it being used other than 1 or 2 days.
We can go back and double-check and show you when the after-hours permits on a weekend was obtained and when it was used. I thought we did submit that information certainly in when
Well, we have a number of Saturday after-hours permits,
Correct.
but it doesn't look like, according to the logs, that they were utilized.
As I said, some of them were certainly not utilized, no question about that.
Right.
So we'll give you some kind of a comparison where the logs relate to the after-hours permit.
Yes. Because you're saying some late-night work was done on weekends?
Yes.
Okay. So that's the thing, maybe clarify what.
Yeah, that's fine, we will look up the,
One more. Also, on the 20th, your log says you poured 8 hours, and that was the date of the text amendment. So
Right.
were you pouring after the signing of the text amendment, or?
I honestly don't know the answer to that question.
So
You could get that information. You can get the minutes from the council.
I'll check and see what I can.
Okay. Hold on a second. All right. All right, anything else that we needed on that? Okay. Okay, so with respect to this application, are there any speakers on this? No? Okay.
Do you want to defer scheduling
Yeah,
this one to
yeah,
the
yeah.
next one?
Mhm.
Item number 10, 2019-175A, 30 West 39th Street, Manhattan.
Okay.
State your name again, please.
Robin Kramer from Duval and Stackenfeld on behalf of the owner applicant, 26 West 39th LLC. All right, so in response to questions that were raised at the review session yesterday, I'm not going to repeat anything that came up that relates to both applications, if that's okay. All right, so you said something about the community board. The community board only had a hearing on the BZY application, which was before we filed the common law application. They did not have a hearing on the common law. The chair of the land use committee told me they'd already found that we hadn't, in her determination, had found that we hadn't completed the foundation. They didn't need to hear the application again.
Okay.
So now there were some questions about the costs in the application. There are 2 tables that show the costs, and there were some questions about that. Each table presents a different sort of scenario. The first table are the costs that were incurred if you don't consider acquisition, demolition, and costs related thereto. in the second table, it includes acquisition, demolition, and costs related thereto. So for example, in the second chart, the costs included asbestos abatement, title insurance, bank fees, mortgage recording tax, which will relate to the acquisition price and not anything else. Those are some of the costs that were in the second table and not the first. So yeah, I know it does seem like, since one is 3 million and change and the other one is 6 million, but it wasn't double counted, just that's what the additional costs were. Then there were several questions on serious loss, so let me see if I can get all of them. So one of the questions had to do with the percentage of the foundation-only work that could not be repurposed for office. As Commissioner Otley Brown noted, the hotel is designed with floors set back in the center of the site toward the mid-block. An office building would not be built with the same configuration because it would have much larger floors, so the elevator core would have to be relocated for a different kind of construction. In addition, I understand that construction would be a steel-based building rather than a concrete building, which would have different column settings and could require some. We will have someone, they'll have a structural engineer and geotech, someone look into some estimate. Again, we haven't designed an office building, so we couldn't give you an actual detail about specifics, the number, but we will try to give you some estimate of how much of the foundation could be repurposed for other purposes.
I'm a little confused with that. I'm looking at the plans. Why couldn't this floor plate be used as an office building?
It's too small.
It needs to set back the distance from the rear, right? It's, in this case, I assume it's a 30-foot rear yard, right? It's a 20-foot rear?
It's a hotel.
Because it's a hotel. So it's the same 20-foot rear yard, right? And then there's a setback from the front, but that may be because it needs to fall behind the sky exposure plane, right?
At some point, I have not done a.
Yeah,
We
so-
submitted a copy of an architect, we had an architect do a sort of a preliminary, sketch of this, so we did submit that.
Right, but so that's the part that I'm having confused about. It's built lot line to lot line, side lot line to side lot line. So it's
Right.
not, a tower on a base or something like that, where arguably that's not a good choice for offices. It's got the minimum rear yard, and it's a weird lot, so it has this little tail that's not very useful for almost anything, right? So it's not like you would pack up the tail with office use necessarily. So it makes sense that you would put the bulk of the floor area in the shape that we're looking at. So I'm not really sure why the floor plates can't be used for office, either double loaded or not. I'm not saying that the elevator core wouldn't be affected, no comment on that, but,
The answer to the
Yeah.
question is I don't know the answer to the
Right.
question, and we will get you an answer to the question. As to, a better answer as to what would be as I said, about the foundation, how much could be repurposed, and why we think if some of it can't. Whether it's the same footprint, just in a different place, or whether it's a different footprint and what is needed. Okay, so now, one of the questions came up about the electrical work. The only electrical costs that have been included are the generator, and we may be able to, I don't think we've analyzed, but it wasn't a significant cost. It may be able to be repurposed for for an office. Now, there was a lot of questions, sort of discussion and theoretical about actually the whole concept of serious loss. Now, serious loss, and it's very different here, right? In the normal application, you can't build a building as tall. You can't build a building with the same density. You can't build a building with some other requirements, height and setback are different. You can't build it, you had all this discussion about tower. You can't build the tower on this portion of lot. One of those is very different. The question here is, we have a permit, and we have a building that was begun construction of, plans were prepared, excavation was undertaken and completed, foundations were constructed, all in connection with building a hotel. So, if we could not build the hotel, would there be a serious loss? Whether or not all or some of the foundation can be repurposed doesn't answer the question. If we can't, let's assume, just for argument's sake, that we could repurpose 100% of the foundation, which we know we can't, so let's say 75%. 75% of, let's assume that 75% of the foundation could be repurposed for an office building. We might not lose as much money on the foundation costs, but in terms of the completion of the building, we would still lose the money, because the costs, the applicant bought the site started in 2014, way before this was even being considered by City Planning Commission for this kind of rezoning, or amendment to the zoning text, not a rezoning, and paid a price for it based on an expectation of hotel development. If they can't build a hotel now, the question is, what else can they do for the site? It's an M1 zone, you can't do residential. It's an M1 zone, you're not building manufacturing here as a practical matter. So the use that would really be most likely to be here is office use. That would be, at least in terms of location, and office would be used. But if you build a hotel, same size or as big as you could be, the point is that given the costs for the purchase price and other costs, you could not recoup the costs, including the purchase price, including construction, including all the soft costs, given the market and the rental rates for office uses. So there would not be another use that we could practically put on the site that we would be able to recoup our losses on. And that's where the serious loss comes in.
So that's a part, I know this is really Commissioner Otley Brown's domain, but I don't understand why you can't recoup the purchase price. I mean, when you're buying this, the seller isn't thinking the price based on, oh, they're going to build a hotel, so I'm charging more money. The seller looks at what's the allowable FAR, it's great FAR, and says, you know, this is 10 times the floor area, and I'm going to charge you whatever I can get per square foot of development potential. And maybe even there's a zoning lot enlargement here that's possible. And so I'll think about that, and I'll think about, you know, what my advisors are telling me is the market rate for this site based on the various uses, hotel, office building, whatever else. So I don't understand that statement that you can't recoup the purchase price for a hotel.
Well, you said it yourself. When a seller is setting the purchase price, they look at how much is someone going to be willing to pay me? And they don't care what the use is. They know that the purchase price is a certain dollar. But the highest and best use for this site is a hotel use. Based on a hotel use, a purchaser could recoup their costs. If we're going to put an office building here, no one would necessarily, I don't know for sure, I wasn't there, I didn't see the market. Right. Someone would not necessarily have paid the same price. We all know that prices, applicants, property owners charge a price based on what they think they can get for a site, whether it's practical, not practical, it's what they think they can get. And sometimes they get that because the purchaser thinks were able to recoup it. If the purchaser doesn't think they can recoup it for whatever use they're planning for, they wouldn't pay the price.
Patrick, loss needs to be stated in more concrete terms rather than the theoretical purchase prices, et cetera. There needs to be something more concrete that we can compare it to show a serious loss.
Well, we did analysis. We had we gave you rental costs. We gave you an affidavit from a broker who deals with this, who knows what rent is, so we could determine how much. I don't know in terms of costs. I'm not sure what we said. And it doesn't matter whether the purchase price was too much or too little. Let's just leave it at that. Let's ignore that. To develop a hotel is going to cost us, and I have my numbers here, to develop a hotel is going to cost us $159 million, including purchase price, including everything else. Now, you then build the building, and then you rent the building. That $159 million is then paid for, right? You get a loan, you're paying interest on the loan. You start renting the building. The upper floors would be office, the ground floor would have retail, and you would get income from that. The question is the income that you're going to get from all of that sufficient to repay the costs including acquisition and construction and operation.
Right. I understand your point, but you're talking more of a highest and best use analysis, like an appraisal. And first of all, when you're coming to us for investing, you haven't spent all of that money yet. So you
Correct.
can't really talk about it as a loss in terms of that. It has to be a loss of what you have already put out there in terms of what you've spent and what you've incurred prior to zoning, going towards a hotel that can't be reused for an office. So that's one part of it. And for that, you would talk about the soft costs and all of the fees that you paid to pursue this hotel application. And then I mean, you could probably put in, demolition, whatever the actual items were originally that were installed that have to be demolished, that's your loss also. But another part of it is the loss in income. And you don't have to do a full appraisal to give us that, and you gave us part of it, actually. It was just, I couldn't find the last piece. So while I said that usually when people come to us investing and it's a bulk issue, it's very easy to quantify. We could have put in 60 hotel rooms, now we could only put in 20, so 60 times 299 a night versus 20. You could still give us some portion of that analysis if you give us the income from the hotel rooms that you were expecting to get, and I couldn't find it. You did give us the office income. So you could show us we had 299 rooms that would rent at so-and-so per room. I could at least get a total income for that and set it against the total income from the office building and say, okay, there's going to be a loss of income here. So that's what I was talking about.
Okay, that's fine, we can do that. I'm sorry, to me, because we couldn't recoup the costs that we would have incurred into the construction of an office, that's what we were providing as the serious loss. You'd like to see a serious loss of income based on a comparison of hotel versus office, so we will give you those numbers.
But I'm just curious, why, and it's true, it's much easier to understand this when it's a bulk loss. But why isn't that a highest and best use argument, that if you have to build a hotel, you just won't make as much money as if you, an office building is just not as much money as a hotel, but you're still making money, unless you're showing that you're not making money, which is not.
Well, I think that because the highest and best use, you're not guaranteed that you can have the highest and best use in any project.
Right.
And to me, the loss has to be more what you invested towards a particular project that you can't recoup. And part of that expectation is we're going to invest in 299 hotel rooms because we expect that they're going to rent for $300 a night times 365 days a year. And now we're just going to have, I don't know, 80,000 square feet of office space at only $75 a square foot. It's the closest you can get to showing the loss in income while staying away from a more market-driven argument of, we like hotels, hotels are the highest and best use, and nothing else is going to be feasible because we spent $40 million to buy this site. Because that's not really what serious loss in a vesting case is about.
I thought...
Unless you had that.
Right.
You don't necessarily want to talk about being able to recoup and have something be feasible, because that's more of a market argument, and what we're trying to get at, to me, at least the way I look at it, is that we want to see what you invested towards this project that would be lost, and part of that is the investment with an expectation, but to divorce as much of the market argument out of it so you can kind of highlight the loss if you're not allowed to complete a hotel.
Yeah, that's also consistent with the case law and common law vesting cases where if the board finds that the applicant has otherwise recouped their investment, it's not a basis for granting the common law vesting.
Correct, which is why we gave you the analysis we did to show you that were we to build a hotel, were we to build an office building instead of a hotel, we couldn't recoup 5 years after. We gave you a build out and a sheet that showed 5 or 6 years down the line. This is how much income we would have, which is zero. So if you have net, I don't mean there'd be zero income, there would be a net, would be below zero, our return on investment essentially to show you that were we to put a permitted use here, we could not recoup our investment, and therefore we would have a serious loss, which we gave you already. That was in the information we gave you, but I will go back and we will provide to you the hotel information that you're asking for.
I mean, I would say also, because if you're going to go down the line that you went, and this doesn't mean that I'm saying this is what your clients did, but it could easily be a bad investment that's a cause of not being able to make the office building feasible. And so we don't want that in the mix of the serious loss that is purely because of the zoning change. That's all.
Okay, I have to say that I'm a little confused here. The serious loss is you can't build a hotel as of right. That's what we can no longer do, right? Maybe we could build a hotel with a special permit, maybe we can't, nobody knows, and we also don't know what additional costs could be sort of imposed as a condition of the special permit, several of which could be very high. So we didn't go that way to say we know what they would be because we have no idea. So instead, we looked at the hotel, okay? Whether we overpaid for the land or not, we paid X for the land. Now, if we were to operate a hotel here and build a hotel, which is doable, it is certainly doable pursuant to the zoning to build a hotel on this site. And if we built a hotel to build an office building on this site, and if we build an office building on the site, we will have costs related to that building, the office building, right? We have some costs, we'd have to, all the soft costs, leaving aside the acquisition, which obviously you pay for both, but the soft costs would all have to be redone, all the plans would have to be redone, obviously.
That's clear.
Yeah,
That's where we should
exactly
be.
what we want you to be
Yes.
focusing on. And you
Right.
could even say, like, it would take, let's say we went to city council, like you did tell us, it would take probably 2 years, and we're not even sure where we would end up. But if we built an office building, it would be 4 years of not getting income. So you could say 4 years of paying off your mortgage and paying your taxes and all of that.
Fine, okay, I understand now, we will do that, we gave you a lot of that information here, but we'll put it in the format, the information in the way you want it. Okay, no
great.
problem.
Thank you. Right, anything else?
I think that was
that's it.
all, unless there was something I missed?
Right. My personal preference on this, to make it just easier to understand, is to not go to the subject of that special permit, to just stay with what's permitted as of right.
Right.
And not project like the cost of the special permit and all that stuff. It just makes it more
Right.
complicated.
I just give,
Okay.
it's just a time, so we'll leave it, so we'll just do a comparison of the office.
Right. And
Okay.
how long it will take you to be able to even get an income.
Got it, will do.
Okay. Are there any speakers on this? Okay, so ready to, are there speakers? Oh, sorry.
No, so I'm looking at my client to see how much time we would need to get.
I see, I
to the answers. Sorry? A week.
A week, but, you know, that's the thing, our calendar, your calendar.
I understand.
They don't match each other.
Right, and because, this is here, they had to lay off all the workers, I understand. I mean, the problem with vesting cases from a development side is, when you're coming for a variance, you may have incurred purchase price, you may have mortgage, but you don't have other costs. When you're coming for a vesting, you've got a lot of other costs related to, so it's just, speed is sort of.
Well, what's odd about this is this application was submitted on March 21st?
No, it was February.
22nd was
Oh, sorry, February.
January.
Yeah,
It was submitted.
Sorry, January, oh, right.
It was, the BZY was submitted timely.
Yeah.
And
okay.
everything was, took 2 months till we got comments, and then, maybe we could have responded better, but who knows?
We can put it on in our
1 month.
October. Sounds really far from now, but it's not actually.
Okay, can we do the first week?
First week in October, that's October 3rd.
Yes.
Yeah?
Because it's a September 11 submission.
Okay, yeah.
What are these for?
These are appeal, this is a vesting case. These are tough variances that are new.
No, I think this isn't good for that.
I left mine on the table. Let's just.
That's putting it on earlier, but I think there's too many things that are variances there.
I'll talk fast. I can do it.
No, it's not
I
that.
think it's the preparation.
Sorry. I'll get it to you sooner if you want to prepare sooner. I mean, we'll get it to you way before
It
September
doesn't look
11th.
that way. We have to prepare for the cases that are before yours.
And there are 30 cases on the calendars before
Yeah.
that one. But that one's pretty
Just look at the next week.
Because there's two weeks of prep time.
Oh, okay. Because there's a 3-week.
Yeah,
Okay.
if you could do it, I could do it, because you've got 2 weeks.
Okay.
September 11th?
Yeah, so, right, because the last hearing
It's
is September 17th.
So,
All right.
Okay, so you can have a continued hearing on October 3rd, which I note is a Thursday.
Oh, it's a Thursday.
For the, I think it's for
Oh, because Rosh
holidays.
Hashanah is that.
And so your submission date would be September 11th.
Okay, thank you.
For both of the cases.
Right,
Yeah,
understood.
Great.
Thank you.
Okay, thanks very much.
Zoning calendar continued hearings. Item number 11, 2016-4469BZ, 49-23 Astoria Boulevard, Queens. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes. And everyone received a letter this
Yes, there was a
last night or this morning? I'm not sure when it came.
This morning.
Yeah.
Good afternoon, Matthew Schomer, David F. Hutcher, and Citron for the applicant. As the chair mentioned, so we attended yesterday's review session and kind of took a look at this case, given the disposition of the board, kind of from the beginning again. And as we were going through the plans, noticed what appeared to be, what we believe is an error with respect to the zoning calculations on the as-of-right plans. Our architect prepared a plan that shows a 13-foot side yard based on a reading of zoning resolution section 2348 for narrow zoning lots. Given the fact that this is a corner lot, it has two side lot lines which intersect at the rear and then go to, more than 80 feet at the street line. We believe that this is based on the definition of lot width, that this is not a narrow zoning lot that can be availed of the relief under 2348.
It gets a little relief, it just doesn't, because you look at the width as opposed to the length of the zoning lot. Corner lots are normally, they're long one way, so in the 77 direction, that's its length. And they're wide the other way, so it goes between 1883 and 5849. So how DOB would actually interpret this, because it is in fact a narrow zoning lot. I don't know without you going to DOB, but what I do want to say is, even if you just took those two widths, 1883 and 5849, and averaged them, and you get a little bit off on the 4-inch reduction and so on, it seems to me that the question is, what's wrong with this zoning lot? What's wrong with this zoning lot is I have to comply with the side yard regulations, that's all, right? So it doesn't prevent you from complying with side yard. It doesn't mean that the relief is a use relief. It means the relief should be a yard relief, right? And so there we are again.
Yeah,
So
I
it
think
seems like if for argument's sake, you've established that the lot has this hardship, and this kind of lot we see all the time, that the hardship is forcing the little house to not be able to be wide enough, then we give a waiver for the yard so that the little house can be a little longer or a little wider or whatever it is. In this case, it would be actually a little longer. And then that's what the yard is entitled to, as opposed to use relief. Use relief is where it's just impossible to use the site for a conforming use for whatever reason. That's a fairly rare situation. Sometimes it's because maybe there was a gas station on the site or something, right?
We had a case on the same street frontage, two blocks down,
where the use relief was justified because the site was so narrow.
Right.
Exceptionally narrow, that even an as-of-right building was not feasible.
Right.
And that's how we came to the conclusion that the use in this case justified it.
No, not that an as-of-right building wasn't feasible. A building that received waivers of yards.
Right, even a
wasn't
with waiver
feasible.
was
Because
not
you
right.
couldn't even put an as-of-right building.
Right, you could build an as-of-right, even with waivers, it was not feasible, and failing those tests, we considered the use. In this case, it may have failed the as-of-right. We have not tested the variance part, right?
Well,
the waiver
but
part.
we don't need, I mean, just go ahead.
I did have a question though, because I was reading through the text prior to the hearing, and I saw where it said you needed at least one side yard of 20 feet. But I thought I also said that it also said you only need one front yard. So I was curious, did I read that incorrectly?
No, we read it again, and it does require two front
It
yards.
does?
It's just that the
Yeah.
second front yard doesn't need to align with the abutting one.
Right. In a district like this.
I reread that.
One front yard has to align with the abutting. You know, if it meets certain criteria, and the other one doesn't have to. That's what the instruction, yeah. So, but, you know, I would say again, and I think it's important what Commissioner Shanda mentioned was on that other case, you couldn't use a site for anything even with waivers. So hence the use waiver for a sign is kind of actually the only use, other than maybe a newsstand. In this case, a small waiver for yards would make a very nice little house. And, you know, you could get even, I don't think it needs any further waivers than that 7 feet for the side yard, because it's indicating quite a nice little house.
Well, I think that in response to that, I would say we haven't actually even, you know, because of how late this came up, we haven't actually looked at what the as-of-right is, but yet, I mean, agreeing that it's going to be significantly smaller and not work. Essentially, at that point, we've established that we have a hardship, that we have an A finding, and then we're proceeding to the B finding for essentially the financial analysis, and I think that even with waivers, even with certain waivers, we have a financial analysis that has already been presented to the board of the house that exists as it is in our current as-of-right scenario. That's actually would require some waivers. That shows that house actually does not work from a.
But prior to us getting this new note from you, I did not read all of my financial comments because we didn't think we had an A, but one of my comments for B was that the construction costs for this house seemed to be quite high, because if you included soft costs, you were at $426 a square foot, and just hard costs seem to be $327 a square foot. And I just was wondering if you could provide a few pages of Marshall and Swift to kind of ground that number, because it seemed high to me. And that's driving the fact that this is not going to be feasible, because your development costs ended up being, what, 1.2 million for this site? 1.325 million, and it only sold for 1.2 million. So the question is, are those construction costs on the high side? So the only way I guess I could really know is if you give me like a survey of building costs, and Marshall and Swift is a good one to use for a borough for a simple type of building like this.
Okay. Yeah, I mean, we can provide that.
So if we just go to that though, then you're looking at the as-of-right house as modified by the 20-foot side yard. Or it's not really 20 feet, it's 19 feet or something. There is a reduction because the averaging of those two actually does have a I think it's 38 feet instead, something like that. So then you're looking at an as-of-right house with a 19-foot rear yard, and concluding arguably that you can't make a living from it. But then we're looking again at the as the what's known as the lesser variance, where now there's a lot of play, right? So you have 10-foot front yards. What if the argument is there's not adequate floor area to make this work? Then
not floor area, not adequate lot area to make this work, that's where the waivers of the yards come in. So what's the magic number that gets you a building of adequate size? Those are the waivers that we normally grant for houses in these kinds of zoning districts. So I think you're kind of in the same place. You're in the board would be willing to give bulk waivers as opposed to use waivers, because the site is actually quite a good site for a house. I mean, it does lay out very well, even under, with that just one waiver on that side yard of 7 feet.
I mean, I think that the broker's letter attests to the fact that it doesn't lay out that well. I think his analysis.
But I don't think that we've even explored all the possible.
No, I agree. We haven't explored all the possible waivers.
How could we know if it's the less, if a use waiver is the least waiver, the lesser variance? How could we possibly guess that?
Well, but in addition to which, the broker says it doesn't lay out well. That's not my opinion. I think it lays out as a great little house. And, it's actually quite nice. And, either you do it as a one-family or you do it as a two-family. Two families are obviously are arguably sort of better uses in this district because the owner gets the benefit of another little apartment income and maybe more typical of this neighborhood, for example. I don't actually know if it's more typical. But you could take advantage of, say, it's a trapezoid. So, all right, maybe, I have to say it's so well designed. The staircase is right in the point of the trapezoid. That's where you put a staircase, right? And it happens to be really comfy. It fits the mechanical room, it fits a little closet, all that stuff. The kitchen, the bedrooms, everybody else are very nice sizes. But the waiver could reduce the extremity of the trapezoid and make it a little bit more rectangular. So if that was the argument,
I think what I want to draw attention to also is that we have today itself another case that is seeking one of the bulk waivers for a very narrow lot, much narrower than this, and the room layout configurations are much smaller than what's indicated here. So to support Chair's argument, I think it may not be your typical rectangular form, but the room sizes and in terms of laying out furniture, I don't think it's going to be much of an issue. So,
I mean, except for the fact that, we have the shape of the lot, the size of the lot, the shallowness of the lot, which prevents sort of a larger yard, a larger and more private yard, in combination with the fact that this is sandwiched between two commercial uses, including this 24-hour gas station, that it's on Astoria Boulevard, which is a busy road. There's no opportunity because of the narrowness along the side street. There's no opportunity for a driveway that's not straight off of Astoria Boulevard. Those are also factors that are contributing to the uniqueness of the lot, contributing to the hardship that is imposed upon the building. And what you're resulting with is, assuming that we can come to some sort of agreement on construction costs, we're still resulting in a building that is not going to be able to sell for the amount, not even be able to recoup the amount of construction costs when it sells. So there's still, even with as the case we presented, this building we presented here, doesn't actually recoup these construction costs. And so, yes, we can explore many other variations of bulk waivers on this site. Side yard, I don't know. I mean, we can front yards, we can go in many different directions with it, which we haven't done yet because we've sort of been focusing on the as of right. As of now, I mean, we can go through all those iterations of various bulk waivers. And if we do come out on the other side of that, going through all the various iterations with a project that's still not financially feasible, then the use waiver is still in play here, I think.
So I don't want to, we were going to close and vote on this case today until we were given this letter, right? I don't want to encourage you to keep going down this proverbial garden path here. The board is not looking favorably on this kind of a use on this site. When we look at the adjoining properties and the properties down the street, there are houses on Astoria Boulevard right here. And right next door to this one is a house. And down the street, there are houses that face Astoria Boulevard. It's true they're mixed with commercial uses, but it doesn't mean that residential is not a viable use here because we see it, right? And if it weren't the viable use, there might be other uses that are viable, but the board is having trouble with the proposed use. So I'd say if there is a case to be made that the zoning imposes on the as-of-right use something that is substandard, then those are the waivers the board would be willing to give. So, and I just don't want to encourage you to keep pursuing this use, but the board is not looking favorably on this use. And as was stated previously, there are other situations where there's no question that a lot is just too small to be used for anything. And the only thing you can do with it is put a sign pole down, right? But this isn't one of those. And so, if what I'd just recommend is if your client does not want to pursue a bulk waiver for residential use, which makes the property more valuable for sale, then you could withdraw this application. Or if your client wants to do that and makes it more valuable for sale, then you could come here for that waiver. But I don't want to encourage you to keep going after this. It's just, for one, we've been at this too long, and for two, I don't think you're going to be able to make the finding. You're not going to persuade us, I don't think.
Yeah, I think that we have not explored all the possible options for a bulk waiver to see if there's something that
Right.
that
well,
makes financial,
yeah,
that
so
actually ends up
we're-
making financial
We're not going
sense.
to allow you to pursue every single one because the board has to cut this off at some point, and we were ready to cut it off today. But again, I reiterate, and Commissioner Shand is showing me photographs of the residential buildings that face right on Astoria Boulevard. And many of them have funny lots and they protect themselves from the commercial. This one's a really good example that I'm looking at.
Those are all the houses you're looking at, I'm sure, 'cause I've seen all of them. They're all existing houses built
Yes.
in like the 20s. So it's
And
not. they're
people
not-
live in them, and people sell them and buy them, and
Right,
buy
but you
them
don't
and
have to
sell them.
construct them right now in 2019. Right, they're already existing, there's no costs imposed, and when someone's selling that house, they're not constructing it new.
I think you're making some good arguments for the bulk waivers. These arguments can be used towards bulk waivers.
If we explore bulk waivers and we find that there is a set of bulk waivers that makes something that we think can work here, then I think we will certainly pursue that option. We haven't looked at, we've only looked at as of right now, so we don't know what the options are.
But I would also like to second and third the chair and vice chair. I believe that a sign at this location is probably the last thing we want to look at.
There are lesser use waivers as well
Right,
than a
yes,
sign.
that would
which I
certainly
think
come before a
we
sign.
we looked at that we discussed it at the very first hearing.
Yeah, we did.
And then that kind of dropped out of the picture because of the residential issue coming up. I think that we're also open, again, to looking at a commercial use here, which is not a sign, which would be a lesser variance.
Okay, that's fair.
I think we're looking.
We're looking at not a sign.
Right.
Fair.
Simply put. Okay. Okay.
So we
All
have
right,
a little work
understood.
to do
We have
to
some work.
figure out where we're going. Yep.
Yes, exactly, and you should speak to your client about how to go with that. All right. Good, are there any speakers on this? All right.
So how much time would you like?
Get that one on it, and that over, or
October, November, about mid-November, split the difference.
I think that's fine, yeah.
Okay. How about continued hearing November 19th, which would be a submission October 30th?
Thank you.
Item number 12, 2018-33BZ, 31-41 97th Street, Queens. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes, I do. Sign?
Yes. That's it. You can go up.
Hello again.
State your name.
Arthur Yellen, architect, applicant. Based on the video, I assume that we've reached finish.
Yes. Good, that's correct. Okay, thank you very much for that submission. It was very clear, and it made the findings that we needed. So everybody is okay, right? So are there any speakers on this? All right, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Shabeta?
And then I just want to draw our attention, our council's attention to the fact that we need to be clear in our resolution that no waivers for floor area, balconies, front or rear yards, or height and setback are included, so that DOB has to accept the floor area at the second floor, has to review the floor area at the second floor, only part of which is under a sloping roof, so that's their domain. We're only waiving minimum lot area and side yards. This is just for their,
use.
for their drafting information.
And use.
And use, yes. Right, right. And use, okay, good point. Side yards.
Is one required.
Lot area, side yards, and use, yeah.
And maybe parking. Although we do fit in two cars,
Yeah.
it may not meet the building
Even though
department's.
it's tandem, it's not considered.
Oh, okay. All right, fair.
And park.
I'm not sure that's what the objection said, though.
I think so.
Yeah, so if the objection didn't refer to parking, then I don't know what to say about that. Okay.
But we don't, without an objection from DOB, we don't have the authority to grant them a waiver.
Right, right. So you might want to just check what your,
I'm checking now.
what the objection is.
I'm going to check the objection now.
I don't think that's for
I'm just checking my notes.
I don't have it. That's
Yeah,
one
my
of
notes
the
don't say it either.
yeah.
Two-family with cellar.
So there was one objection
Objection.
submitted July 30th, 2018, and it includes 2522A requirements where individual parking facilities are provided. So it is
Yeah.
listed.
Good, okay, then it's covered.
Okay.
All right then, so with that, I'd like to make a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
Thank you very much.
Thank you.
Yeah, did we close it?
We closed, yeah,
Yeah,
we
we
closed
closed.
at 4.
Oops, can we just hold on 1 second?
Item number, are we taking a break?
No, just 1 second.
Okay.
I'm pretty sure we granted. You can go ahead and call it, actually.
Item number 13, 2018-39BZ, 1249 East 23rd Street, Brooklyn.
Swear in.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good afternoon. Lyra Altman from the Law Office of Lyra Altman.
Okay, so I think we're finished with this. Any other comments from the board? Are there any speakers on this? No. Okay, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
And a motion to grant on condition, the usual removal of existing walls and/or joists in excess of that shown on the approved plans will void the special permit.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
Thank you very much.
Thank you.
Item number 14, 2018-52BZ, 159 Borum Street, Brooklyn. Do you affirm to tell the truth? Oh, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Getting submissions of this, I never know what's the last one.
The last submission was from FDNY, FDNY had objection with regards to the parking.
Yeah, right.
That's it, if you don't have anyone else.
Your own submission.
Okay.
Good afternoon, Chair, Commissioners.
Hi.
Nora Martins from Ackerman LLP on behalf of the applicant. Listened to the board's comments yesterday. We will, in response to comments regarding the plans, we'll remove the extra plan sheet from the Johnson project that was inadvertently included in the plan set. I apologize for that. We are happy to add the notes that were discussed. I believe the chair suggested adding a note to the site plan regarding the 25 off-site parking spaces that will be provided at Johnson. That note does appear on the parking plan, the proposed parking plan, but we can add it to the site plan to make sure it's very clear.
Right.
The proposed parking plan also does have a note noting that the...
I just want to add that
sure.
the off-site parking is pursuant to section, whatever it is, in the zoning resolution that says you're allowed to be that far away. So your site plan should show that it's complying with that section, that it's within 300 feet or whatever the distance is, I always forget, of this zoning lot, right?
Yes, we can show that. And then there's a note on the proposed parking plan, the BSA's standard note regarding the parking layout being subject to DOB approval. Is that note sufficient, or would the board like a more detailed note, given
No, that's
the
fine.
comments?
Subject layouts and parking, yeah, that's fine.
Okay, so that note is already on the plan.
Right, but you're aware of fire department's letter of objection about the parking? They always have, so this is an automated parking garage, right?
Yes, fully attended.
So, so fire department is always concerned about these automated parking garages and issued a letter of objection to us.
Okay, we did not
That was
receive a
something
copy
we
of
just,
It was
right?
just received, sorry.
No,
That's okay.
incorrect. Sorry. Chief Daly, please.
Good afternoon, John Daly, Fire Department. I do want to apologize for the late submission to this application. I know you heard it before. I do also have to apologize. I didn't have the applicant's email. I thought I had it, but the email was returned. I can give her a copy of my objection for the application right now.
Okay, yes, please do that. But the issue is, it's a letter of objection because it's an automated parking garage, and the fire department always requires a lot of, there's a lot of criteria that have to be satisfied for that parking garage, right? And they just want to make sure that you go through all of that, but they will be monitoring this, so that's not something that will, other than to make reference to fire department's objections, that's not something that will hold up our application because we don't review the real layout of the parking garage. Go ahead.
We would like them to submit an application to OTCR and to the tech management unit, OTCR being the DOB. And once they submit it, we'll inform the board, and they can then move forward. We will follow up with the approval and working with their architect or engineer, whoever designed the parking system.
Okay.
So just to make sure I'm clear, do we need to show proof that we've submitted that before the board can make their determination, or can that just be part of the regular DOB approval process?
No. These submittals, the automated parking garages, they go to a separate unit at the DOB. They're going to be reviewing it as well as the tech management. But if you can file with both of the unit at the DOB and the fire department, they will inform the board that, okay, we are in receipt of your filings, and that we'll work with the applicant to comply with all these items. There's about 3 pages just from fire department.
Yeah, it's a lot.
OTCR, I don't know their timeframe, but we'll work with, again, with the applicant, and the board can then, but that, they don't have to worry about the parking garage.
No, but the point is that we would make the submission according to fire department, according to the letter of objection.
Right.
We would make that a condition of approval, that you have to meet the fire department requirements. Because we're not talking about having OTCR review these drawings in advance of our decision.
Okay, yes.
Right, because
I'll find out.
we don't get into the weeds about our parking garages.
Okay, yes, true.
Right?
yes.
Right,
Okay. Yeah, as a condition, I have no objection to that.
Okay.
That works
All right.
as well. They will make sure to comply with that. We can also update the EAS and parking study to reflect the change from 30 off-site spaces to 25. I'm sorry, that wasn't picked up. And then we did submit an updated restrictive deck with all the correct numbers in it last Friday. The chair had mentioned, and I think Commissioner Shanda had also mentioned yesterday, potentially including some additional language, whether it's in that restrictive declaration or just as a condition of the board's resolution about if the unit mix should change, that we would come back to the board. And I mean, we have no objection to that. It seems to me to make sense to be in the board's resolution as a condition rather than in the restrictive deck, because the restrictive deck does already provide if we have any less income restricted housing units that we will provide the parking, but whatever the board's preferences will.
Right, it's easier for us if it's in the restrictive deck, because it's a very direct instruction. Otherwise, it ends up getting lost in the wash,
Okay. I will note that the total number of units that's proposed at Forum Street right now is the max density that's permitted by zoning. So there would not be additional units in any scenario that would require additional parking, only if there were less income
So
restricted
this is the
units.
maximum permitted under the zoning?
Yes.
Oh,
Yes.
okay. So that would.
But that wouldn't address it whether they change the mix.
So
That
it
would
can
then
become
impact the
less.
parking.
Right, but in terms of the effect on the parking spaces, since they're at their maximum, right? You're not going to get more parking spaces needed.
Unless they change the
unless they.
mix.
Yes, sorry, I misunderstood what you said.
So it
Okay.
could result in reduction in parking.
Or an
units.
increase, because there could, actually, that's what Lori.
Market rate.
We actually can't
Go ahead.
change the income, we can't reduce the income restricted units, the 20%.
Right.
That don't require parking, because the restrictive covenant that was recorded against the property in 2016 mandates that minimum requirement. So for 421A, we may have more affordable housing, but unlikely there would be any less, there would not be any
So
less
there'll
income
always-
restricted housing.
So there will always be 20%.
Right.
Of the total mix of units affordable, and the total mix is also fixed because it's reached the maximum.
Yes.
So it's hypothetically possible that there could be a change in the unit mix, but it wouldn't be such that it would impact the parking. 'cause
The number of parking.
Right, okay, great, okay.
It may be less parking spaces,
Right.
but never more.
Not more.
But, so I think the current language in the restrictive deck, which I actually don't have in front of me, the language in the restrictive deck just says if the building ceases to have the number of restricted units as shown on the drawings, right?
I can read it for you. I have it in front of me.
Great,
It's, if any of the blank units in the existing building cease to be income-restricted housing units as defined by ZR 1210, or if any of the income-restricted housing units as defined by, this one is for Johnson, sorry, so numbers are confusing because they're not the same, as defined by ZR 1210, and the proposed buildings cease to be income-restricted housing units, declarant shall provide accessory parking as required by the zoning resolution.
Okay, so when we say any of the units, it's because right now, we're assuming a unit count of whatever the number is.
Total unit count 161.
161.
No, but it's 161 total, but it's of the restricted units. It says if any of the restricted units cease to be restricted units, right? So how many restricted units are there?
32. 32.
32 are at 80% or below, yeah.
Right, so are we clear that it's 32 when we, in the restrictive deck, it does break down how many units there are, right, in the restrictive deck?
Yeah, it does.
I'm sorry, I don't have it in front of me. So it
It's
says,
with 32 income-restricted housing unit and 13 units that are not income-restricted housing units, but that are subject to rental restrictions for a term of 30 years. So there are two distinctions that have been made between the two types
We have two levels of
income.
affordability.
And it's the 32 where that's waived from parking. For the
Okay.
13, parking is being provided plus the market rate.
okay, so then I think we don't need further clarification on the parking because you can't reduce the 32.
Right. You can only increase, the only possibility is an increase.
To increase, and you can increase, the income restricted, and you can increase the total number of units because you're maxed out at zoning.
Right.
Yeah.
So therefore, I don't think we need anything more on the restricted deck. Okay, that's a good thing. Okay, keep going.
I think that addresses the comments that the chair made on the Borum Street application.
No, so the other thing I had a question about was the question of the fail on the unit mix was about, on the test B unit mix was about the parking.
Right, and just to clarify that, although I think this is, you haven't decided not to review that, you only have to satisfy one of the two proportionality tests, A or B.
Oh, okay.
So just to clarify that.
Okay. All right, then I think that's it. So was there anything that still was needing to, you said you're going to add a note to the site plan, that's a shame.
Right, we'll remove the extra plan, we'll add the note about the off-site parking. And we'll update the EAS and parking study
Oh, you
just to
need
make
to
sure the numbers
update-
are.
Yeah, okay.
I mean, we can do that all very quickly.
Yeah, could you do it next week? Yeah, next week?
Yes.
By Friday? No, easier, earlier. Next week is, by close of business Thursday?
Yes, we could do
And
that.
submit close of business Thursday?
Yes.
Are there any speakers on this? No.
Okay, so if you submit by close of business Thursday, you'd be on for continued hearing next week, August 13th.
Would it be possible to close the hearing
Yeah, I
today?
think so.
And schedule for a decision?
I'm just wondering whether anything, the EAS is still an open document, right? You need to amend the EAS to
She
coordinate.
mentioned she was gonna.
Yeah, but I can't close when I have an open EAS.
Yes, that's true, that's true.
Right, okay.
Okay.
All right, so,
But we have sign-off from all the agencies, right? So is it more of a editorial?
Yeah, it's just having the final EAS in the final form.
I mean, the effective date will be next week, it won't start or anything, so I think
it would be okay to close?
I think so.
Okay. Tracy.
Welcome back, Ms. Sankey.
Okay, then, I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
So then, next week, it'll be on the decision calendar.
Yay.
Great, thank you.
Item number 15, 2018-55BZ, 222 Johnson Avenue, Brooklyn. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Yes. Thank you.
Nora Martins from Ackerman LLP on behalf of the applicant. So on this application, we heard the board's discussion yesterday regarding the parking demand versus the zoning requirement. While we previously did not provide the additional parking spaces, given that we felt the demand was met separately from the zoning requirement is also met, we understand the chair's concern, and despite the additional cost of providing this parking that we don't believe will be utilized or necessary, we will provide 17 additional parking spaces to total 88 parking spaces at 222 Johnson, which meets the demand generated by Johnson of 63 spaces and also accommodates the 25 off-site parking spaces for Borum Street.
Good, okay.
And we can update the plans to include the same notes to, if you think it would be helpful also to have the site plan for Johnson refer to the off-site parking that's being provided for Borum.
Right, with the distance shown, right?
Correct.
And the same objections from fire department about the parking garage will become a condition of our approval that you have to comply with the fire department's letter of objection, right?
Correct. I think the only copy I have is, I don't have a copy of that letter of objection, but
They
we'll
look
get a
the same.
copy.
They're kind of standard for these automated garages.
Okay.
And ditto for the issue of the number of parking spaces. In this case, you're not, are you maxed out
Yeah,
on the
let me,
zoning
I was
here?
going to say, I want to
Yeah.
confirm, let me get the,
That's what I wanted to know, if they're maxed out.
I don't believe so. I think on Johnson, we did not fully max out the density.
Okay, so in that case,
I don't have the zoning analysis with me, so I don't have that information, but I'm fairly certain that we do not.
number of dwelling units, 271. Yeah, you didn't max out.
And the proposed is 190.
Yeah. So that one, we will need one line on the declaration that indicates what did we say? That, if the number of units changes, that if in some way, I mean, the language will work, the council will work out together, right?
Yes.
But in other words, if units count changes such that the parking requirements increase or, then you have to return to the board, right? Correct? Is that
Yeah.
right? Okay.
We'll work out the exact language.
Right, okay.
I believe that was all that was noted yesterday.
Correct. I'm just taking.
Yeah, I just didn't know if
Okay.
there were any
All right.
further questions.
Are there any speakers on this? No, I don't think so. All right then, so, and in terms of environmental, we're in the same place, right?
No, actually, this EAS was fully updated.
Okay, so, but the restrictive deck, well, the restrictive deck isn't up to date with, no, actually, nothing is up to date with the number of parking spaces actually provided.
Right,
So
right. We will
actually,
have to update all of
everything
those
needs to
things.
be revised.
That's correct. That's correct.
So, okay. So you have to revise the RD, EAS, and the plans. And what did I leave out? RD, EAS, and arguably the parking study. Okay. All right then. I don't know if you can do that one as quickly as you can do Boyram. I don't.
I mean, on our end, we
Yeah.
can, but I don't know if L'Oreal will be able to do
too
that.
much. Okay. So this one, I don't know when to put it.
Is it okay to separate them?
No. Yeah, unrelated. Is it okay to separate them? That's an interesting question.
Because the parking.
Because the parking of one is the parking for the other. How can you separate them?
Feel much more comfortable posting them together.
Well, we can't.
Voting on them together.
Voting on them together. Well,
I mean,
You'll do it. We'll do
They
it.
could stand alone, though, because we're just, but on Borum, we're satisfying the whole demand on-site, and the off-site is
No,
just,
no, no,
it's
no.
a zoning requirement that we will, will be compliant with
no, it's not
zoning.
about demand. You're not satisfying the zoning requirements on site. So it means there has to be another site, the Johnson site, in
Right.
order to satisfy the requirements for the boiler building.
Right,
And
but I'm saying
that
if you don't
buil-
approve Johnson, we'll still have to do that. We'll just
Yeah.
have to, you know what I mean? We'll still be, Borum will still refer to satisfying their zoning requirement at Johnson.
Even if it's a vacant lot.
They've come this
Right,
far
exactly.
together, that's fine. It's fine. I can talk to Ms. Martins about the language for the RD prior to close of business on Thursday. It's fine, yeah.
Well, thank you, I really appreciate
Yeah.
that.
Okay.
So we'll put them both on for for next week.
Yes, okay.
And did you want to close this one?
Can we close, no, can we close this one? The EAS is going to be, it's the same, just sort of
Yeah, there's no
ministerial
order
changes? Okay,
So we will review it. The
Okay.
plan's on Thursday.
okay, okay. So then I'd like to make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye?
Commissioner Otley Brown,
Aye.
Commissioner Shabeta.
Thank you.
Thank you.
We will take a 5-minute break.
Yes, thank you. You know, some people just don't pay attention.
Oh, aren't we doing the adjournment first?
We're back on the record.
Number 16 first.
Item number 17.
Well, 16, we haven't called 16 yet.
We haven't done 16 yet. We just
Get
the
an
school.
older line, I'm sorry.
No, it's-
Okay, item number 16, 2018-136BZ, 251-77 Jericho Turnpike, Queens.
Just to flag, this is a 7344 permit to reduce the required parking.
Yes.
That's this application.
We did not discuss
Okay,
this.
do you affirm
That was
to
the
tell the
statement.
truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Great.
That's fine. No, I did not review it, but I just.
Oh, you thought it was an adjournment. No, for some reason, off the line. Sorry, go ahead.
That's okay. Hi, Eric Palatnik. We intend to withdraw this application. We are not withdrawing it right at this moment just because there are other companion applications that are pending, and we want to just make sure the outcome from everything is the way that we're all hoping it's going to go, so we'd like to let it, and I'm sure it will. But before we just withdraw it entirely, we'd like to just keep it in abeyance, and we have every intention of withdrawing it, and I'm sure all the other applications that are associated with it, when we show you the great information we have, that we're hoping you'll be happy, and then we'll make a formal withdrawal. That's okay.
Yeah. So this will just follow the pattern of the
Of the other ones, yes, and we do intend to withdraw, so.
Great. Okay, go ahead, John.
Item number 17, 2018-137BZ, 251-77 Jericho Turnpike, Queens. Do you all affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Yes. And will everyone sign in? You will.
Project manager? They can have mine.
Hi, Eric Palatnik. We passed up some handouts, and we have our experts here, each specialist, who can go through with you the handouts and what we've done. But what we spent, hello, first of all. We went to your review session yesterday, and we heard everybody's comments. Oh, sorry, Eric Palatnik on behalf of the applicant. We went to the review session, we heard all of your comments, and we spent the last 18 hours, so overnight, putting together this material, which we think addresses a lot of the board's concerns. There's been revisions done to the plans, there've been parking spaces removed, there's been circulation that's been made better, there's been signage that's been both added and clarified, there's been changes to the entrance with the parking area for the daycare separated with some screening, with some clearer signage directing folks. There's been some correspondence that came in overnight from the fire department on this stairway issue, on the rooftop issue, on things, and the hallway issue of the egress. So a lot's gone on in the last 24 hours between what your comments were and what we've tried to react to. We're doing all this. We hope the board is taking note. We're sure you are, that the applicant is desirous of pleasing the board however they can. And that includes, as you know, we just had the previous hearing that is associated with this for the special permit parking reduction. But one of the concerns of the board was the circulation of cars on the site and the parking reduction. You expressed tremendous concerns at the last hearing. The applicant went and complies now fully with the parking at great expense. They've excavated out a portion of the site to provide every single stitch of parking that is needed. So we're not here asking you anymore for what I thought was one of the more cumbersome parts of the application, which was the parking reduction. And what we're here for now is to seek your permission to allow the use of a portion of the premises as a daycare facility, and that daycare is located within a C8 zone, and we're not allowed to have daycare uses within C8 zones. So that's why we're here. The parking lot and all the discussion that we've had about the parking lot, and I just want to call out for the board, we're doing this to make something better that is not even written into any legislation anywhere. There is no drop-off requirement or a parking requirement for a daycare. My friends' children go to daycare. They're all in New York City. They're all in Brooklyn. They are dropped on the side of a road, and they are walked in by their parents. That's it. The cars are double parked, cars are triple parked, and that's because in New York City there is no requirement that we provide parking for daycare. So what we're trying to call out for the board's attention here is the grave efforts that the applicant has taken at great expense, not to satisfy the board by providing parking for daycare, because I could come here with this application for daycare with 0 parking and ask for it, and no drop-off and ask for it, and I think I'd be within my rights, because daycare facilities in New York City, none of them require drop-off. So this applicant has done it because we feel it provides a great service. And Children of America, they're in the back. Raise your hands, Children of America. That's Children of America. They're nice people. They'll tell you a lot of their facilities don't have drop-offs in the city, and a lot of their facilities don't necessarily have separate parking for their customers. But we're providing it here, and the idea of providing it here in the residential portion of the lot is to make things safer. That's our idea, because we know that children are going to come and parents will be much more comfortable in a safe environment. So what we've done, when you're looking at the plan revisions that you've got both in front of you and what we sent you already, is we've eliminated all surface parking except for 2 parking spaces now, and that's within the plan revisions here. It gives plenty of room at the top for the cars to move around, for people to circulate, for the cars to make a turn after the parents drop them off and get out of the facility. We've moved since the last hearing all of the valet operations downstairs to the cellar level, so that all the mashugginess with people coming in and out of the facility, anybody interacting with cars up top, it's going to be eliminated. Now you're going to have things that are going to be going on down at the cellar level. We've taken every bit of advice that you've asked us to do. We had the fire department at your specific request come out to the property, walk through the property just like you directed to have happen, and that's what caused the issuance of the last 3 letters that you saw, which we're here to tell you we will comply with each and every request of the New York City Fire Department that is on the 3 letters that were issued within the last 2 days. 1 letter pertains to the basement with the parking. We will comply with each of the requirements that came out last night. We'll give you everything to show you we'll comply, and more importantly, we'll give it to the fire department, get their sign off and present it to you. The second thing is the egress. There's been a lot of discussion at the board's last review session yesterday about the egress. We are providing an interior staircase C, that's a courtesy stair. It's internal. It's just like at the New York City Department of City Planning at 120 Broadway. When you walk into their offices upstairs in the lobby on the 31st floor, you could walk down a stairway and go down to the 32nd floor. It's not a fire egress stair. It doesn't go to a fire egress. It leads to internal stairways. It leads from an internal lobby to another internal lobby, to an internal staircase. Not a fire egress. It doesn't say fire egress over it. That's staircase, that's hall C. That's C. That's what C is all about. C is not meant to be a direct route to protect anybody. It's meant to accommodate what the board asked for at the last hearing, which was that people move within the space, that the children have their own staircases, that they're secure, that they're separate, and they're not intermingling with other uses within the building. Dina and her team have done a great job of doing that. And to Vice Chair Shampachandra's question yesterday, All the other floors, the cellar floor, the second floor, and the fourth floor are all key-coded, and there's nobody coming in and out. And Dina can sit here and go through the plans with you. She designed it herself. She's been designing longer than she would like to say. She's well aware of this. She's worked with Children of America before.
Sorry, what's key coded?
The staircase, there was discussion yesterday that from the interior staircase, the fire staircases and from C, that there'd be movement into the children's space, Children of America, from somebody who wasn't supposed to be there. And Dina will explain to you that that can't happen because she's put security measures on all the doorways
So,
that will
no, we
prevent
don't need it
people.
explained, we need drawings that show how it's going to
Well, you
operate,
wanna come
because,
up?
no, it's too early to come up.
Okay.
But just let me clarify. The issue with stair C, we know it's a convenience stair. It's good that the convenience stair was put in, because at a certain point, the owner was shaking his head, I'm not going to do it, so it's good that it was done. The issue is that in a fire, people run to whatever there is to run to, right? And if it's a staircase that they're used to using all the time, they will run to that staircase because they know it takes them down to the ground floor. And the issue is, it may send a lot of people downstairs C, and where the egress route is through an occupied space, et cetera. So that's why fire department had their objection.
Well, fire department didn't have their objection. They asked for us to run it from that it was exiting at the, they had no problem with that stair, except their only comment was that it should exit at the front of the building instead of at the rear. And Dina has redesigned things in her head last night to satisfy the fire department so she could accommodate their request and so she could satisfy their concern. And if they're not happy with her redesign, that still leaves it at the rear, she has in her back pocket the ability to still bring it up to the front street, just like the fire department asked. So
Will it be exiting without going through another?
not exit C. At exit C, at staircase C, and Dina's going to come up here and speak to, that is all allowable by building code. You are allowed to have staircases. Like I said, the Department of City Planning, there's no confusion. If I'm on the 31st floor of City Planning, waiting for a meeting, and there's a fire going off, that same scenario that you just described, I could make that mistake like a dummy in a moment of panic, and I could run downstairs to the 30th floor that is not an egress. I can do that. In a building, in a staircase controlled by the City of New York, by the Department of City Planning, who created the zoning resolution. So the very same mistake that you're trying to protect against is in the very same building of the people that crafted the zoning.
That's not the model, please.
Well, but it's a great example. We've all been to 120 Broadway, and we all know.
Children have more value.
Excuse me?
Nothing.
Well, oh, you're saying, oh, I'm making a joke. But the point I'm trying to raise is that I think we're getting very hung up, that they're trying to voluntarily comply with the board's request. There is no requirement in the zoning for a convenience stair. You asked for them to put it in. They put it in a way that does exactly what you were asking them to do. There are fire stairs that are designed and built to code to do exactly what they're designed to do. If there's a fire, I'm in this room, I know to go to that. That has an exit sign. There's a door there I could run through. That leads me into another room and gets me out also, but it's not the fire egress.
So here's the deal. I don't want to argue about
Tell me.
just
Tell me.
fix it, make sure that fire department is happy with
We
the
will.
solution. I'm not going to have a discussion about
we
what
will.
the
Thank you.
firefighters know best,
And
right?
that's how we feel too, and we'll
Okay.
satisfy them. Good, I'm glad, because we had a lot of, we were talking about stairs yesterday until our heads were spinning. So that's the stairs. I guess the next biggest issue your board had yesterday was really related to the traffic and the movement of cars and the sidewalk on the side.
So just go
Yes.
back to the stairs. You talked a lot. Are the drawings modified now
Why
to
don't you come up,
reflect this?
Dina, if you
No.
can?
So, no, you don't need to
Okay.
talk about it. I want to see it on the drawings, and if it's not, it needs to be, it satisfy fire department, okay?
Dina is sitting right here, and she will take care of that. The second issue that I thought, if I could bring it into bigger pictures, well, one of them was, we'll go to the traffic and the movement of cars. School safety. We got a letter back, I think your examiner, Jella, forwarded to us a couple days ago, on the old plans that were sent to the Department of Transportation that had comments on school safety. As you talked about at the review session yesterday, with the parking portion of the application being gone, and the gym portion of the application that's being handled by another firm, having an EAS that doesn't require any analysis of it, it doesn't require an EAS, it's a type 2. We're left with just the daycare, and this daycare doesn't trip any thresholds, as Sydney could attest to. She's got much years' experience with Philip Habib and Associates. Doesn't trip any modal splits or trip generation or demand analysis or any of that stuff at all. I know there was a lot of discussion yesterday about it, And we're happy to try to show the board, we've hired experts, obviously, we've got traffic control measures, but what I wanted to just, we went back and did our own research yesterday after your hearing, after your review session, and the whole discussion about providing more modal split data and providing this data and that data, we had a lot of that engaged around the parking reduction. And that's how we got into that sort of mode about the modal split. But now that we're withdrawing that, we're respectfully asking that we stick to just the Department of Transportation school safety concerns with the safety of the students on the site, because we don't think that providing any more information on modal transportation or anything is really relevant to the applications that we're making anymore. So that...
I think it's once the application is before us, you're subject to seeker, and then, DOT or DEP has to review the issues, right? They look at the entire project in its totality, and that's how they look at whether anything's been triggered.
Right, nothing has been triggered, though. We've done the analyses, the analysis, none of it triggering any further analysis for the daycare facility.
No.
Standing
They
on
look
its
at
own.
the
Standing on its
building-
own triggers any, what's the term I'm...
No, you're
blanking
saying
on?
staying on its own. Let's just stick with how seeker works. It looks like it looks at the project, the no build and the build, right? And so that's what we're looking at. And so it's DOT's review of the project.
Right, so what I'm trying to communicate, I guess, is that DOT is going to get the revised plans back. They didn't look at the new ones. When they're going to look at those plans, they're going to see Sydney's information on the EAS, they're going to see no parking reduction, so we won't trigger any thresholds at that point in the revised application that's going to warrant any further analysis under that component. That's what Sydney could attest to, if you'd like her to come up and speak.
They have it now. They do have it now, and they'll review it, and they said
new
they would,
plans.
yeah,
Yeah, so-
they'll revise accordingly.
Right, so I'm asking to hold off on that part, the modal split, or the information you wanted on the demand
No.
component.
That aspect of it has to do with DOT's review of the materials, right? What they ask for, you should provide, because it'll speed things up, right?
Okay.
Yeah.
What I was really trying to go to is they did review it, and they had some comments on school safety design features at the at the first grade level.
Right.
And some of them we've addressed through our redesign. I guess what I'm trying to say is you had the whole discussion about DOT.
I'm sorry, Mr. Clark. Just to clarify, so the comments that were received from DOT were based on the previous
The old
iteration. So we forwarded the new proposal, and we'll await for the
Well, wait,
comments.
I guess
to
that's
come,
what I'm
And
trying
you'll
to say.
respond to them.
However, you said these were revised within the last 24 hours, so they still need the latest plans, correct?
Yes, we have revisions. Thank you for catching that. That's good. You have fresh eyes on it. Yes, we made revisions last night, and those make it circulation even better at the first floor. So we will get to you the revised plans.
So, to the extent that it's a moving target, then you can't be upset if DOT asks for more
No, I
things
wasn't,
because...
no, I'm not saying, no. Nobody was upset at all. What I'm simply trying to communicate is that the scope that they were reviewing before, I think, was the conversation you were having yesterday about the demand and all that scope and DOT was related to the old plans. That's all I was trying.
I'm sorry, one last thing, just for clarity, so that there's no confusion. And DOT simultaneously was also reviewing the parking reduction at that time.
Yes.
So they
That will be dropped.
will or have been alerted that.
They will be, that's where I was trying to go. So that's the whole circle, is that the whole discussion. We're all on the same page, I think.
Okay.
I don't think we need to.
We'll continue the
We'll continue that conversation. So that really brings us down now. We've whittled away the egress issue. We've talked about the
Before we go to
DOT.
the DOT and egress, where's my threshold question answer?
Oh, of the
How in the
sites?
world is this a 7319 school?
Well, it's clearly, the daycare component is clearly a school. And you're talking about the students that are of grade school age that come in the after-school program?
I asked that
Right
yesterday.
now, and we tried to make it clear in our paperwork, and I'm sorry if it didn't come through that way, we understand that Frank St. Jacques has a pending, he's also working for Children of America, which is the same applicant, the same people that are in the back of the room right there, with the same exact facility where they were asked the same exact question. So he is prepared as ERD1 to the New York City Department of Buildings on the issue, which we have a copy of here, and I'm sorry if our paperwork wasn't so clear. So we're waiting to see what they say. I'm pretty sure customary all across America that kids go to after-school programs at learning facilities such as daycare centers. I mean, it's everywhere. I have friends whose kids go there, their moms work, their parents work, and they go after school, and these are the facilities they go to.
But is it a
So it's-
12-10 school?
Is it a 12-10 school, or is it a definition, is it an accessory? But either way, it would be permitted, because even if it's not a school, it's got to be accessory. I mean, you can't have these
Make
facilities, there's
case.
one on,
So please stop talking.
yeah.
Write down, the comment I had yesterday is you were going to make an argument that it's an accessory to the nursery school, right? So you said it must be accessory, and that was the end of the discussion.
Yeah, but-
Accessory has like some findings, right? Do you hit these points? You didn't even try to hit the
No, because I
points.
guess we were thinking that we were going to get a response from DOB, and that would solve the problem, address the issue, so why go through the exercise? But
Okay.
I'm seeing now, if we don't get a resolution within the time frame, we'll put together, I mean, I could think of 20 facilities just off the top of my head in New York City and Brooklyn that all have this exact program that are not Children of America, that are daycare centers. People send them to them all over the city. So I'm confident that either Department of Buildings will say it's kosher, or I think I could give you enough examples of enough daycare facilities that we all have friends with kids, where they bring their children. I'm sure we've all walked in and seen an 8-year-old boy or girl playing chess or checkers in the corner after school, and that's that kind of environment that we're creating here. So I'm not so nervous about that, but I understand we need to provide it to you. I thought when you said threshold question, I was going to Commissioner Ollie Brown's
Yeah,
comment yesterday.
That's the second threshold question.
Which, and then Frank, Andrew, don't worry, we're coming back to you. So, you made the comment, God bless you. Thank you. You made a comment yesterday, so we tried to make it a little more clear again.
Thank you.
And I underlined in the letter they wrote, the sentence of the years ago. That's,
No need for me, just for the project manager.
so, Zach is here, has been working on behalf of AB Capstone, working with Worldwide Realty Investment Corporation. I have not. But you could, the comment that was made, I think, by Commissioner Ollie Brown yesterday, was that we gave a lot of sites that were just around, not sites that were available. The reason why is nothing was available. There was zero
What's available mean? For sale?
for sale or for lease for a 10,000 square foot daycare facility.
On several floors?
On several floors with a outdoor play area. Zero fit, nothing fit. So the way that we were trying to satisfy the board's finding was to show you that we went out and went to try to find a site and cold called people and approached things and looked at sites and tried to find something to show to you. Trust me, Children of America is sitting in the back. One flew up from Miami. The other one doesn't really want to be here today. They would rather be operating their daycare center right now in one of those other locations. They don't care for Mayor Babayov personally. AB Capstone is not a relative of theirs. They didn't pick this building because they like him or they like his building. They don't care how beautiful the building is. They need a space in this neighborhood in a nice building. So
Wait,
that's,
so
they would have
let's
found
just
it.
look at what you did. Sorry, you want to do this? or-
Oh, yeah, I
Dan?
just wanted to say, what you said and what you wrote are two different things. So what you said was, we were looking for sites that had this, and nothing was available.
Right.
And this is an example of what we looked at. But when you look at this, it's saying, we searched for these sites, and they weren't available.
They were not.
It's
Are we saying the same
slightly
thing?
different.
I'm missing the
No.
nuance, I'm sorry.
No, it's like casting a net looking for availability. Are you available? No. Are you available? No.
Right.
Are you available? Versus looking at a map and saying, oh, these lots here all look like they're 10,000 square feet, but they're not listed anywhere. They're not even available.
But that's what we did. We did a spreadsheet that attached that
Right,
showed
but
you those lots.
You don't mention here that we cast a wide net and nothing was available, and so then we cold called these guys.
I get
who
it. So
weren't
maybe we could
available.
wrap up the whole story and sort of make
Yeah,
it clearer.
because what happens is, even if you don't intend to have that happen here, somebody else can take this and in the next case, literally look at your radius diagram
And use
and
that.
just say,
I
oh,
understand.
there are 40 sites here and none of them
We-
are available.
We will, I
But
understand.
besides that, I'm just looking at the 36 sites that are on this list. And I don't know what the size of the sites are. It's just lot and block number and the address. And it says this is a single-family home converted to a dental office. So I'm guessing it's a 25 by 100 lot. And the next one is, this is a gas station, and this is a Pizza Hut, and this is a home, and this is a church, and this is a Subway, this is a church. How is that a study of what's available that will fit my 17,000 square foot daycare center on 3 floors with
But-
rooftop access, which
Because
is
what
what
they're trying to,
this is?
what Zach did it with the broker, he could, if you'd like him to come up here and testify, he can. They spent a lot of time trying to find places that met their criteria, none existed,
It
so.
just seems like you skipped the first step.
Right, yeah, which
So
is
the first-
the looking, right?
Yeah, if you skip the first step, and that's all I think that.
I'm hearing you, but what's the first step? I mean,
The
I'm
first
just
step is
dense.
saying, this is what I need, looking to see if anything like that's available on the market, and that statement isn't, if I'm not mistaken,
Right.
that statement itself isn't in here.
The affirmative statement is not there, even though they did look, and that's how they got to
And I'm
here.
certain,
but
it seems
I
clear
get-
that they looked. It
Okay.
seems clear that they looked. I think. that
I
since we are
understand
going-
what everybody is telling
I
you.
don't feel so clear that they looked. I feel more like they produced data from one of those
From
great
radius
easy.
diagrams,
Yeah,
right.
because like, what's the catchment area? What I see is this shape, whatever that shape is, and I don't know what the catchment area is for this particular daycare center. Who's the target market? Where's their nearest other one that they would be overlapping, which wouldn't be good? We don't know anything about it. How did you get that shape? Normally,
pick
we
this?
look at, for instance, with a lot of the schools, like charter schools, for
Right.
example, that's really simple. The charter school says, we need to service the kids in census tract X, right? Or community district Y. It says that. Or more importantly, school district Y, right? And so there's school district Y. We can't service school district Z because we're already servicing them, or a competitor is already servicing them. So we need to make sure we have a catchment area. Your site is on the edge of a catchment area, so I don't understand, why aren't I seeing more
I think.
more
yeah,
stuff in
I
this
think just
radius?
Expounding on your oral statement that they identified this location, this area that they want to service, why, and then the steps that you take to address it.
Right, and then also, as I think expounding on what the chair said, when you list all these people that you called, there's got to be a reason why you chose them.
Yes.
You got to state why. Like, we were looking for 17,000 square feet on 2 floors, blah, blah, blah. Lot 1 is 3,000 square feet with a possible FAR of 5. We thought that might be a good fit, but the guy has a house on it, doesn't want to sell the house.
I understand. We left a lot for us, that we didn't fill in the blanks enough.
Right. But to that point, there's no way to putting a daycare center on a 25 by 100 lot, right?
Well,
You're
that was
just not
one of the-
even going to look at it.
That's one of the problems. They came, you're in a neighborhood here of really, there's the commercial strip and the smaller homes behind it. So that's, you're limited to Jericho Turnpike.
You
really.
don't have to have 36 buildings on it. Most site searches have like 10, 12 buildings
Right.
on it because they're thorough in what they're looking for.
I'm
And there's a
understanding
thorough
what you're-
analysis of each one.
I'll have them go back through the data and I'll have
Right,
them. look
but
at their
I just
records.
want to also say that if you were going to a real estate agent and you said to the agent, I'm looking for 17,000 square feet with rooftop access or rear yard access, and the 17,000 square feet can be on 2 or 3 floors, but if it is, it needs to have an elevator, or the owner has to be willing to put in an elevator, or the owner has to be willing to add a floor, or any of those things, what do you have for me? That's how a real estate agent would work, right? And then the agent goes out and talks to the other agents in the neighborhood, and then they show you 5 sites, right? As opposed to this, which is kind of trying to back into something, which is not really at all what this regulation is intended to do. The regulation says, we don't want you to put a school in a manufacturing district. We want it in an R or a C district. So you need to have proven to us that there's nothing that would be appropriate.
And we will, and we'll meet the regulation.
Okay.
I think in your initial submission, you had a map which had
We
the
did.
square footage, so you need to marry that with the Excel spreadsheet and go through each one of those justifications.
I understand what you're telling me.
Okay.
I'm cleared up now. That I think brings us really to the parking and the movement of, well, the movement of vehicles, I should say. So why don't you come up, Andrew?
Can I just, before we move
Yeah,
into
sure.
parking, my comment was not with regards to staircase C, my comment was with regards to elevator B.
Okay,
And the comment was that it wasn't clear from the diagram whether elevator B was stopping at all the levels, given that this was going to be an exclusive elevator for the daycare.
This is Dina. Dina, introduce yourself.
Hi, Dinah Clamert. The elevator B is stopping only on the first floor, the third floor, and the roof for the daycare access. It's locked on all other floors.
Okay. So I think we would need a note of...
No, more than a note. So, yeah, so we have, and we can give an example. I don't know who's in charge of the security system for the building. I don't know if we should be talking to the owner or to the daycare operator, but it's very standard for us to have in schools that are shared with commercial uses, that the staircases, the elevators, all the means of egress are signed. They have cameras in them, they have alarms in them, so that the daycare operators can know, or normally it's the school operators can know, that someone has entered into school turf, and also that the people in the rest of the building, the commercial users, know that this is not an accessible route. You're not allowed to be in the staircase or even try to go in, except in an emergency, and an alarm will sound if you go in. We need a full security plan, and if you need an example of what one looks like, we can share. Otherwise, if you already know what one looks like, then please give us that, okay?
We will, yes, we'll address all that, and just for your knowledge, all the stairs are locked from the inside. They're only accessible from the tenant side with a push bar and keyed from the interior of the stair to that tenant with cameras and security systems, but we'll give you all the relevant information.
How would how would they enter, say, the third floor? Is there an attendant who's unlocking the door?
Who's they?
Any from, if it's...
They're escorted by
They're
members
escorted.
of the
And
Children of
so,
America.
You'd imagine a supervisor or a teacher would be the person with the key to unlock the door.
Correct.
And so there's no attendant on the other side of that door?
Not necessarily. So basically, the reason for keeping the doors locked, they're exit only, no re-entry.
Okay.
They're strictly emergency exit stairwells. So say that the medical office enters stair A. They can, because they have a push bar, but they can't go back onto that floor, even to their own space.
And they wouldn't be
if
able
they're
to get
if they're a patron or a customer. But if they're the tenant, they have a key to get back into their own floor. That's typical for the daycare as well.
Okay, and they wouldn't be able to get onto the other floors?
No, once you close the door behind you and you're not part of the staff that has a key, you will not be able to re-enter that floor.
Okay, so that's true with stair B.
Stair B and stair A, both egress stairs.
Okay, so this is, you're with the daycare center, right?
No,
Are you building management or daycare center?
Architect, engineer.
Oh, architect, engineer for the whole building?
Yes.
Okay, so here's the other issue. The medical facility and, not probably the PCE, but the medical facility is split on 3 floors. And it's my experience that medical facilities, the doctors decide they're going to rent either the whole, one set of doctor rents the entire thing, so labs on one floor, offices on another floor, or you go and you get one kind of an examination here and you go for another one, and the staff in particular, but often the patients, are using the fire stairs as a convenience stair. So what you're suggesting about locking it from the inside, in the end, isn't going to work for the medical office, because I predict, and I have direct experience with this, that they end up doing things like putting duct tape on the locks so that they don't lock and so they swing freely onto those floors. So the issue then is, how do you make sure that there's no access by the older kids, say the 8-year-olds,
the 10-year-olds, because we're going up to 12 years old, right? By the older kids onto other floors, and by adults onto, well, let's say, non-daycare related people onto the daycare floors. That's the security question. You don't have to answer it now, but that's the security question, okay?
Okay.
All right, thank you.
Good afternoon. For the record, Andrew Valeri of the firm Stonefield. I listened to the review session yesterday, and we have worked overnight to come up with hopefully some solutions to a couple of the items that were raised yesterday. And really, what I'd like to start with is the design rationale with how we laid out the outdoor parking space. We had 3 goals in mind, and these were themes of the conversation held at the executive review session. The first of which is pedestrian safety, the second of which is traffic calming, and also the third and most importantly is to reduce congestion off of Little Neck Parkway. That was something that was discussed at length at the community board. So considering the 3 goals of this, we came up with the plan that's on the easel right now. We've also distributed handouts to you. Hopefully this is a clearer delineation of what signs we are proposing and also the striping. So a couple of the engineering methods that we sought to implement here to reduce traffic and promote pedestrian safety, because when you think about it, the crosswalk in this parking lot isn't all that of an uncommon environment for New York City. It's any unsignalized crosswalk that you'd see on a public street or, in this case, on private property. What we sought to implement here are 2 things. We have a raised crosswalk, and there's another 2-sheeter from your packet that comes directly from the city's DOT Urban Street Design Guide, and the second of which is a chicane, or what I like to call is a bottleneck. So on this plan, you can clearly see where the crosswalk is going to be, and it's not just any crosswalk, it's a raised crosswalk, so it's also commonly referred to as a speed table. It's 6 inches raised off of the normal asphalt grade. There's a ramp up and a ramp down, similar to an expanded speed bump. Another benefit of this is that cars have to slow down going over it, speed bump. You're more cognizant of pedestrians crossing in front of you. It also is beneficial for pedestrians because it's at the same elevation of the sidewalk on the top side of the page. A couple other things that are different on this plan than what was previously submitted to you is the hatching that you see in red dots and also yellow. The red dots are meant to better emphasize what we're proposing. They're bollards meant where there's going to be a safe area for pedestrians where any car that's not paying attention can accidentally, God forbid, run off the road. The safe areas are delineated in yellow. They're on the top side of the page. You are on a physical sidewalk. You're protected by curb and also these bollards. And then in front of the entrance to the daycare, you have an area that has flush asphalt with the entrance to the daycare building. And you're also protected by these bollards again. So another thing that we looked at was to make sure that we had adequate maneuverability for regular passenger vehicles to use the daycare area, which is on the top side of the plan. This is the residential district where no commercial traffic can be. That's what Mr. Palatnik was mentioning, that we're seeking to provide an added amenity to this tenant by providing a drop-off for the daycare when we're not required to do so by zoning. We looked at how a typical passenger vehicle could circulate that area. And this exhibit was also provided in your package. I just want to flip the exhibit.
Well, okay.
The path of a typical passenger vehicle is shown in the red outline. And you see that we previously were proposing 4 parking stalls parallel along the building. What we found is that in adding on, or parallel parking along the building and 3 feet of sidewalk along the building, really, what's only feasible is adding 2 parking spaces on the building. So that's 7 in total for drop-off pickup for the daycare, which is still going to be enough. Now, we've talked
Sorry,
already.
what, it was only feasible because why?
Because compared to previous plans, right, this isn't all that much different than what previously had.
I know, I'm
But
trying.
now, the changes include parallel parking along the building and then also 3 feet of sidewalk along the building.
No, but you used to have more parallel parking. You said you reduced it because why?
Sidewalk.
No, not because of the sidewalk.
We made this swing, right? This is the path that a vehicle would take. It's basically making a 180-degree turn.
Okay.
And in providing parallel parking along the building and also sidewalk, we're losing width, and that's what's needed to make a 180-degree turn.
So in other words, the car was going to clip a car parked
Exactly.
there,
If there
so
were-
you needed to,
Yeah, previously
because you
we had
couldn't
2
make
more
a tight
spaces.
turn, right?
Previously, we had 2 more spaces, and that turn's not feasible for, minivans that may be using the daycare center. So we wanted to remove that, only provide 7 parking stalls for the daycare, which is still enough, right? And we've talked already about eliminating the parking reduction application. The parking for the daycare isn't considered in that application. There's none required by zoning, so this doesn't have any impact to that.
But my problem is those 3-foot sidewalks, which is the comment I had yesterday.
I heard.
3 feet isn't enough for a wheelchair to get out of the car and move along. 3 feet's an extremely narrow sidewalk, especially when it's right up against a building. It'd be different if it was, bordered on 2 sides by planting. But I don't understand how you think 3 feet is like squeezing between the car and the wall.
Respectfully, I disagree. So we do a lot of work for ADA accessibility projects for private developers all over New York City, making sure that they provide ADA access to their storefronts. We do this not only in New York City, but all over the Northeast. So I'm very familiar with the ADA code. And what the ADA code speaks to, and when I'm talking about ADA code, I'm talking about the clear width that's needed for specifically a wheelchair. I mean, that's what the ADA code is based on. 36 inches is the minimum that's required per ADA code, and in certain instances, you could actually be reduced to 32 inches in width. So that's based on ADA code, it's the industry standard, and that's what we're providing here. So it's also important to note that the facade of the back of the building is flush along the building. There's no columns that stick out for any architectural features, so there's never any inhibitions to the clear path of travel here, and 36 inches is actually enough for wheelchair access. What else? So let me flip back. So some additional signage that we are proposing now is to make it abundantly clear how vehicles are accessing this facility for different uses, right? You have a mixture of uses that would be using this area. As Mr. Palatnik mentioned, improvement on this plan compared to previous plans is now that the valet drop-off and pickup area occurs in the basement, right? There's never a scenario, or I'm sorry, I should back up a bit. Our previous plan called for the valet drop-off and pickup.
Sorry, I need to go back to the sidewalks.
Sure.
So there's 2 cars parked there. They open their doors. Now what happens?
How long are they opening their doors for?
There's a person walking and the doors are open, and the doors, how long are the doors on a car?
How long are the doors on a car?
What's the swing on a car door?
About 3 feet or less, 2.5 feet.
So it hits the wall, right?
Perhaps, if you want to open your door that far, if you're up against the building.
I see where you're going. I clearly see where you're going.
I'm just like, it's very obvious to me that 3 feet's not enough along that edge. And particularly because you're using it as, the issue here is that this is the front door of the daycare center, right? And it's a very strange, the whole thing is strange, right? And you're saying, oh, we don't need to provide drop-off parking or anything, but look at how you get into this daycare center. It's through the access to a parking garage, right?
Right,
It's
so you got
through
the
the
2 uses
access to
simultaneously.
144 parking spaces, and I, as a person delivering, let's just say, kid with stroller, kid walking along, so a kid holding onto a stroller and walking along while the guardian pushes pushes the kid is wider than the 3 feet, actually, and then the car door swings open. Yike! And so that's called dooring the kid.
No, I hear what you're saying.
Right, so, I look at that and I say, get rid of those other 2 drop-off spaces because I think it's terrible.
Yeah, that's what I was about to say.
Right, and I also think,
That's what I was about to ask the architect. If we could kill a couple spaces, that would free up a little more room. So you're talking,
look at that
Eric
thing.
Palatnik.
There,
So-
look at that.
Yeah, I'm hearing what you're saying, and I wasn't looking at it through the lens of that, and you're right. So if we kill these 2 spaces here, that will give
Give
you,
you a 5-foot sidewalk, like a normal person's sidewalk.
we can do that.
Then you have more room to
Yeah.
maneuver to get into
We can
the
do that.
parking garage. I don't understand the point of that
We can do
thing.
it. That's
And then I would look at also that this is a comment that I had before, so it's exactly the same thing. You're walking along this wide sidewalk where you unloaded the kids from the car. You want them to be on the sidewalk. I can't believe they'll go on the sidewalk, but let's just say. They go on the sidewalk, and then you're asking them to make a sharp right turn on a narrow sidewalk. I'm not doing it. I'm walking directly into the street, into that driveway, and ignoring your speed bump raised platform. So I don't understand why that's over there. Why don't you slide that thing, that special raised platform to if that's the east? I don't know which way's
Why
east.
don't you go over with the mic and that way you can...
That's east? Yes.
Yeah,
Slide
so
it
you're
over there.
suggesting move which portion, this?
That striped thing, move that to the east so it lines up with the big wide, no.
Move
I'm
it-
I'm talking about the curb that is the sidewalk
Sure.
now that's bordering the parking spaces.
So basically, just move this and make it line.
Make it straight.
Make it straight so that the continuation of the sidewalk.
Yeah, there you go.
Yeah. You don't have to make another right turn and then get into the
Right.
crosswalk.
So
Just
we-
go straight to the
Understood,
crosswalk.
understood. That's
Right.
definitely possible, and we can look into that.
And then you just have a wider access area for the daycare, right? And
A
then the
wider
next
access, you're
part
talking
of-
about the yellow area, right? So
Yeah.
basically
Yeah,
drag
so
it
the
this way a
yellow
little bit.
area is bigger. The front door, I know that there's a fire exit there somewhere. I don't know which one is the fire exit.
The daycare entrance is on the left side, west
Yes.
side, and then the exit from the fire
Door,
stair.
but that's an emergency exit. The door arguably isn't open. So, right.
So we can do that. What we saw with this plan is to minimize how long the pedestrian crossing is. And in this scenario, and we could totally maintain this by just shifting it slightly to the east, the pedestrian crossing is only about 13 feet long, right? So that's the only space where vehicles and pedestrians could possibly be is 13 feet long. So we were listening to some of the initiatives that, the city is currently ongoing, Vision Zero, you hear about it all the time, to minimize spaces where pedestrians and vehicles could potentially conflict, and that's what we're doing here. So if we wanted to make a diagonal crossing directly, we wouldn't do
No,
that.
no,
It
no,
makes
no,
it
no,
possible.
no, no, no.
We're going to shift it.
Basically,
to the
just
right.
take-
We can
yeah.
definitely do that.
Yeah.
We can definitely do that.
Right. And since you've got a sidewalk now that goes all the way across, that's the other part I don't get. You've got a sidewalk, and then all of a sudden it becomes at the grade level of the roadway. That's weird. So instead, what you're talking about is wanting a ramp that goes up for a stroller ramp, right? Instead of being in the roadway, you should be on a sidewalk the whole time with simply a stroller ramp that's coming up, as opposed to making you feel like now you're in the roadbed.
I understand completely.
Okay.
But the thing is, that's why we proposed the bollards. So why we had to do it this way by providing pedestrian ramps is because the foundation of the building is there. Flush floor elevation, it's there, right? The plans were designed for this outdoor area to be asphalt, right? It's flush between the entrance to the door and the entrance to, or the asphalt area, right? So the door opens out, right? If you have a 6-inch curb there with sidewalk, door wouldn't open. You'd have to, I don't know how you would do that.
So you're
that's why.
saying that grade and the first floor are the same elevation? There's no change in level?
Correct. So that's why we had to keep elevation here and the elevation of the foundation building the same, so that's why we did this ramping scenario, and that was for the wheelchairs, for the strollers.
Can you on the drawings indicate that? Because for one, I won't remember, and for two, it's really not clear that what the elevations are, finished floor, exterior, so that we can understand that you're doing that to get into your own building. Okay.
I think, correct me if I'm wrong, maybe you shifted it where you did, A, you wanted to align it with the school vestibule.
Correct.
And B, the ramp up that is going to happen, it's going to be in the way of the turnaround. So that triangular piece, that's ramping up to that crosswalk. If you moved it to align with the sidewalk.
No, it'll still clear it.
That'll still work.
Right, would it? No, this would be then in the middle here, if this is lined up.
Oh, you're saying that little triangle thing would be there.
Yeah. So I don't know if that's an issue.
I don't believe it is.
Oh.
But we'll revise the plans. We're going to have a 5-foot sidewalk along the building. We're not going to have any parallel parking along the building. And we're going to show some elevations of finished floor and also the asphalt outside.
There is that advantage.
But it doesn't really separate them because all the cars are coming this way.
That it will, either way it will not. No, I just thought I saw. Here you have worst of all two. Here it worst of two.
I have a question, though. We're talking about, because again, it's so strange, you're entering a daycare through a parking garage. It's just totally strange,
Well, you're
very
entering
suburban.
through a parking garage.
It is. The entrance to the daycare is through the entrance to a parking garage. It's
Parking lot,
just
right.
true.
It's a parking lot, right? For the
Well, it's
outside,
not a
it's
parking
just-
lot, it's covered over, is this open to the sky?
It's
or
open to
this
the
is
sky.
covered?
to
Open
the
to the
sky.
sky, but still,
Just a
it's an
parking lot.
active driveway for a parking garage, right? 144 cars coming and going.
Just because there's 144 cars required per zoning doesn't mean there's 144 cars.
It doesn't mean there aren't 144 cars, right?
I think we've
It can
proved already that it's not.
accommodate 144 cars, assume someday it'll accommodate 144 cars, right? So, but anyway, what I was wondering is whether there could be maybe, when you have at your stop there, somewhere in this story, a drop gate, so that the cars can't keep going, that there's a timing and a signal, and the parents who are crossing the street or guardians know that, okay, now it's safe to cross with the kids, right?
So we considered that exact idea. We considered even like a green, yellow, red type scenario. The issue is that we have a constraint, how many vehicles we have to queue before the driveway on Little Neck Parkway. So what we opted for instead of a traffic signal or a gate was to have this scenario where we're creating a bottleneck, so people are slowing down when they get to the crossing. We created a speed bump where it's safe for pedestrians into a very short crossing, to also mitigate that same scenario that you have with signalizing these.
Where's the first speed bump?
There's only one speed bump. It
The
is the
speed
crosswalk.
bump is, well, I hit the pedestrian, I hit the speed bump.
You actually, so it's a two-way drive aisle. It's a two-way drive aisle right here.
Yeah.
This is less than 14 feet wide, right? It's narrow in terms of a scenario where you have to have two ways of traffic, right? If you consider your car here after you go through the stop sign, right? You can't directly drive straight because you'd run into this bollard right here. Right? You have to be careful of the oncoming speed bump, right? There's a lot of signage, right, that we're proposing where we say yield to pedestrians. Another thing that came up in yesterday's review session, which I want to get to, and I think it is going to answer your question, Madam Chair, is that in the last hearing for this project, which now is 6 to 8 weeks ago, one of the items that you said, it resonated with me because you said that architecture speaks, right? And in my opinion, engineering can also speak, right? And proposing this raised crosswalk, proposing a bottleneck where people have to slow down before they get to the pedestrian crosswalk, those are engineering techniques, right? And in addition to engineering, what we could also do is provide enforcement. So what the applicant has decided to do, based on our consultations and one of the comments raised by Vice Chair Chanda yesterday, is to employ a crossing guard for this area. And that would make sure that parents with children are using the sidewalks and using the crosswalks that they're supposed to, and people that are driving through the area to the valet downstairs, they're not ripping through here, they have to be slow being mindful of pedestrian crossing.
But that's no longer architecture or engineering
That's
speaking.
enforcement. So that's when engineering may not be enough.
That's when engineering isn't enough. We don't like it when engineering and architecture aren't enough. That's the whole point, because this daycare center may, at the moment, be up to speed, and then the next thing you know, they need to cut back, it costs a lot of money for a crossing guard person, et cetera.
Where can we put a gate?
I would say put a gate.
What's the difference? It's a gate. It's a building.
Or at the very least, yeah, it should be something so that people feel safe.
What if the crossing, we'll
It's
have
an
the crossing
automatic
guard. We
gate.
thought that the commission, Vice Chair Shonda had a good idea, but if the crossing guard goes and gets a cup of coffee, there's nobody there. So it would be, a
Right,
gate
so
would be
the
good.
gate might be triggered by, I'm not sure how it works, a push button?
Pedestrian arrives to either one of these yellow areas, there's a button.
Mm-hmm. That's one.
Would you still keep it as thin as it is now, or would it get wider?
How wide the crosswalk is?
Yeah.
So the thing is, I don't think that the width of the crosswalk would be the issue here. If we keep the stop bars as they're shown, right, a vehicle wouldn't be at all close to where a pedestrian would be crossing.
How wide is the crosswalk now?
It is, I believe, 6 feet wide.
Yeah.
So two cars wouldn't be going through at the same time?
No. Right, so this is, I was talking 6 feet wide this way.
Okay.
It's 14 or
14, that's what I
feet
thought.
long. So, right, so it's
14.
impossible for two people to cross without only, waving the guy on in front of you or going slowly around.
So that leads to the other issue that the community board had, which was the fear of it becoming congested. And how do you address that?
Can you talk closer
I'm
to
sorry.
the mic? I can't hear you.
That leads to that second question of the question of the community board, which was congestion as the traffic surrounding the area. If we're bottlenecking and we're making this, there's going to be a lot of cars queued there at certain hours of the day.
Right, 'cause if you
Popular
have-
gym times, popular daycare times,
If
right?
you have more than 4 cars waiting at the gate, that's dropped. You start having backup on Little Neck.
So
That's the issue, and one of the reasons why we, so far, have opted not to do that.
Well, that's it.
So
That's also why we have a crossing guard going too. So I think a combination of the engineering and the human factor, somebody's aware that there are people waiting and they can address it. We could do the gate as you're suggesting.
The fact is that the crossing guard, if doing the right job, would have the same effect, let's say, the same effect on traffic buildup as a drop gate. So whether it's a guardian, a parent effectively, the caretaker, pushing a button saying, or maybe there's some kind of, it's tripped by a motion sensor or something like that lowers the gate. It's the same as the guard who walks across and stands in front and doesn't let the cars come until all the kids have passed, right?
Yeah,
It's
but there's
got the
not going to
same-
be, there's only 7 spaces there. So it's not as if you're going to have 50, I understand what you're, and I'm kind of, as you're telling that, I'm thinking like a school letting out and like 100 kids lined up waiting to cross. You're coming in, you're limited by the number of, and the chances of 1, 2, 3, 4, 5, 6 cars all coming at the same exact time with 3, there's going to be one kid. So I guess what I'm trying to say is, it's naturally going to be a flow of a couple of kids coming, a couple of kids coming, a couple of kids coming.
But it's
not
going
going
to
to be a constant.
If the drop-off, the prime drop-off times, would we say, it's like 9 a.m. or something like that?
No, I think it's earlier for the daycare. The
6 to-
daycare is earlier. The
6 to-
daycare is much earlier than everything else.
So as I have it in the program, it runs from 6 a.m. to 6:30 p.m. and students arrive between 6 a.m. to 9 a.m. and leave between 4 to 6:30 p.m.
Yeah.
Right. So, and what you're talking about is, so therefore, this 3-hour period of parents coming and going, or, coming and going and parking in there, then taking it out, there's supposed to be a 10-minute turnaround, right? 7-minute turnaround. So you do actually potentially have a lot of activity there, not to mention all the people who are coming for their doctor's appointments and going to work out for the gym, right? Gym, 6 a.m., we know that, right? 6 a.m. to 9 a.m. is prime gym coming and going, right? And we know the doctor's appointments depends on the doctor, could start at 8 a.m. or even earlier, right?
No, there's definitely
So
some
gonna be a
overlap, but all I'm
convergence.
suggesting is that the 6 cars or the 5 cars that are up there won't bring a mass of people coming across that crosswalk that'll be enough to jam up that crosswalk, just by common sense. There's just no way. You won't have all 6 cars showing up at the same time. That's nearly impossible.
But so what's going to happen? All 6 cars, let's just say, because it's there, all 6 spaces are occupied.
Right.
So now what you've got is, you've got daycare drivers coming in, they don't see a parking space. They drive into that little drop-off area and they double park or something strange. You know, they park just there because it's only going to take a minute, right? Or they swing around and they park where they really shouldn't park, which is on the exit route from the garage. I mean, you know, some of this is just reality. You're putting a lot of pressure, you know, I just keep going again. It's an incredibly dense, pressured spot.
I understand.
Which, by the way, see, you know what's annoying about this project is it's all a function of the order of the leaseholds, right? Architect innocently designs a building, and then what do you know, gets a call from the client, I know because this has happened to me, gets a call from the client saying, you know what, we just got a call, there's a gym that wants to move in, or doctor's offices want to move in. So you could quickly figure out where the front door is for this, and so the daycare center, which should actually have a front door down where the gym has its front door, actually, because this is a much better entrance location for a gym where there are adults who can take care of themselves than it is for a daycare center. So all of this is the accident of the leasehold, and I find that particularly annoying because it is creating a crazy dense situation where you've got tiny kids involved in the story.
But the flip side is, and I understand your concern with that, the flip side is, first of all, we've eliminated the pressure point of the parking, the number of spaces. The drop-off area, I can't accentuate enough, it's voluntary. It's voluntary. If your board were to decide that you don't like that, we can nix that from the application entirely, and then it would be just like any other building in New York City. We don't have to provide the daycare drop-off. We thought it was great. We think it's providing a benefit. It's not in the code, it's not a requirement. You obviously have never granted one probably that even has any at all. I'd be surprised. I don't remember doing any that have any. So if you were to say to us, you know, I don't feel this is safe at all, then let's just nix the daycare drop-off and let people do what they do at every other daycare facility the board has ever acted upon. Let them fend for themselves on the streets and let them bring their kids in. That's what's going on everywhere. So that's not, you know, I'm not trying to, we don't want to put the board in a situation where it's a dangerous situation, where you're approving a dangerous situation. I don't want to make it worse. But by the same token, we kind of feel like we have enough space here. We've got a nice thing that could be a really nice service. I know we're backed into it a little bit because we built the building, but we've got these extras, so to speak. So there is a solution. The solution is very simple, that, you know, we'd have ample room to make a nice sidewalk there from the street, and it'll be just like every other building in New York City where people walk into the building, either through the side door or whatever door, and there'll be a
True, it gets rid of all the
It eliminates a
problems.
lot of your problems that you're talking about, and if that's what you wanted to see. I personally like this. I think that it can work. I don't see the volume of people rushing into the gym at the same exact time. I don't see everybody. I think that you're going to see a much more natural flow in the morning. I think the daycare will be the rush in the morning. Every parent is crazy with their kids in the morning, that's for sure. But after the daycare is in, people aren't crazy to go to a gym. Then, you know, they're
Not based on the gyms we've seen crazy to go to.
Well, maybe. But you get what I'm saying. I mean, we'd like to try to make something work here. I think Frank has some, Andrew has some creative ideas. Sorry for calling you Frank, your predecessor. I think he's got some good ideas, and we're malleable. I mean, whatever you want us to do, remove cars, create a sidewalk, put a fence in, put signage in, put a gate in, speed bumps, whatever you think will work, we will do.
Interesting point.
Yeah, I think I actually, based on what you have just said, I personally think having a drop-off area, in this neighborhood, I know we have not seen daycares with drop-offs and everything because they're in a much more urban area where people are walking or on the way to work, that type of thing. Here also, it's probably on the way to work, but people are driving on the way to
more
work.
suburban.
Work, I'm sorry. And so to keep in mind that this is also going to affect the larger neighborhood and the traffic circulation, I think having a drop-off area here
We agree.
serves the larger purpose. And so I would be in favor of wanting to keep the daycare drop-off pickup to the minimum, to the number that you need that would serve in terms of based on your calculation, number of turnovers and all of that. And I mean, and you need to provide the necessary security system within it to secure the children and the parents crossing that portion. That's really how I see it. And I think we are working on it, and you have some ideas, and I would, I would like to see those alternatives and solutions.
And Frank, Andrew is very, calling you Frank, Andrew's got some good ideas, and I think if we accentuate those a little bit more, maybe if he interplays those with some of the arrival times that we just went through.
I think that would be helpful.
Maybe gives you a little more edification on it, might help.
I think you had provided that as part of the parking
We did.
waiver.
Yeah.
So you may want to
We have all that
extrapolate from that and indicate when the peaks are and how
Lay it
during
out a little
those,
bit.
yeah, how during those peaks of vehicular conflict, would you be taking care of these situations? And I think I would be for one, wanting to make sure you have those safety provision all throughout while the daycare is in operation.
Okay, yeah, no, I agree that getting people off the street is important, but you've got this.
We got to do it in a way that's
And
works.
so you still have school safety to deal with on this subject also,
Yeah,
right?
they're going to give us
Right.
probably
Yes.
they saw this plan, that's what I was trying to say earlier when we got into that whole discussion. I wasn't trying to confuse us, but what I was saying is they saw the concept plan at least. They had the idea. They saw there was a drop-off area, they saw cars coming through, they saw the driveway. Their comment that the letter that we did get, none of them were like, this is horrible, don't do this. They had constructive criticism on it. So I think with your comments today and what Frank is up to, Andrew, third time I'm calling you Frank.
Third time is a charm.
Yeah, sorry. We'll get somewhere.
Okay,
Andrew.
all right, so,
And I have, this is just my little pet peeve. Why do you have a sign that says valet parking? Why don't you just say parking?
Because when you get to the bottom of the ramp, at the end of the road, so to speak, you have to valet your car because of the stackers configuration that we have in the basement.
Right.
why can't you just say automatic parking or something like that? So the
So it's
concern
attended
being
parking.
valet sounds fancy and sounds like it's going to cost me $25.
Sorry,
right?
say that one more time?
Valet sounds fancy, and it sounds like it's going to cost me $25, and so I won't do it, right?
It
But
might.
if you say automatic parking or something like that,
Attended parking, is that better?
attended parking,
Yeah.
attended parking.
Attended.
Right. Okay, I don't think are there any speakers on this? There are, okay, fire department.
Good afternoon, John Daly, Fire Department. The department objects to this plan, the layout, especially in that the means of egress for the daycare is exiting out the rear of the premises. In the event fire operations have to respond to a fire at this location, normally we have an engine and, no, I'm sorry, 2 engines and a ladder. Because we have a daycare, we double up everything, 4 engines and 2 ladders. And we'll be stationing off of Jericho Turnpike, a Little Neck Parkway. So the incident commander can observe his men or woman entering the building to especially go to the 3rd floor or down to the cellar where we're going to have parking stackers. Having people, the daycare exiting out to the rear, into the driveway, firefighters coming into the rear of the building, we believe it's a dangerous condition.
So you're talking about the fire exit?
The fire exit, yes. That we would like to see, well, we appreciate they put the stair C in as an access stair, not a convenience stair, but we would like a corridor be constructed out to Jericho Turnpike. So in the event that we have to respond, we'll break the door and get up to stair C and up to the third floor, or from the rear of the building. So, I mean, we're asking for what, minimum 3'6" wide passageway to stair C from Jericho Turnpike.
Okay. So if I'm, based on what you're saying,
Yeah.
so right now, if there's a corridor, it's kind of like the snake-shaped corridor that goes from Jericho to the rear.
And that's right.
You're saying
From
instead of-
stair C to the rear, yes.
C to the rear.
Right.
No, it doesn't
C
go
to
all
the
the way
rear.
to...
Well, no, it doesn't go to the stair, it's from the stair A, one
No,
has to.
he's saying from stair
Stair
C,
C.
convenience stair, he doesn't like that it egresses to,
Back into the
back
daycare
into the space. It should egress.
Into the, what is now called the medical office lobby.
No, the retail. At the first floor, so we come to the first floor of stair C. So you could enter the daycare center, but, which is okay, but we'd also like to be able to exit directly to the retail space, directly out to Jericho Turnpike.
Through an occupied
Okay,
space.
okay.
It's not occupied right now.
No, it will be occupied.
Well, we'd like them to take at least a section of that retail space and make it an exit passageway.
So in other words, you exit stair C, and instead of turning left into the space for fire egress,
Right.
you turn right into the retail where you have a parallel
Unless you turn the
fire
staircase
corridor.
around.
Yeah, you can turn the staircase around,
And then it just
something
exists.
like that. You got it?
That works.
Okay, okay, good. So as
This
long as
one
you got
works.
it.
This one works?
So we'll be able to exit into back into the-
That'd be fine. Yeah,
That
yeah.
would be fine.
Fine
Okay.
with us. That's, you
Okay.
guys have to work this out, okay?
Okay.
We'd have no objection.
Okay, good. As long as the owner's willing to. Yeah, good, all right.
Listen, we are trying to satisfy everybody.
All right, so you have, and are there any other speakers on this? Okay, so you have your various marching orders. You can see they're still coming up with creative engineering solutions, not just human body solutions, for how to reduce the conflict there while maintaining however many that is, 5 parking spaces, is a goal.
He's been
Okay?
eating, drinking, sleeping it.
Okay.
He'll come up with some stuff.
Okay, so in terms of schedule, though, I think the best we can offer is that October 3rd?
October 2nd.
So there's 30 cases on it right now.
Oh, yeah. No, the next one.
October 22nd has 17 cases.
Okay, October 22nd for an October 2nd submission. I'm sorry, it's the best we can offer.
You've got the Jewish holidays, you've got Labor Day, you've got
Not our fault.
a lot going on in the next few weeks.
Okay.
October 2nd and October 22nd, the first
Yes.
3 twos. We're on three times. Thank you.
Thank
Thank you for
you.
all your patience.
Sure. And then we're calling the PCE.
Item number 18, 2018-145BZ, 251-73 Jericho Turnpike, Queens. This is for the 7336 special permit. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Yeah, you can print your name here.
Good afternoon, Chair, Promoter, Commissioners.
I'm sorry,
My name is
hold
Frank.
on, hold on. Oh, wait, don't go, we need you.
The other dates before, that's the same
Yes, the
dates,
same
right?
schedule,
So-
yes.
It's the same schedule, it's the same briefing schedule, but also, we want you to so this is the PCE
Platt.
in your building, right? And the problem is, there's been no communication somehow, coordination between your drawings and their drawings, and that's a mess. So we need you to listen, so you can hear that we have coordination problems and share, okay? Okay.
Frank St. Jacques, Ackerman LLP for the applicant. We attended yesterday's review session and understand that the base building plans, the seller plan, the site plan need to be coordinated with the other applicant.
Right.
The building owner. We will endeavor to do that for next submission. We also have a recommendation from a sound consultant for sound attenuation measures. We'll submit plans showing those sound attenuation measures with our next submission. I think more importantly, the coordination will be in place with that next set, though. Other than that, we're happy to submit, I believe it was October 2nd for a continued hearing,
Right.
October 22nd.
Okay, so just for the benefit of both Mr. St. Jacques and the team from the prior application, you need to exchange business cards if you don't already have them with the architect. I mean, you know, obviously with Mr. Palatnik, you probably have access, but with the architect and so on, and the building owner, to make sure that everything you submit is the same thing that they submit, because then otherwise it's not possible for us to really be reviewing this. And the fact that you're looking at acoustical information, that's very important for the architect and the daycare center and so on to be looking at as well, because they will be most affected by this gym, right? Imagine the 4-year-old during nap time and then someone drops the weights.
So if I may, Chair, we've been in close contact with ownership. Our client, the PCE operator, is working directly with the building ownership, both on the sound attenuation piece. We'll do better on the coordination with the plans.
But when you say ownership, I want to make sure it's the architect for the building that is coordinated
Yes, so
with.
the entire project team, including the base building architect, ownership, Mr. Platnick, and
Okay,
his team are speaking directly with our office.
Okay, great. Great, all right, so are there any speakers on this one? All right, so then same schedule.
Thank you.
Do you want
Thank
a
you.
letter for the other case, the first case, the parking reduction, for the withdrawal?
No.
No,
We
it's
don't
not a
want the letter.
withdrawal.
They
No,
said
no,
they're going to,
They're going to, but they
haven't
didn't.
Yeah, I know.
They didn't
but-
submit anything yet.
Yes, but do you want that in the?
Ultimately, we will need one if they want to withdraw the case, yes.
Okay.
Yeah.
Okay.
Yeah, we'll call it, we'll just second call it.
Okay, I was just asking, so you'll call the first one, the second call it?
Yeah, and then we'll continue, then go back.
That's fine, I just want to help down that.
So go ahead and call the first case.
We will begin the zoning calendar. New cases.
Wait just a second. Close, yeah. Okay.
We will begin the zoning calendar, new cases. Item number 1, 2018-193BZ, 1389 East 22nd Street, Brooklyn. This item will be second call
Because the architect isn't here.
because the architect.
Not the architect isn't here, it's the architect, the second one is here, the other one isn't coming, so I'm trying to flip it to let Sal get in there.
No. We hear them in order.
Yeah,
No,
that's
we
a
hear
different,
them in
that's a
order.
different issue,
Oh, that's why I
yeah.
asked.
Let's just hear it in
No, okay,
order.
she didn't understand your
Didn't
question.
understand what you were
Okay,
saying.
so we hear them in order.
Okay, I'll call it again. Item number 1, new cases, 2018-193BZ, 1389 East 22nd Street, Brooklyn. It's okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Good afternoon, Lyra Altman from the law office of Lyra Altman. We had somebody attend your executive session yesterday and watch the tape. We will address each item. Before I do, I'd like to point out that we also have a form for consent that was sent to my office. I'm not sure why, but I'll be submitting it to your office as well from one of the neighbors. There was a question regarding adding the standard note for the existing walls to remain. We will, of course, be happy to do that. We will also add the total exterior linear footage for the walls. Where would you like that, seeing as what
No,
he's done?
there
is on
was a
each
chart,
page.
but the chart only said walls to remain.
Right.
Walls existing, but it doesn't tell you what's the total number, the total linear footage of walls so that you can do the math on. other
Right, as I
than
said,
having to do
we're happy to add that.
No, so there were charts on each drawing, that's
Right.
fine. But it doesn't actually tell you what it's 50% of.
What we'll do is we'll have it put on one page, perhaps, just to summarize it as well.
It doesn't matter, they don't have to move it, it's just that it needs to be totaled, right?
I'll make sure that it
Total
is.
number of existing walls are X, walls to remain 50% of X, right?
I'll make sure it's clear.
Okay.
Next, whether the floor joists are being raised, I'm having trouble reaching the architect, but we will clarify that with you. I see the concern on one drawing, it says 2 feet, on the other it says 2'5", and it doesn't say it's being raised, so I'll have that checked.
Okay.
The side yard reduction, you are correct. We are off, but we're actually off by 3/4 of an inch. We will have that corrected to be a total of 13 feet, considering this is a 40-foot lot, of course. NAVD 88, we will be happy to add both the note and the actual numbers on the sections for you. With respect to the height, if you look at the photographic streetscape that we provided to your board, all of the homes on the block actually are 30 feet tall, or I should say, a good number of them are 34 feet tall. We are currently proposing 35 feet, which is slightly higher. If your board would like, we could bring it down to 34 feet to be in line with what is, well, what I'll call relatively typical on the block.
Okay. Can you make them bigger?
Would you like me to get my copy to show you?
No, we have it
Okay.
here. 34, 34.
I know there was also just a few little things I know you're not going to have to look at while I mention. We have a new zoning analysis form that is properly filled out now as well, which we'll provide to your board. One other thing that wasn't mentioned yesterday, there was an error on the DOB objection. We will be providing a new DOB objection to your board. What was done is it was written as zoning resolution section 23-142 and referenced the wrong sections. We're going to do 23-141, and instead of saying lot coverage and open space, it's going to be open space ratio, because that is the correct item for this zoning district. And lastly, there was a question on how the second floor addition at the front comports with the neighborhood character. And the Sanborn map, I should say, we will provide. But if you were to look at, once again, the photographic streetscape that we provided to your board, if you look starting on the top left of that drawing.
Of the drawing or the photo?
Of the photo streetscape.
Yeah.
You will see building numbers 2022, 1375, 1377. Then there's one that covers both 1411 and 1417. It's a double lot. 1447 and 2201. All of those buildings go straight up to a second floor without a setback.
So can you, please, in a cover letter, since you're going to be submitting, explain those two things? Talk about which houses go straight up, and also talk about the heights on the block to justify which really should be 34 feet, because it looks like that's
I'd be happy
the
to.
height. Okay.
And I believe that covered all of the comments from yesterday, in addition to the errors that we had noticed. And I should tell you that the DOB objection was put in on Thursday. The request just hasn't been signed yet.
Okay. So you'll do those justifications in writing?
Absolutely. We have the information already, we just have to put it in a letter.
Okay. Zoning analysis chart. Oh, you said zoning analysis chart doesn't include the existing and proposed OSR.
Yep, I had said that before. I think
Oh,
you were
okay.
looking at that. I apologize. We do already have a new zoning analysis
Okay.
form, and I will submit that, of course.
All right.
And I will, as a matter of fact, I will double-check all the numbers on it myself as well.
Okay. Are there any speakers on this? No. Okay, so we can put this on for late October.
What date?
What about, there's October 29th hearing.
That's good.
How about a continued hearing October 29th?
Would it be possible to have a date before then?
No.
Okay, then I'll take October
Simply
29th
put.
on that note.
Okay.
Had to ask.
So the submission date then is October 9th.
10/9 submission, 10/29 hearing. Thank you very much.
Item number 2, 2019-20 EC, 1933 East 14th Street, Brooklyn. testimony before this board and to respond honestly to board member questions.
And I want to note that I had made a comment yesterday that we didn't have proof of notice of hearing, but I received proof of notice of hearing.
Okay, thank you.
On this.
Oh, no, here. It's okay. Just right below Larry's. It's okay. No problem, no problem.
Again, still Lyra Altman, Office of Lyra Altman. Once again, I have received another form for consent in the mail on this one. It's unusual that I get these, and I received one on each of these today in my office. I'm not sure why. Nonetheless, we do have them. What did I just do with my note? I put down my page with all the comments. Okay, so your board had said yesterday that there was a question regarding NAV D88. It's already been added to the plans. Like, I can actually hand up a set of revised plans for you to look at. This is a revised set that includes many of the things we've discussed yesterday.
Where is it? Sorry, 2019.
In addition, there was a comment regarding the first floor not showing the existing illegal closet described in the statement of facts and findings. We were actually able to obtain a 1950 map of this site, and what we discovered on the 1950 Sanborn map is that this house looked exactly like the existing plans in 1950. This is right here. Come down.
Ah, okay.
We're not quite sure why the 1929 Belcher High that we provided to you looks so different.
Because everybody added what was probably not a closet. It was probably like an outdoor shower
It's
or...
even the lot sizes look different than
Yeah,
from the 1929 Belcher High. Something looks
Oh.
unusual in this circumstance.
They all have
But
it.
nonetheless, when you look at this block in 1950, clearly that's been there and that it's pre-61. Regarding the survey, we do have a copy for your board of that as well. With respect to the second floor rear yard, if you were to look at the plans, you would see that the house to the right, many of the things we've cited show the house to the right was obtained a BSA approval. And actually, that BSA approval was courtesy of the same team as here. I do have a copy of it for you. Just have to find my approval. I think I left it over here, but I can hand you the approval if you'd like. Sal, would you go in there?
Oh, this is the...
these were revised.
Yeah, I'm not sure what what is this?
What did you just hand up? I think you handed up the wrong.
Oh, that must be the neighboring, that's the neighboring building, right?
we didn't see the bump.
Yeah, I thought it was this one.
I'll hand you this moment, don't worry. I was
Okay.
just about to tell you, the adjacent house to the right has a BSA approval, these are the ones.
Okay.
So I was going to hand these to you anyway. What you will see is that home provided a 20-foot rear yard on the first floor.
When was this approved? In 2015?
Say, what was the exact, do you remember the date? I think it was 2014 filing. What are you looking at?
2015 revision date. November 2014 revision date.
It was filed in 2014, I think it was approved in 2015, give or take.
Okay.
So that house to the right had a 20-foot on the first floor.
4 years.
20 foot on the first floor, 24 foot on the second floor.
But, so the thing is, if it's not built yet, right?
It was built.
Oh, it was built?
We're just waiting for the CO.
Oh.
Absolutely built.
But, so that's why we wanted to find a survey. So the rear yard study shows the existing rear yard is 35, not 31.7, as indicated on the drawings provide survey. And the reduction in the rear yard to provide the justification for 24 feet at the second floor, right?
New survey, actually. Come on up, Sal.
Please state your name.
Good evening, Salvatore Vincenti. I'm the architect for this job that's being presented today and also next door. So we're almost there. We're about to obtain C of O. I may have a survey, I may not have ordered a final survey yet, but it is built.
Okay, but don't you have a survey for this property, subject property? Right? And doesn't that show the height of adjacent properties?
Yes.
So is this a recent survey?
Yeah, this is,
October 2018.
I have the photos. Okay, these are the more recent.
I mean, August 2018.
It shows a 20-foot rear yard and a 4-foot one above on the second story. Yeah.
But it's 20 foot and, 4 foot one on the second story on that side, and this side is further back.
That side is further back, correct.
Right, so that's the same question, is justification for the 24-foot rear yard at the second floor.
If I may, when we did the one next door, it had a similar situation where on the one on the right had a 6-foot greenhouse and it had, I think, a 20, maybe even 19-foot rear yard. So that's why we got the 20 on the first floor, and at the same token, we set back a little bit more because the other one was set back. So we're just moving down the block here. Hopefully I'll get the next one too. I mean, it would be nice.
No comment.
No comment, thank you.
Okay.
So what we're going to do is basically duplicate, if we can, a similar situation to what we have on the right.
All right. What'd you say?
I just wanted to flag that there's a shed proposed in the rear yard of this property. And there's not an elevation provided, so I don't know the height of it, and whether or not it's a permitted obstruction, A. And then B, I don't think that it's floor area, or sorry, it's not included in the lot coverage calculations or in your open space calculations. So
I'm sorry, one more time.
there's a shed in the rear yard. It's shown only in plan. It's not actually shown in elevation or in section anywhere.
Okay, we can show
So
that.
if you can show that with
Absolutely.
the height indicated.
Absolutely.
And finally, if you could add a note that DOB to ensure compliance of shed with all applicable.
Absolutely. And I think even in our floor area ratio, or for that floor area that we're requesting, it even includes the
It
shed.
does, but it doesn't, you don't include it for lot coverage or open space.
But you need it for floor area, a shed is
You
a
need it for
floor.
all three.
Right,
All three,
okay,
yeah.
absolutely.
Because it's a shed as opposed to a garage.
Yeah.
Yeah.
Yes.
I just want to clarify, do you want a separate plans for the shed, or do you want me to
No,
add
it
it to the
doesn't
elevation
need to,
in
just
the
put
back?
it in the elevation so
Okay.
we know how high it's supposed to be.
Yeah, perfect. And just include a note that says the DOB to ensure compliance.
Okay.
Also a discussion of photo streetscape.
Yeah.
What we've done is actually, I should say, what Cornerstone Designs and Sal has done is to take the streetscape that was provided for 1937. He went to the block yesterday. He checked all of the houses to see which ones have changed. Any ones that have changed, he provided a new picture. He made sure to stand in the same place where Urban Card Graphics stands, which is across the street. So if you'll see any of the photos that have a white,
That are what?
somewhat of a white, I'll say, sky, as opposed to that beautiful blue sky.
Oh.
Those are the photos that were taken yesterday that have changed since the 1937 house was done. So if you look,
Yeah, I was going to say, there are three of them, 1925, 1937, and 1969.
beat me to it. No worries.
Yeah, and in those three cases, those are the houses that don't have the front setback on the second level.
Correct.
Yeah, okay,
They were just built.
okay. All right, all right,
We
so
also had a question regarding the beams.
yes,
What Sal has done is, as he has done in many other cases, he has already provided a letter discussing how he proposes to move the beams.
so, all right, in order to obtain, so the proposal is to raise the ceiling beams from basically 3 inches. Why 3 inches? Why all that money and trouble for 3 inches?
Yeah, I'll tell you why. I will tell you why. Because the existing second floor is only 7'11". 7'11", you cannot have, a minimum height for habitable space is 8 feet. So since we're adding a little bit of radiant heating, that's why I went up the extra few inches.
You're adding radiant heating,
on the floor.
that's why you want 2 inches more as
Yeah.
opposed to 1 inch
I
more.
might as well gain it
Yeah.
at that point, yes.
So, okay, in order to obtain the desired height, we are proposing to add a taller stud adjacent to the existing while bracing the floor of the attic. Then we will start the process of raising the existing joist one at a time. We will lay a new subfloor and add a new, so the issue is, okay, so you're going to add studs between the existing studs that sit on the plate of the second floor?
Correct.
Of the second floor?
Yes.
And then you're going to increase the height of the studs. And then what happens to the existing walls?
Well, we're only leaving one wall in the attic. So it's not that hard to push next to it. Most of these are balloon framing.
Oh, so this is only the attic, it's not the
Yes.
second floor?
That's only, that's being
second
affected is the
floor.
attic. Correct.
Oh. I thought we were looking at, sorry, demo drawings, I thought we were looking at also
I
beams.
thought your second floor is also 7 foot 11.
Yeah.
The existing.
It is the second floor, that's 7 foot 11. So
So
it's
you're
the
just
attic
moving the
floor.
ceiling height above.
Correct. So it's the attic floor that's being affected.
Okay.
But in the attic floor, we're only keeping just one dormer. So because most of these are balloon framed, it's easy to move everything up.
Right.
I may have to put the ledger board just a little bit higher.
So I see on the proposed drawings, it just says existing floor ceiling to be raised. Basically, it's the floor of the third floor, which will now be, which is the attic, right?
Correct.
But and I don't have it easily reachable, but if I compare your floor heights on the proposed section to your existing section, is that the existing section?
Let's see.
You have, so you're excavating the basement, the cellar?
Yes, I am.
And then so you have 9'1". You see there's a 1 inch difference between your first floor and your second floor ceiling.
Yep.
And and 3 foot not right, and a 2 foot
Yeah.
different. There's a lot of differences in numbers.
Right, so what I'm doing is basically, again, because I'm adding radiant floor, it's almost the same thing. I could put the same number, but because I'm adding radiant heating, on the first floor, I'm gonna have to do maybe from underneath, in between the floor joists. I don't have a choice, unless I can lower it to 8'11"
What's
and be
happening is
done.
the floor is getting 1 inch thicker, so
Yeah,
the
that's all it is.
floor ceiling height is getting 1 inch shorter.
No, but it
Floor
says
joint-
between this one, oh, it's saying 2 inches thicker, not 1.
I can make it.
1 inch
you know
thicker,
what?
so that's the thing, the numbers don't match. Please go back and check the numbers.
So would
Because
you like
it's
to-
showing 3'9" to the top of the floor on the first floor is the existing, and it's showing 3'11" is the
All right.
proposed.
No,
but me-
reverse.
I mean,
Yeah,
sorry,
yeah.
it's the
I got
existing.
it.
3'11" is the proposed, and
Okay.
3 foot, sorry,
No.
let's go
3
back.
foot 11 is
Not a
the
problem.
existing. and
I'll
3
put the
foot-
same, and then if we lose a few inches, we lose a few inches. We'll do
No,
that.
it's simply to make sure that the
Yeah.
numbers that you're showing are the correct numbers, because something doesn't match here.
Not a problem.
This is
Right?
fine, 1 foot 1.
This
is 12, so 1 increase, so
But this is an
becomes 9,
increase
this
of
becomes a
2.
9.
But that's an increase
Right.
of 2.
So I think this might be required adjustment.
Yeah, that's the thing, your
Not a
numbers
problem.
are not matching.
Not a problem at all.
Okay, and ditto for the floor of the second floor.
That's also increasing by 1 inch. so
No, it's increasing by 1 inch because you made the floor fatter, and then the ceiling is higher.
Correct.
So you must be lifting up the floor of the second floor.
Correct. The floor, the second floor?
Yeah.
No.
According to comparing your drawings. No, that's the third.
I will, again, because of the
Please go
radiant
back.
heat, that's what the issue
Yeah,
is,
but-
but it's okay. I will
Yeah, but if
modify my
that were
drawings.
true, then you would have, then your ceiling went down. Oh, I see,
No,
your
no, no,
ceiling
this
went
is
down.
first floor. This
Okay,
is
that
the
one's.
second floor is
okay.
here. It's the second floor, the
Okay.
floor is being
All right.
I will,
spend all the
I will
time.
correct
Just-
that.
Just,
They
yeah,
will
correct.
match, that's not a problem.
Okay. All right, and then the retention of the 50%, that's because it doesn't look like your demo drawings and the proposed are coordinated, so please, because that's the main thing, is you're removing a lot of exterior walls, it looks like here, and so you need to overlay your demo calculation drawings
on top of the proposed plans, so I can see that it's exactly the same walls that are being retained, and it doesn't look like that. When I compare those drawings, there's 3 sets of drawings,
Gotcha.
okay?
I apologize.
Okay.
We will correct that, and that'll be easier. I think we did already, yeah?
Yeah, we actually already went through, we made sure all the numbers match, and that's in the revised set that I provided.
Okay, but we can't do that now.
But I'll
Okay? And of course, you know you need to retain 50% on the first and second floors of the existing walls of the existing exterior walls on the exterior. Don't want to have a debate about it, that's the rule, okay?
Okay, but I don't know, because,
Okay.
I mean, this is new.
It's not new. 50% of the existing exterior walls on the exterior. I don't want to have a debate about it, please don't make me do this. It's it's almost 6 o'clock.
We just want to clarify,
I'm sorry.
50% total.
50% on each floor of the existing exterior walls retained on the exterior, right? You're giving us 41% on the second floor, that's not okay. And anyway, I'm not even sure you're making it because I see walls on the interior of the building being treated as if they count and they don't.
I'm not counting it.
They weren't
Okay.
added to the calculation.
All right, that's just the direction, no discussion, make that happen.
One question
Okay.
for you. On a prior hearing, we had been told it was a total of 50%, no less than 45% per floor.
I'm not
The new
going
rule-
to have a discussion about this.
I'm
It's
asking for
50%. We're
clarification.
done.
The new rule
Bye.
now 50% per floor, just so I have direction to give my architects. Want to make
It's
sure we're clear.
50% on each floor retained on the exterior of the building of exterior walls, all right?
Okay.
Okay.
As reflected on our drawing guidelines.
Yes. Okay. Are there any speakers on this? No.
Gonna put it on for the schedule, October 9th.
What's yours?
I guess.
Okay. We could put it on for the same schedule, submission October 9th for continued hearing October 29th.
I assume there's no possibility of moving that earlier either? Thank you.
Thank you.
Thank you.
All right. Almost there.
Item number 3, 2019-81BZ, 144 East 39th Street, Manhattan. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes.
Good afternoon, Chair and Commissioners. Nora Martins from Ackerman LLP, representing the applicant. This is the smallest audience I've ever had, I think.
Feels good.
Yeah. It's nice to be the last item. So I heard the board's comments at the executive session. It seemed that the commissioners were satisfied with the proof of continuous use that was submitted. I'm happy to answer if there are any questions on the evidence that was submitted. I know the chair raised a question about whether this, the current use could possibly be classified as use group 4, a nonprofit without sleeping accommodations, which would be permitted as of right in the R8B zoning district. So the current owner and tenant of the building, the English-speaking union, is a nonprofit institution. This location is their national headquarters, and the majority of the space here is not used for program space. It is essentially a central office function. And the entire third floor, which is the subject of the BSA variance, is entirely used for office space. It's not accessible to clients, and there is no programming offered on the third floor of the building. So I believe it's properly classified as use group 6. Everything submitted to the Department of Buildings to date to obtain the updated CO, which has been a multi-year process, resolving many, many very old violations and open items. Everything is reflected use group 6 for the building with no objection from DOB.
Okay, but, you know, the reason this came up is because in your statement of facts, it states that there's program space and
yes,
office function space in the building.
Yes, there is some program space in the building, mainly on the ground floor.
Okay. So, what's it says
Yeah.
Which is indicated
Because it's
outside
not,
of the,
it's, yeah, it's not subject to
So
the.
your waiting area,
It's probably this garden lounge.
a lounge, which is arguably
The program area.
program, right? Waiting area, receptionist program, and the second floor?
Town office spaces.
It's, you know, the reason that I brought this up is because we had a recent meeting with another not-for-profit where they were coming for a potential variance. And when I listened to their program, it seemed as if hardly any of what they were doing was really central office function. You know, they had an accountant, they had a this and this, but basically, it was caseworkers on the phone with clients, right? And so those people are pursuing the program. And so my concern here was that, and of course, it's all how you portray it to DOB, was that your program space on your existing non-conforming floors might be in jeopardy because it is a not-for-profit. So you need to do something to clarify very specifically, so that you don't get caught in this idea that you might have abandoned your non-conforming use.
Right, and understood. And everything, again, submitted to DOB to update the CO for the whole building has reflected use group 6 without objection from DOB. I mean, it is optional to be classified as use group 4 or use group 6 for
No.
business office.
No, it's optional when it's in a C district. It's not optional when it's it's a non-conforming use, right? When it's a non-conforming use and you legitimately are qualified as a use group 4, then it's not an option.
Right,
You
I see what you're saying.
It's only an option when you can go either way, both are allowed, et cetera, right? So what I just recommend to you is you do make some kind of affirmative something on your drawings that indicates exactly what this stuff is. Accountant's office, lawyer's office, that kind of stuff that sounds like central office functions, right? That's just my recommendation, so you don't get in a few years when some angry neighbor is upset about all the noise that goes on here and says, you know, this isn't even allowed here because, right? Okay. Are there any speakers on this? No. I don't know that we had otherwise any other issues, right? So then I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
Yeah, it's a term.
Just for a year.
Say that again.
I was just asking what the term was for the
The
extension. I
prior
think
was-
the request was for a year.
The request for a year to obtain the CO,
CO,
the maximum, we're requesting the maximum term of
Was
10
it
years.
was 10 years, I believe, right?
Yes, that's the request.
So, and I seem to remember there was some comment that the C of O extension wasn't needed, right?
There wasn't a requirement to get in a certain amount of time, only to have conditions if you're on it. It wasn't done.
So the extension for the C of O, the extension of time to obtain a C of O is not really
It's not really
an
applicable.
It's not required.
It's
application,
not required, yes.
right?
It's not required because it wasn't a condition of the
Right.
board to obtain it by a certain time.
Right. So what we're really talking about is just an extension of the time, of the terms.
A reinstatement of the term.
Of the term of this variance, okay. So
Which would
then,
start a new 10-year term.
Yes.
right, okay. So then, did I already make a motion to close? A motion to close on that.
You already closed.
It already closed?
Now we're
Sorry,
done.
it's 6 o'clock. I'm
I distracted you.
And a motion to grant for a 10-year term starting today.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shabeta?
Aye.
Case has been
Thank
granted.
you.
Thank you. Have a good evening, everyone.
This concludes the public hearing for August 6, 2019.
Did somebody guess 6 o'clock?
No, this is Juline's first case on the calendar.
Oh.
And she got to close and vote.
Look at that.